ಓಕೆಪ್ಪ ಆಫೀಸರ ಹ್ಞೂ ನಮಗೆ ತೊಗೊಳಕ್ ಆಗಿಲ್ಲ ಅಲ್ಲಿ ಬರೋಕ್ಕಾಗಿಲ್ಲ ಇಲ್ಲಿ ಇದು ಸೇವಿಸ್ ಭಾಳ ಆಯ್ತು ಈ ಬರೋಲ್ಪ ಬೇಕಾಗಿಲ್ಲ ಹೋಗಿದ್ದೀರಿ ಅದು ಈಗ ಸ್ವಲ್ಪ ಮಧ್ಯಾಹ್ನ ವ್ಯವಸ್ಥೆ ಅದರ ನಿಮಗೆ ನೋಡೋಣ ಗೊತ್ತಾಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಆಫೀಸಲ್ಲಿ ಹೋಗಲ್ಲ ನಿಮ್ಮ ಆಫೀಸ್ ಹೋಗ್ತೀರಾ ಅಂತ ಆದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಗೊತ್ತು ಅದೊಂದು ಮತ್ತೆ ಹಾಕಿತ್ತು ಆಗುತ್ತೆ ಫೋನ್ ಮಾಡಿ ನಾವು ನಾಳೆ ಗಂಟೆವರೆಗೆ ಟ್ರೈ ಮಾಡ್ತೀವಿ ಆಗಲಿಲ್ಲ ನಾವು ಟ್ರೈ ಮಾಡ್ತೀವಿ ಹಾಂ 100% ಆಗುತ್ತೆ ಯಾಕೆ ನಾಳೆ ಇವತ್ತಿಗಾಗಿದೆ ಕೇಳಿಸಿ ಇವತ್ತು ಅಷ್ಟೇ ನಾಳೆ ಅದಕ್ಕೆ ಇರೋದಿದೆ ಓಕೆ ಓಕೆ
ನೋಡಿ ತೋರಿಸಿ, ಲೆಟರ್ ತೋರಿಸಿ, ಮತ್ತೆ ಲಿಬರ್ಟಿ ಮಾಡೋಣ ಅಂತ ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು.
ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಬರ್ದಾರ, ಅಸೆಸಿನ ಬರ್ದಾರ?
SSC.
The respondent assessee has addressed a letter dated so and so to the effect that this appeal be disposed of as having been withdrawn. Full stop. Ordinarily, it is the prerogative of the dominus litis who can seek withdrawal and not the opponent. Full stop. Be that as it may. Next part. Learned panel counsel appearing for the appellant revenue submits that the list involved in the appeal appears to have been resolved under a statutory scheme.
Vivad se Vishwas scheme. Vivad se Vishwas scheme.
Under the statutory scheme called Vivad se Vishwas scheme, and therefore appeal be disposed of as having been withdrawn with liberty to seek its revival in the event the efforts under the scheme fail in fruition. Full stop. We agree with this. Ordered accordingly and appeal is disposed of. Okay.
My lords, I have got the book, my lords. I've got the book.
ಯಾವ್ದದು?
Pullimavina Mara, my lords.
ಹುಳಿ ಮಾವಿನ ಮರ, ಲಂಕೇಶ್ ಅವ್ರದ್ದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಅದು.
Yes, my lords.
ಲಂಕೇಶ್ ಒಬ್ಬ ಪ್ರಬಲ ಬರಹಗಾರ. ಅವರ ವಿಚಾರ ಒಪ್ಪೋದು ಬಿಡೋದು ಅನದರ್ ಥಿಂಗ್, ಡಿಬೇಟೇಬಲ್. ಬಟ್ ಕನ್ನಡ ಜನರಿಗೆ ಓದ್ಲಿಕ್ಕೆ ಹಚ್ಚಿದಂಥವ್ರು ಓದ್ಲಿಕ್ಕೆ ಒಂದು ಅಭ್ಯಾಸ ಮಾಡಿಸ್ತೇನೆ
Yes, my lords.
ಹೇಗೆ ಅಂತ.
I'll just have it.
ಎಷ್ಟು ದಿವಸ ಇದೆ ಇದು?
I have to take process, my lords, but other similar matters, my lords, I'll take out hand summons, my lords.
Sorry. Issue steps to be taken immediately. Other condition ittano?
Yes, my lords, subject to production of book, but I've not now got the book, my lords.
Proof of?
The book, my lords. I'll deposit the book, my lords.
Subject to presenting the book in terms of order dated 17/1/2025. First off, in addition to taking usual steps, the appellant revenue is permitted to take hand summons to the respondent assessee as well. Okay.
My lord, I filed withdrawal memo, my lord. I may permitted to withdraw with liberty to review if occasion arises, my lord.
But one memo idea?
Yes, my lord, already filed, my lord.
Yeah.
Assessee filed under Vivad se Vishwas scheme, my lord.
Appellant has filed a memo dated so and so, seeking leave of the court to withdraw the appeal with liberty to revive it in the event his efforts to have the list resolved in terms of Vivad se Vishwas scheme does not bear fruit. First off, there is no objection from the senior panel counsel representing the revenue. First off, next part. In view of the above, the appeal is permitted to be withdrawn and accordingly disposed of with liberty as sought for. Okay, courts made easy.
Much obliged.
Okay. Sundara Raman.
So we are led by senior counsel in this matter.
Ah.
It is, we are yet to finalize the synopsis in this matter, my lords. I pray for a week's time.
1 week beka.
Last time my lords have made it clear, there is
Ah.
no further adjournment.
But you know, idea?
Sir.
No adjournment will be granted. Entide. No further period will be granted antidiya. Anyway,
A week's time, my lords. We'll finalize this synopsis and next Thursday it may be listed, my lord.
1 week will give, because the last time also you took time. Give some good books to the library. All right, which book you will give?
My lords.
Hmm?
To the court, my lords.
ಅಲ್ಲ ಹೇಳಿ, ನೀವ್ ಹೇಳ್ಬೇಕು. ನೀವು ನಿಮ್ಮಲ್ಲಿ ಓದಿರಿಲ್ಲ, ನಂಗೆ ಗೊತ್ತಾಗಬೇಕಲ್ಲ. ನಮ್ಗೆ ಏನೇನೋ ಕೇಳ್ತಿರ್ತಾರಪ್ಪ, ಈ ಪ್ಯಾನಲ್ಗೆ ಒಳ್ಳೆ ಲಾಯರ್ನ ಸಜೆಸ್ಟ್ ಮಾಡ್ರಿ ಅಂತ ಕೇಳ್ತಿರ್ತಾರೆ. ಅವಾಗ ನಾವು ಯಾರು ಓದ್ಯಾರೆ ಯಾರಿಲ್ಲ ನೋಡ್ಕೊಂಡು ಅಡ್ಡಿಲ್ಲಪ್ಪ ಇವನ್ನೆಲ್ಲ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪೋಜರ್ ಜಾಸ್ತಿ ಇದೆ ಇಂಥವ್ರನ್ನ ಮಾಡ್ಬೋದು ಹಿಂಗೆಲ್ಲ ಹೇಳಿಕ್ ಬರ್ತದೆ ನಮಗೆ. ಹಂಗಾಗಿ ನೀವ್ ಹೇಳ್ಬೇಕು ಯಾವ ಪುಸ್ತಕ ಕೊಡ್ಬೋದು. ಇತ್ತೀಚೆಗೆ ನೀವು ಓದಿದಂತ ಒಳ್ಳೆ ಪುಸ್ತಕ ಯಾವುದು?
Not aware.
ಅದೆಲ್ಲ ಅಂತವೆಲ್ಲ ಇಲ್ಲ ಅಂತನ ಲಾ ಬಿಟ್ಕೊಂಡು ನಾವೇನು ಆ ಕಡೆ ನೋಡೋರಲ್ಲ ಅಂತ. ಅದ್ ಲಾದ್ದ ಹೇಳಿ ಯಾವ್ದಾರ ಒಂದು.
Allottees are there. That's the reason why I'm pressurizing.
Nah.
Allottees are there. They have spent their retired benefits amount to the.
ಇನ್
VD.
ದಿಸ್
That's the reason why, my lords, I'm pursuing not otherwise.
ಒಂದ್ ಒಳ್ಳೆ ಪುಸ್ತಕ ಹೇಳಿ, ಒಂದ್ ವಾರ ಕೊಡೋಣ ಟೈಮ್. ನೀವ್ ಹೇಳಿ ಒಂದು ಒಳ್ಳೊಳ್ಳೆ ಪುಸ್ತಕ, ಲಾದ ಪುಸ್ತಕ ಓದಬೇಕಲ್ಲ. ಲಾದ್ ಓದ್ಬೇಕು, ಲೈಫಿಗೆ ಸಂಬಂಧಪಡೋದು ಓದ್ಬೇಕು. ಶೇಕ್ಸ್ಪಿಯರ್ ಎಲ್ಲ ಇಂಗ್ಲಿಷ್ ಲಾ ಓದ್ತಿದ್ದ ಗೊತ್ತಾ? ದೇರ್ ಇಸ್ ಎ ಫೇಮಸ್ ಬುಕ್, ಅದನ್ನೇ ಕೊಡಿ ನೋಡಮ್ಮ. ಶೇಕ್ಸ್ಪಿಯರ್ ಅಂಡ್ ಲಾ ಬೈ ಹ್ಯಾರಿಸ್ ಅಂತ ಅನ್ಕೊಂಡು 2-3 ಬುಕ್ ಇದೆ. ಅಟ್ಲೀಸ್ಟ್ ಒಂದ್ ಪುಸ್ತಕ ಕೊಡಿ. 1 week granted, subject to the petitioner presenting one book by on Shakespeare by Harrison, mostly Harrison. ನೋಡ್ಕೋಬೇಕು, Shakespeare and Law. And another book also, Law and Literature by Brian ಯಾರ ಇದೆ ನೋಡಿ. 2-3 books ಕೊಡಿ, 2 books ಕೊಡ್ಬೇಕು. Entry order to continue, subject to presenting these books. Okay.
Can I request for the date? I'm sorry, ma'am.
Next week ಬರುತ್ತೆ.
Next Thursday.
Next week ಬರುತ್ತೆ. 1 week ಕೇಳ್ಯಾರ ಅವರು ಬರುತ್ತೆ. ಯಾಕಂದ್ರೆ ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಪೋಸ್ಟ್ ಮಾಡಿರ್ತೀವಿ ನಾವು. ಹಾಗಾಗಿ ಮತ್ತೆ ಒಳ್ಳೊಳ್ಳೆ ಪುಸ್ತಕ ನೀವು ಓದ್ಕೊಂಬಂದ್ರೆ ನಿಮ್ಮ ವಾದಕ್ಕೆ ಒಂದು ಪುಷ್ಟಿ ಸಿಗ್ತದೆ. ಅದಕ್ಕಿಂತ ಮುಖ್ಯವಾಗಿ ನಮಗೆ ಅನಿಸ್ತದೆ, ಇವನು ಹೆಂಗಪ್ಪ ವಾಪಸ್ಸು ಏನು ಆರ್ಡರ್ ಇಲ್ದಂಗೆ ಕಳ್ಸೋದು ಹೆಂಗೆ ಈ ವ್ಯಕ್ತಿನ, ಇಷ್ಟೆಲ್ಲ ಚೆನ್ನಾಗಿ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಮಾಡ್ತಾನೆ, ಇಷ್ಟು ಲರ್ನೆಡ್ ಇದ್ದಾನೆ, ಹೆಂಗ್ ಹೌ ವಿ ಕ್ಯಾನ್ ಸೆಂಡ್ ಹಿಮ್ ಬ್ಯಾಕ್ ಎಂಟಿ ಹ್ಯಾಂಡೆಡ್. ಹೌದಾ? ಅವಾಗ ಒಂದು ಮುಷ್ಟಿ ಮಾರ್ಕ್ಸ್ ಜಾಸ್ತಿ ಬೀಳ್ತದೆ ನಿಮ್ಗೆ. ಅಧ್ಯಯನ ಮಾಡಬೇಕು. ಲಾಯರ್ ಸಾರಸ್ವತ ಲೋಕ ಇದು. ಲಾಯರಿಂಗ್ ಎಲ್ಲ ಕಲ್ಟಿವೇಶನ್ ಮಾಡೋದಲ್ಲ ಇದು. ದಟ್ಸ್ ಆಲ್ಸೋ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ದೇ ಇಟ್ ವೆರಿ ವೆರಿ ಆರ್ಡರ್ಸ್ಲಿ ದೇ ಡೂ ಫಾರ್ಮರ್ಸ್. ಹಾಗಾಗಿ ನೀವೆಲ್ಲ ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಓದಲಿಕ್ಕೇನೆ ಇಷ್ಟು ಸಮಯ ಅನ್ಕೊಂಡು ನಿಗದಿ ಮಾಡ್ಕೋಬೇಕು. ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್ ಅದು. ಇದು ಯಾಕೆ ನಾನು ದಿವಸ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ ಓದೋ ಸಂಖ್ಯೆ ಕಡಿಮೆ ಆಗ್ತಾ ಇದೆ. ನಾನು ಭೈರಪ್ಪನವ್ರಿಗೆ ಕೇಳಿದೆ, ನಿಮ್ಮ ಮುಂದಿನ ಪುಸ್ತಕ ಯಾರು ಅಂತ. ಓದೋರು ಯಾರು ಅಂತ ಹೇಳು ಅಂದ್ರೆ ಅವರು ಮೊದಲು. ಹಂಗಾಗ್ತಾ ಇದೆ. ತುಂಬಾ ಜನ ಎಸ್ಪೆಷಲಿ ಪೋಯೆಟ್ರಿ ಅಂಕು ಓದೋದೇ ಇಲ್ಲ. ಎಷ್ಟು ಒಳ್ಳೊಳ್ಳೆ ಪೋಯೆಟ್ರಿ ಇದೆ. ಲಾರ್ಡ್ ಬೈರನ್ ಅಂದು, YB ಈಟ್ಸ್ ಅಂದು, ಜಾನ್ ಕೀಟ್ಸ್ ಅಂದು, ಎಷ್ಟು ಒಳ್ಳೊಳ್ಳೆ ಬರಹಗಳಿದೆ. ಶೇಕ್ಸ್ಪಿಯರ್ನ ಒಬ್ಬ ಸೋದರ ಸಂಬಂಧಿ ಡ್ರೆಡಾನ್ ಅಂತ ಬರ್ತಾನೆ. ಅವನು ಶೇಕ್ಸ್ಪಿಯರಿಗೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾನೆ, ಮಾಮ ನೀನು ಇಷ್ಟೊಂದು ಪುಸ್ತಕ ಬರೆದು ಫೇಮಸ್ ಆಗಿಯಲ್ಲ, ನಿನ್ಕಿಂತ ಫೇಮಸ್ ಒಂದೇ ಪುಸ್ತಕ ಬರೆದಾಗ್ತೇನೆ ನಾನು ಅಂತ ಹೇಳಿ ಆಲ್ ಫಾರ್ ಲವ್ ಅನ್ನುವಂಥ ಬುಕ್ ಬರೀತಾನೆ. ಗ್ರೇಟ್ ವರ್ಕ್. ಏನ್ ಲ್ಯಾಂಗ್ವೇಜು, ಭಾಷೆ, ಭಾಷೆಯಲ್ಲಿರೋ ಪ್ರತಿಮೆಗಳು, ಅಲಂಕಾರ, ಛಂದಸ್ಸು, ಏನಂಗ ವಿಜೃಂಭಣೆ ನೋಡ್ಬೇಕು ಅವನ್ನೆಲ್ಲ. ಈ ಬೇರೆ ಡೆಡ್ ಲೆಟರ್ ಆಫ್ ಲಾದಿಂದ. ಆಲ್ ರೈಟ್, ನೆಕ್ಸ್ಟ್ ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಮತ್ ಹಿಂಗ್ ಹೇಳ್ತೇನೆ ಅನ್ಕೊಂಡು ಸಿಟ್ಟಾಗ್ಬಾರ್ದು, ಕಾರಿಡಾರ್ನಲ್ಲಿ ನಂಗೆ ಬೈಬಾರ್ದು. ಓದು ಅಂತ ಹೇಳ್ತಾರೆ ಇವರು ಅಂತ. ಎಸ್.
Challenge the order passed by the learned single judge in the company petition, my lord. This is relating to BGML, my lord, winding up of the BGML. On 29/1/2001, my lord, the relationship of employers.
ಎಲ್ಲ ಒಂದ್ ಕಡೆ ನಾನು ಅಪಿಯರ್ ಆಗೇನೆ.
Yes, my lord. My lords had appeared on behalf of the Union of India as well as BGML throughout, my lord, and almost for a.
ನಾ ಅಪಿಯರ್
I am
ಆಗೇನೆ.
appearing for
ಯಾಕಂದ್ರೆ
the respondent, my lord,
ಗೊತ್ತಾಯ್ತು.
and the appeal is filed on 18/6/2004. And they are not so interested in pursuing the case.
ನೋಡ್
In the meantime, at least.
ನೋಡ್
well,
ನನ್ ಮುಂದ್ ಬರಲ್ಲ. ನಾನು ಅಪಿಯರ್ ಆಗೇನೆ ಅದರಲ್ಲಿ. ನಾನು ಇದ್ರಲ್ಲಿ ಏನಾಗ್ತದೆ, ಇವೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿಬಿಟ್ರೆ ಅನೇಕ ಕನ್ನಡಿಗರಿಗೆ ನೌಕರಿನೇ ಸಿಗಲ್ಲ. ಇವೆಲ್ಲ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಕರೆಕ್ಟು, ಆದ್ರೆ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ಕರ್ನಾಟಕದ್ದು, ಜನ ವರ್ಕ್ ಮಾಡೋ ಕರ್ನಾಟಕದ್ದು, ಆಮೇಲೆ ಗೋಲ್ಡ್ ಕರ್ನಾಟಕದ್ದು. ಅಲ್ಲೇ ನೀವು ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡಿ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಮತ್ತೆ ಗೋಲ್ಡ್ ಪ್ರೈಸ್ ನೋಡಿರ ನಿನ್ನೆ? ಜಸ್ಟ್ ಐ ವಾಸ್ ಅಬ್ಸರ್ವಿಂಗ್.
Increase in 5%.
ಹಾ,
84,000.
84 lakh per kg. ಅದು 24 ಕ್ಯಾರೆಟ್. Of course, that's the highest carat is another thing, especially Swiss gold, Mauritius gold, ಇವೆಲ್ಲ ಸಿಕ್ಕಾಬಟ್ಟೆ ರೇಟ್ ಇದೆ. Therefore, ಸ್ವಲ್ಪ ನಾನು ಏನೋ ಇದರಲ್ಲಿ ಹೇಳಲ್ಲ, ಬಟ್ ಎಲ್ಲಿ ಕನ್ನಡಿಗರಿಗೆ ಜಾಬ್ ಸಿಗೋದು ಹೆಂಗೆ? ಹೌದಾ? ಹಂಗಾಗಿ ಆ ಕಡೆ ಸ್ವಲ್ಪ ಗಮನ ಹರಿಸಿ. ನಾವೇನು ಆರ್ಡರ್ ಮಾಡಲ್ಲ ಇದರಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಐ ವಾಸ್ ಎ ಲಾಯರ್. ಐ ಮೇಡ್ ಲೈಕ್ ದಿಸ್ ಸಬ್ಮಿಷನ್ ಓನ್ಲಿ ಇನ್ ದಟ್ ಕೇಸ್. Anyway, now pushed before a bench not comprising KS DJ, who had appeared for the central government in this matter earlier as a lawyer. Okay. ನೋಡ್ಬೇಕಾದ್ರೆ ಎಫರ್ಟ್ ಮಾಡ್ರಿ. ಎಫರ್ಟ್ ಮಾಡ್ರಿ. ಇಂಥ ಹೋರಾಟಗಳನ್ನು ಮಾಡಲ್ಲ. ಅದು ಎಂತ ಬಾವುಟ ಹಿಡ್ಕೊಂಡು ಅಡ್ಡಾಡೋ.
Start date may be indicated. Start date.
ಬೇರೆ ನಾನೇನ್ ಬಿಫೋರ್ ಅಂತರ್ ಬೆಂಚ್ ಹೋಗ್ಬೇಕು.
Because the matter stands submitted, my lords. Other matters of the similar nature, same assessee is admitted, my lords.
ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ?
Yes, my lords.
Lords, I appear for the respondent in this matter. My lords, in
ಕಾಂಪ್ಲೈನ್ಸ್ ಏನದು? ವಕಾಲತ್ನಾಮ ತೆಗಿಲ್ರಿ, ಅದಕ್ಕೆ ಸೀಲ್ ವಕಾಲತಿಗೆಲ್ಲ ಎಂತದ್ರಿ? ನೋಡ್ರಿ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬೀಯಿಂಗ್ ಇನ್ಸಿಗ್ನಿಫಿಕೆಂಟ್ ಈಸ್ overruled on the submission of learned counsel appearing for the respondent. All right. ಅದೇನು ಅದು ಕಂಪಲ್ಸರಿ ಇಲ್ಲ, ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಈಗಾಗಲೇ. ನೋಡ್ರಿ, ಬರ್ಕೊಡಿ. ಯಾರು ಇವರು ಬರ್ಕೊಡ್ತಾನ? ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಅಂತ ಬರ್ಕೊಡಿ.
No, sir, they are.
ನೀವೇ ಬರೀಬೇಕು. ನಿಮ್ದು ಅಪೀಲ್ ಮೆಮೊ. Compliance is done in the open court with leave. First off, the questions raised as substantial questions raised in this appeal are similar to those framed in
62 of
ITA number 62 of 2024. Admitted by a coordinate bench of this court. This court. Wide order dated
29 January.
29/1. So and so. First off, in view of the above, in view of this, the subject appeal is also admitted for consideration on the questions framed in therein, which are as under. Okay. Call this matter along with ITA number. Yes, next. ಒಂದ್ ಸಣ್ಣ ಪುಸ್ತಕ ಕೊಡಬೇಕು, ಆಗಲ್ಲ ನೋಡಿ 3 ಸರಿ ಆಗಿದೆ.
ಮಹಾಶ್ವೇತ.
ಯಾವ್ದದು?
ಸುಧಾಮೂರ್ತಿ ಅವ್ರದ್ದು ಮಹಾಶ್ವೇತ.
ಮಹಾಶ್ವೇತ ಈಗಾಗಲೇ ಕೊಟ್ಟೇವು ನಾವು, ಅದನ್ನ ಈಗಾಗಲೇ ಕೊಟ್ಟಾಗಿದೆ ಅದು. ಹಂಗಾಗಿ ಅದರ ಹೊಸ ಪುಸ್ತಕ ಹೇಳಿ. ಹಾಲೆಂಡ್ ಆನ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್.
ಕನ್ನಡ ಬುಕ್ ಯಾವ್ದಾರ ಸ್ಮಾಲ್ ಕೊಡ್ತೀವಿ. ಇದು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಷ್ಟೇ, ಡಿಲೇದಲ್ಲ ಇದು.
ಅಂದ್ರೆ ಈಗ
ಸ್ಮಾಲ್ ಬುಕ್ ಇರ್ಲಿ ಸುಮ್ಮನೆ.
ಇದು ಚಿಕ್ಕದೇ, ದೊಡ್ಡದೇನಲ್ಲ ಇದು. ಎನಿವೆ, ಅದು ಚಿಕ್ಕದು ಹೇಳಿ, ಅದು ಚಿಕ್ಕದು ಹೇಳಿ. AN ಮೂರ್ತಿರಾಯರ ದೇವರು ಕೊಡಿ ಪ್ಲೀಸ್. ದೇವರು. ಓಕೆ. ಟು ಕೆಳಗಿನ ಲೈಬ್ರರಿ ಕೊಟ್ಬಿಡಿ, ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ಸ್ ಲೈಬ್ರರಿ ಟ್ರಯಲ್ ಕೊಟ್ಟಿರ್ತಾರೆ. ಆಲ್ ರೈಟ್. ಎಸ್. ಎಲ್ಲಿದ್ದಾರೆ? Post after compliance of office objections. If objections are complied with within 2 weeks. Okay. Dr. Halaswamy.
My lord, 1 week time may be given. Last time we had complied, they have raised the new additional objections.
Precedent in English law by Rupert Cross.
My lord, it's not available in.
Not available. Give precedent in English law by Professor Lakshmi Kanta.
Okay.
Tali. ಆ ರೀತಿ ಆರ್ಡರ್ ಮಾಡ್ಕೋಬೇಕು. ಸೆಕೆಂಡ್ ಎಡಿಷನ್ ಕೊಡಬೇಕು.
Yes, my lord.
Okay.
So blessed.
It's also a good book. He has written like our Amartya Sen has written in comparison with John Rawls' theory of justice. He has written idea of justice. Professor Lakshmi Kanta has written this book, Keeping in View, Precedent in English Law by Rupert Cross. But Rupert Cross is a great work. See how many judgments of our Supreme Court refer to Rupert Cross.
So, my lord, even in online and bookstall.
Anyway,
it's not.
this is available.
Okay.
The Fadnisi heli ತರಿಸ್ಕೊಡ್ತಾರೆ within 2 weeks. Yes. Non-compliance for fifth time.
Matter pertains to Shivram Karanth layout. May
Huh.
post it for tomorrow minutes. In the meantime, I will comply the.
ಐದು ಸರಿ ಆಗಿದೆ ಅಲ್ಲ. ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಹೇಳಿ. ಎರಡು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಡಿ. ಒಂದು ನೀವು ಇಟ್ಕೊಳ್ಳಿ, ಒಂದು ಲೈಬ್ರರಿ ಕೊಟ್ಟು.
Please.
ಯಾವ್ದು?
Recently, I read Melot's 48 powers.
ಯಾವ್ದು?
48 laws of powers, Melot's.
48 laws of powers.
Please.
ಯಾರ್ದದು?
It's by Robert Melot's.
Is it?
Please.
This new book I also did not know. I'll try to. Noodama. Very good. Thank you for
matter
telling me a book which I have not seen. Yes.
The matter request to be posted tomorrow since the matter.
ನೀವು ಬುಕ್
but
ಕೊಟ್ಟ ತಕ್ಷಣ ಇವತ್ತು buk ಕೊಟ್ರೆ ನಾಳೆನೇ ಬರ್ತದೆ.
Let's have to order from online.
ಅದೆಲ್ಲ ನಡೆಯಲ್ಲ. ಇದು ಯಾವತ್ತು ಬೇಕು ಅಂತೀರ ಅವತ್ತಿನ ದಿವಸ.
Maybe on 12th. Maybe on 12th, Melot's. The next setting is on 12th.
12th ಇದೆ.
12th ಇದೆ.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾ?
ಅಲ್ಲ, ಇಲ್ಲೇ ನಿಮ್ಮ ಮುಂದೆನೇ ಇದೆ.
ನಮ್ಮ ಮುಂದೆನೇ ಇದೆ.
ಹೌದು.
ಅಲ್ರಿ ಅಷ್ಟ್ರ ನೀವು ಇಲ್ಲ ನಿಮ್ಗೆ ಈಗ ಸಿಗುವಂತ ಪುಸ್ತಕ ಹೇಳಿ, ಅದನ್ನ ಹಿಂದಿಂದ ತರಿಸ್ಕೊಡಂತ್ರಿ.
Please.
ಈಗ ಯಾವ್ದು ಒಳ್ಳೇದೊಂದು ಪುಸ್ತಕ ಹೇಳಿ. ಏನ್ ಬರಿತಾ ಇದ್ದೀರಾ? ಯಾರಿಗೂ ಗೊತ್ತಾಗದ ಪುಸ್ತಕನ ಏನು?
ಕೇಳಿದ್ರು.
ಬುಕ್ ನೇಮ್
Please.
ಯಾವ್ದು ಹೇಳಿ ಒಂದ್ಸರಿ.
48 laws of power, Melot's.
ಅದು ಮತ್ತೇನೋ ಸಿಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ. ಲಿಮಿಟ್
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಸಿಗುತ್ತೆ.
ಹೌದಾ?
2 ದಿನದಲ್ಲಿ ಸಿಗುತ್ತೆ.
ತಾಳಿ ನೋಡಮ್ಮ. ಬಟ್ ಪೋಸ್ಟ್ ಆನ್ 12th if book is presented and not otherwise. Okay.
Great.
ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಬೇಕು. And when the bench is constituted.
Please.
And book is presented and bench is constituted. ಎರಡು ಆಗಬೇಕು. Yes. ನಮ್ಮ ಲಾ ಇಂಟರ್ನ್ ಬುಕ್ ಕೊಡಿ, ಆ ನಂಬರ್ ಹೆಸರು ಕೊಡಿ. ಗಿವ್ ದಟ್ ನೇಮ್ ಟು ಅವರ್ ಲಾ ಇಂಟರ್. ಎಸ್. ಥ್ಯಾಂಕ್ ಯು. ಎಸ್.
Council on record request me to take 1 week time.
ಏನಿದು?
Complaints legible copy ಅಂತ ಕೊಡ್ಬೇಕು.
ಎಲಿಜಿಬಲ್ ಕಾಪಿ. ಎಲಿಜಿಬಲ್ ಇಲ್ವಾ? ಕೊಟ್ರಿ ನೋಡ. ನೀವು ಓದಕ್ ಬಂದ್ರ ಆಯ್ತಪ್ಪ, ಅದೇನು ಒಂದೇ ಪೇಜ್. ನಡೀತಿದ್ರೆ ನಂಬರ್ ಅಷ್ಟೇ ಇದೆ. ಏನು ಇದು ಏನು?
My lord, Foxy Council, my lord, engage senior council itself. Next Wednesday maybe. my lord.
ಅಲ್ರಿ, ಪೋಸ್ಟ್ ಆಫ್ಟರ್ ಕಂಪ್ಲೈನ್ಸ್ ಎಷ್ಟು ಸರಿ ಕೊಟ್ಟಾಗಿದೆ ಟೈಮು?
Not aware.
ಎಷ್ಟು ಸರಿ ಕೊಟ್ಟಿವಿ? ಸೆಕೆಂಡ್ ಟೈಮ್. ಗಿವ್ ಒನ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ಮಾಮ್ಡನ್ ಲಾ ಬೈ 5G to library. Sorry, 1 week granted, subject to the condition that the petitioner shall present principles of Mohammedan, outlines of Mohammedan law by 5G, FYZEE. It's a very good book on Mohammedan law.
Yes.
Just look into
Yes.
it. Okay?
Yes. ma'am.
Good. All right. Yes, Rajendra. Compliance, 9 objections, second time.
Yes.
Huh.
I may also be permitted to donate some of the books.
ಯಾವ್ದು?
ಕನ್ನಡ ಸಾಹಿತ್ಯದ ಬೇಕಾ, ಹಿಂದಿ ಸಾಹಿತ್ಯದ ಬೇಕಾ, ತಮಗೆ ಇಂಗ್ಲಿಷ್ ಸಾಹಿತ್ಯದ ಬೇಕಾ? ಕನ್ನಡ ಸಾಹಿತ್ಯ
ನಮ್ಗಲ್ಲ,
ದಾರಾ ಬೇಂದ್ರೆ
ಲೈಬ್ರರಿ ಇದೆ.
ದಾರಾ ಬೇಂದ್ರೆ
ಪಾಪ
ಇದ್ದಾರೆ.
ಅವ್ರು ಯಾರು?
ದಾರಾ ಬೇಂದ್ರೆ ಅವರಿದ್ದಾರೆ.
ಬೇಂದ್ರೆ ಅವ್ರದ್ದು
ಆನಾ
ಸಾಹಿತ್ಯ ವಿರಾಟ
ಕೃಷ್ಣ
ಸ್ವರೂಪ.
ಆನಾ ಕೃಷ್ಣ ಇದೆ, ತಾರಾಸು ಇದೆ, ತ್ರಿವೇಣಿ ಅವ್ರಿಗಿದೆ.
ಯಾವ್ದು ಕೊಡಿ?
ತಾವು ಯಾವ್ದು ಹಿಂದಿದಲ್ಲಿ
ಆಯ್ತು, ಈ ಮೂರು ಜನರದ್ದು ಒಂದೊಂದು ಬುಕ್ ಹೇಳ್ತೇನೆ. ಫಸ್ಟ್ ಒಂದೊಂದು ಬುಕ್ ಕೊಟ್ಕೊಡಿ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ನೋಡಮ್ಮ, ಒಂದು ಬೇಂದ್ರೆ ಅವರ ಸಖಿ ಗೀತ, ಇದನ್ನ 2 ಕೊಡಬೇಕು. ಓಕೆ,
ಅದಕ್ಕಿಂತ ಪಂಚತಂತ್ರಗಳು ಅವೆಲ್ಲ ಕಲಿಬೇಕು ಮಕ್ಕಳೆಲ್ಲ.
ಕೊಡ್ಬೋದು, ಅದು ಒಂದು ಕೊಡಿ. ಆಯ್ತು, ಇದೊಂದು ಸಖಿ ಗೀತ ಪಂಚತಂತ್ರ ಬೈ ದುರ್ಗಸಿಂಹ, ದುರ್ಗಸಿಂಹನ ಪಂಚತಂತ್ರ.
ಕಬೀರ್ ದಾಸ್ ದೋಹೆಗಳಿದೆ.
ಯಾವುದು?
ಕಬೀರ್ ದಾಸ್ ದೋಹೆ, ರೈದಾಸ್ ಇದೆ.
ಹೇಳಿ, ನೀವು ಹೇಳಿದ್ದೆಲ್ಲ ಬುಕ್ಸ್ ಕೊಡೋಣ.
ಕೋಸ ಇದೆ, ತುಳಸಿ ರಾಮಾಯಣ ಇದೆ.
ನೀವು ಹೇಳಿದ್ದೆಲ್ಲ ಹೇಳುವ, ಕೊಡಕ್ಕೆ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಈ ಸೋಪನ ಕಥೆಗಳಿದೆ. ಜಸ್ಟಿಸ್ MC ಚಾಗ್ಲಾ ಅವ್ರದ್ದು ರೋಸಸ್ ಇನ್ ಡಿಸೆಂಬರ್ ಇದೆ.
ಈ ಸೋಪಿನ ನೀತಿ, ಅದು ರೋಜಸ್ ಆಗಿದೆ. ಈ ಸೋಪನ ನೀತಿ ಕಥೆಗಳು.
ಆಮೇಲೆ ಸ್ಪೀಚಸ್ ಆಫ್ ನೆಹರು 14 ವಾಲ್ಯೂಮ್ಸ್ ಇದೆ. ರಿಯಲಿ ನೈಸ್. ಡಾಕ್ಟರ್ ರಾಧಾಕೃಷ್ಣ ಸ್ಪೀಚಸ್ ಇದೆ. ದಟ್ ಇಸ್ ಆಲ್ಸೋ ವೆರಿ ನೈಸ್.
ಅದು ಯಾವ್ದು ಕೊಡ್ತೀರಿ ಅಂತ ಹೇಳಿ.
ತಾವು ಯಾವ್ದು ಹೇಳಿದ್ರೆ
ಇವು ಇಷ್ಟನ್ನು ಕೊಡ್ಬೇಕು ಅಂತ ನಾನು ಕೇಳಿದೆ. Anyway, ನೆಹರು ಅವರ
ಸ್ಪೀಚಸ್ ವಾಲ್ಯೂಮ್ ಅದು ಅಲ್ಲೇ ಸಿಗುತ್ತೆ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್.
ಸ್ಪೀಚಸ್ ಗಿಂತ
14 ವಾಲ್ಯೂಮ್ಸ್.
ಅಲ್ಲ,
ಲೆಟರ್ ಕರೆಸ್ಪಾಂಡ್ ಟು ಹಿಸ್ ಡಾಟರ್.
ಹಾ,
ಬ್ಯೂಟಿಫುಲ್.
ಗ್ಲಿಮ್ಸಸ್ ಆಫ್ ವರ್ಲ್ಡ್ ಹಿಸ್ಟ್ರಿ ಅಂತಾರೆ ಅದಕ್ಕೆ.
Yes.
She wrote letters to Indira
Yes.
when he was in prison. ಅಂದ್ಕೊಡಿ, ಚೆನ್ನಾಗಿದೆ.
Yes. That is why she is a very good able administrator.
Glimpses of world history by Pandit Jawaharlal Nehru. All right? ಎರಡು ಅನ್ಕೊಡಿ, ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡಿ.
ಆಗ್ಬೋದು ಯೋಗೇಶ್.
ಹಾ, ಇದು ನಮ್ಮ ಕೋರ್ಟ್, ಹೈಕೋರ್ಟ್ ಲೈಬ್ರರಿ ಕೊಡಿ.
Please,
Huh?
please. May lordship.
ಹಾ, ಮತ್ತೆ ಆಗ್ಲಿ ಕೊಟ್ಟ ಮೇಲೆ ಮುಂದಿಂದು ಕೊಡ್ಬೇಕು.
ನಾ ಕೊಡ್ತೀನಿ lordship. I will.
ಕೊಟ್ಕೊಂಡು ಮಾಡಿ, ಕೊಟ್ಟಾಗನೇ ಪೋಸ್ಟ್ ಮಾಡಿ.
Not because the last date is tomorrow to complain make pre-deposit condition.
ಈಗ ಪಾಸ್ ಓವರ್ ಅವ್ರಿ.
Please, madam.
ಆ ಬುಕ್ಸ್ ತೊಗೊಂಬಂದ್ಬಿಡಿ, ತೋರಿಸ್ಬಿಡಿ ನಮ್ಗೊಂದ್ಸರಿ, ನಮಗೂ ಸಮಾಧಾನ ಆಗುತ್ತೆ. ಒಂದು ವಿಷಯ ಅಸರ್ಟನ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಗ್ಲಿಮ್ಸಸ್ ಆಫ್ ಹಿಸ್ಟ್ರಿಯಲ್ಲಿ ನೆಹರು ರೈಟ್ಸ್, ಪಂಡಿತ್ ನೆಹರು ರೈಟ್ಸ್, ಕ್ರಿಶ್ಚಿಯಾನಿಟಿ ಕೇಮ್ ಟು ಇಂಡಿಯಾ ಬಿಫೋರ್ ಇಟ್ ವೆಂಟ್ ಟು ಯುರೋಪ್ ಅನ್ನೋ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ. ವೆದರ್ ಇಟ್ ಈಸ್ ಟ್ರೂ ಆರ್ ನಾಟ್ ನೋಡ್ಕೊಂಡು ನಂಗೆ ಹೇಳ್ಬೇಕು.
Please, madam. Before BC or AC ಅಂತಲ್ಲ ಇರ್ತದೆ.
Just look into it, say. Yes.
32 days delay there, it may be
Eh?
valid. 32 days.
Under one.
Transfer pricing issue is involved.
Eh?
Transfer pricing issue.
Same. Application allowed, signed.
Question one only, my lord. The other question I may be permitted to urge in connected matter 435 of 24. 435. my lord.
Appeal is admitted on the
Question-
first
first question.
substantial question of law alone. First off. However, liberty is reserved to urge rest in
435 of 22.
appeal number 435 of 2023.
22, my lord.
22. ಇದ್ರ ಜೊತೆನೆ ಕಾರ್ ಮಾಡ್ಬೇಕಾ?
ಮಾಡ್ಬೋದು.
First, call that matter with this. Okay. Ah. 233 days delay. Nageshwar Rao,
Lordship, may I request for a passover?
Passover.
Yes, Your
Delay
Lordship.
condone ಮಾಡ್ಲಿಕ್ಕೆ.
Your Lordship, request for a passover because our objections also we have prepared. My colleague is carrying. Mr. Nageshwar Rao is presently on his legs before another court.
All right.
Kindly give me a passover.
All right, Passover.
Much obliged, Your Lordship.
Passover. Yes.
My lord, appearing for the respondent,
Ah,
we have no objection to the delay. my lord.
no objection. 191 days. ಒಂದು ಪುಟ್ ಪುಸ್ತಕ ಕೊಡ್ಬೇಕು.
No objection ಹೇಳಿದಾರಲ್ಲ.
No objection. ಅವ್ರು ಹೇಳಿದ್ರು ಡಿಲೇ ಇಸ್ ಕ್ವಶನ್ ಆಫ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ. ಅವ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳ್ತಾರೆ. ಅದು ಅವಾಗೇನು ಆ ರೀತಿ ಅವರು ವಿಧಾನಸೌಧ ಬರ್ಕೊಳ್ರಿ ಅಂದ್ರೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾವು ಬಿಡ್ಬೇಕಲ್ಲ. ಹಂಗೆ ಒಳ್ಳೆ ಒಂದು ಪುಸ್ತಕ ಕೊಡ್ಬೇಕು. ಯಾವ್ದನ್ನು ಕೊಡ್ತೀರಿ? ಅರ್ಜುನ್ ಭಾರದ್ವಾಜ್ ಅವರ ಹೋಮರ್ಸ್ ಎಪಿಕ್ಸ್ ಕೊಡ್ಬೇಕು. ಬೆಸ್ಟ್ ಪುಸ್ತಕ ಅದು. ಐ ಆಮ್ ರೀಡಿಂಗ್ ದಟ್ ಬುಕ್. ಅದನ್ನ ಭಾರತೀಯ ಸೌಂದರ್ಯ ಶಾಸ್ತ್ರದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಬರೆದಾರ ಅವರು, ಒಬ್ಬ ಸ್ಕಾಲರ್. ಅದನ್ನ ಕೊಡಿ, ಒಂದು ಬುಕ್ ಕೊಡಿ.
Please.
ಇಟ್ಸ್ ಅವೈಲೇಬಲ್.
Please.
ಓಕೆ, ನೋಡಮ್ಮ. ಡಾಕ್ಟರ್ ಅರ್ಜುನ್ ಭರದ್ವಾಜ್ ಈಸ್ ಎ ಪಾಲಿಮಾತ್ ಆಲ್ಸೋ. ಡಿಲೇ ಕಂಡೋನ್ಡ್. ಹೈಕೋರ್ಟ್ ಲೈಬ್ರರಿ.
It may be admitted, my lord. The transfer pricing issues are.
ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Question 1 to 6, my lord.
ನೋಡಮ್ಮ, 1 to 6 as follows. Okay. Next.
My lords, yesterday, my lords, the connected matters came up, my lords. There also, my lord has given me 3 weeks to file a better affidavit. I'll file a better affidavit, my lords. 621 or 23.
2 weeks for filing better affidavit in support of subject application. Yes. Better affidavit means something more will happen.
Yes, yes, my lord. Yes. Yeah, it can be tagged along with the other matter, my lord. 621/23, my lords.
ನೋಡಮ್ಮ. All right.
Petition, my lord. Lord, this I number 2 of 2024 for amendment of writ petition. It's already allowed on 17/12/2024, my lord.
ಅಲೋ ಆಗಿದೆ.
And I've also filed amended writ petition and carried out the amended.
ಅಮೆಂಡ್ಮೆಂಟು ಆಗಿದೆ, ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಹಾಕಿ ಆಗಿದೆ.
Oh, please. I've served the copies to the.
ಸರ್ವ್ ಮಾಡ್ಯಾರ. This application is already allowed by the order dated 17/12/2024. First off, registry has not bothered to look into it. Okay.
Lord, interim order may kindly be extended in both the cases.
I am ready. It's also Arkavati matter. Justice Keshwanarayan committee report.
Committee report ಮೇಲೆ
Last ಇನ್ನೊಂದು matter ಇತ್ತು ಅದು ತಾವು ಎಜ್ಜೆಲ್ ಮಾಡಿದ್ರು.
4 ಮ್ಯಾಟ್ರಸ್ ಇರ್ಬೇಕು ನಮ್ಮ ಹತ್ರ ಅಲ್ಲ.
Serial number 5.
ಒಂದ್ ದಿವ್ಸ ಇವ್ನ ಹಾಕೊಂಡು ಮುಗಿಸ್ಬಿಡ್ಬೋದೆಲ್ಲ. ಸಪರೇಟ್ ಆಗಿ. We can have, but ಸುಮ್ನೆ ಇದೆಲ್ಲ ಹಿಂಗೆ ಏನೋ ಒಂದು ಗೊತ್ತಾಗ್ಬಿಡ್ಲಿ ಅಲ್ವಾ? ನೋಡಿ. Post this matter ಒಂದು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹೇಳಿ.
Great.
18 or 19, my lord. 18 or 19, my lord.
18th, my lord.
18.
25
Yes.
February.
Great.
ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಇದ್ದಾಗ ಅದೇ ಡೇಟ್ ಹಾಕ್ಬೋದು.
Number 5.
Serial number 5 ನು ಅದೇ ಡೇಟಿಗೆ ಹಾಕ್ಬೇಕು.
5 ನೋಡಮ್ಮ. 5 ಆಲ್ಸೋ ಅದೇ ಡೇಟ್ಗೆ ಹಾಕ್ಬಿಡಿ. ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಕಂಟಿನ್ಯೂ.
In both the cases. In both the.
In both the cases.
Please.
ಅಲ್ಲೂ ಇದೆ ಅಂತೆ ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Please.
Great.
Great.
My lord,
Ah,
writ appeal filed by the revenue, my lord, against the order of the learned single judge. My lord, setting aside the notice issued under 148
148 notice.
for reassessment,
Reassessment.
where, my lord, there is an, according to the revenue, escapement of income. My lord, in GK and drive shaft, my lord, in the case of GK and drive shaft, the Honorable Supreme Court, my lord, laid down the law which was not there in 148. They said SSC filed a writ petition challenging 148. Then the Honorable Apex Court said, my lord, whenever 148 is issued, the SSC has a right to get the copy of reasons recorded in writing, which is noted by the assessing authority prior to issuance of notice. Reasons recorded in writing. So, my lord, recording that income has escaped assessment. And that copy, he is entitled to get it. Once he gets the copy of the same, he is entitled to file an objection. And that objection should be considered by passing a speaking order. Then only, if at all, he should approach the courts. My lord, in this
Did
case,
I refer to that judgment in one of my judgment?
ಇಲ್ಲೇನಾಗಿದೆ ಅಂದ್ರೆ 148 came to be challenged. Reasons recorded were submitted, given, supplied to the SSC. But even before the assessing authority could pass a speaking order,
You passed the order.
learned single judges, my lord, gone into the merits of the case. My lord, now my humble submission is, my lord, assessing authority had no chance to even to rebut the objections or.
On
my lord,
what
contest.
ground learned single judge?
He has gone on merits. So my humble submission is, my lord, let it be admitted, my lord, a date be fixed for arguments.
There are 2-3 other issues also, my lord, in addition to what my other friend is saying, which is what compelled us to come to court. And therefore, my lord, lords may have to hear this at some point in time. Because there are actually quite a significant number of other issues which may require your lordship's kind attention.
Then we will admit this.
Please.
Admit. Entry order ಕೇಳಿರನ?
ಇಲ್ಲ ಕೇಳಿ.
ಕೇಳಿಲ್ಲ. Admit. ಅಲ್ಲೇ heard learned panel counsel appearing for the appellant and the learned senior advocate appearing for the assessee, assisted by advocate on record. First, matter requires deeper consideration. First, admit. Great.
There are another two connected matters, my lord. 74 of 24 and 75 of 24. It may be clubbed, my lord.
ಯಾವುದು 22
Yes,
ನಾ?
number 22, my lord.
ಅದೇನು 78 days ಡಿಲೇ ಇದೆ ಅಲ್ಲ, ಕಂಟ್ರೋಲ್ ಮಾಡೋಣ ನೋಡಮ್ಮ. 78 days ಕಂಟ್ರೋಲ್. Call this matter along with
74 of 24, 75 of 24.
very well.
Please.
Challenge at the DRAT order, my lord.
Huh?
DRAT order, 50% I supposed to deposit, 6 weeks time is granted, I'll deposit that amount, my lord.
50%
DRAT.
deposit
Before DRAT, my lord.
before DRT for filing appeal.
DRAT, my lord. DRAT, appellate order,
Section 18.
18, my lord.
ಏನಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
That is page number 73, my lord. Which accordingly, the petitioner appellants are directed to deposit 50% of the 37 lakhs 9,000, which comes to rupees 18 lakh 54,574. It has to be deposited on or before 22/11. Otherwise, this petition will be dismissed.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಈಗ.
Dismiss ಆಗೋಗಿದೆ.
ನೋಟಿಸ್ ತೊಳಿ. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ. ಶೂ emergent notice.
If I may be permitted to deposit and I'll contest the matter in merits, on merits in the DRAT, my lord.
No, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇದ್ದಂಗೆ ಹೆಂಗ್ ಮಾಡೋದು? There is already an order in their favor. Emergent notice. In addition to taking usual steps, petitioner is directed to take hand summons to the respondent bank as well. Post immediately after service.
Appellants, my lords. Challenging the order of the learned single judge, my lords. The question for here is, my lords, whether a proper officer can issue a notice, show cause notice, when substantial part of investigation has been partaken by improper officer, my lords. Some part of the investigation has been done by the improper officer, my lords.
Improper or unauthorized?
My lords, the wording used in the judgment is improper, my lords. It's
Improper.
Improper. The issue in question is, my lords, there was a cross-jurisdictional issue. There was investigation ongoing through two parallel agencies, my lords. In fact, the first agency.
One agency is?
The Bangalore Commissionerate, my lords. Bangalore Commissionerate took up the issue initially, my lords. Subsequently, it was found out that the issue comes within the jurisdiction of Northwest Commissionerate, Bangalore, my lords. In view of the same, the issue got transferred. Subsequently, all the materials also was transferred. Material seized till that date got to be transferred, my lords. Subsequently, the investigation began from the Commissionerate's end, Bangalore Commissionerate's end, my lords. Based on that, the learned single judge holds that the initial part of the investigation, which was done by the improper officer, cannot be relied upon. The documents or the materials seized cannot be relied upon by the proper officer, my lords. My lords, in fact.
In American law, there is such a judgment where illegally they barged into the house without warrant of a citizen.
Yes.
And they found incriminating material, which they wanted to use it in an offense in prosecution. American Supreme Court said the due process of law comes in the way. But in India, that has not been agreed. 1971 Supreme Court says, where it says illegally procured evidence can be admitted to record if it is otherwise admissible anta hold ಮಾಡಿದ್ದಾರೆ.
Should I join Delhi High Court?
नहीं, दिल्ली में अभी नहीं आएगा.
क्यों?
वो अभी 5th के मैटर्स टेकअप कर रहे हैं, एक मैं बता रहा हूँ.
But प्रतीक तो बोलता है.
Okay. So just look into that.
Yes, my lords, I'll do this.
It requires otherwise also
It requires
consideration.
consideration, my lords. My lords, the
Issue
directed for
emergent notice, interim order as prayed for till next date of hearing. First, in addition to taking usual steps, petitioner appellant to serve copy of the petition along with all the documents on the learned counsel who represented the assessee before the learned single judge.
much.
Right. I represent the petitioner in this matter.
Yes, Mr. Rao.
My lord, Annex A, my lord, is the order under my lord challenge. But my lord, the arbitration proceedings and my lord, the prior instituted suit by the petitioner, could it go, my lord,
Earlier it
together?
was.
Is the question. Please.
Earlier
My
suit.
lord, mine suit is earlier.
Is it true? You are for
Yes.
appellant.
No,
Please
he's my
then show.
colleague. my lord. He's my. Please. But in fact, order sheet of my lord, the suit I have placed before the court. Annex F, my lord will see. Blood suit is instituted
OS
as early as
2922
of
2922 of 2023.
Please, my lord. There, I have challenged, my lord. The my lord, what he does, my lord, during subsistence of the contract in my favor, joint development agreement, deals away with the property. My lord, later, my lord, he approaches this honorable court for appointment of an arbitrator. Subsequently, my lord, the arbitration proceedings are constituted.
You show
My
when the suit was filed?
My lord will see the date there, my lord, in Annexure F, page 97. 27/4/2023 is the date of filing of the suit.
And arbitral proceedings?
The proceedings commenced only, my lord, by virtue of the orders of this honorable court. That is, my lord, subsequently on 7/6/2023. My lord will see, my lord. Yes, my lord.
7/6.
20 subsequent to that, my lord. In fact, I have placed it, my lord, on record. I'm
Where have
sorry,
you
my lord.
stated?
Yes. My lord, in the synopsis, I have said 21/12/2023, CMP 767 of 2022.
Honorable Justice Shyam Prasad's order.
Please, my lord, please, my lord, please. It happens.
When the
subsequently.
arbitration proceeding is deemed to have been commenced?
No, my lord, the moment, my lord, the notice is issued, my lord, for appointment of an arbitrator. And thereafter, my lord, the court appoints, my lord, the arbitrator. Meanwhile, my lord, the suit was already pending, where, my lord, several contentions are put forth.
Emergent notice, interim order as paid for till next date of hearing.
I'm grateful, highly obliged.
For the appellant, my lords.
Yes, Monica.
My lords, order was passed under section 271D, my lord. And
271D.
please, my lord, for violation under section 269 SS of the Income Tax Act. Now, my lord, as per limitation under section 275(1)(c), my contention is that it was barred by limitation, my lord.
What's the limitation period?
My lord, it is 6 months from the date when the matter was referred by the assessing officer to the Joint Commissioner of Income Tax.
Now, you know, the judgment.
Please, my lord.
There, my lord, the difference is
Court of
the assessing authority had recorded issue notice for penalty, something like that.
Assessing officer is, your contention was when the penalty proceedings are deemed to commence anta. Him contention yenittu kelkoli pura judgment now barada.
Yes.
You refer to Kerala High Court judgment and Delhi High Court judgment.
Please.
ಅದರಲ್ಲಿ ಟ್ರಿಗರಿಂಗ್ ಪಾಯಿಂಟ್ ಅನ್ನೋ ಕಾನ್ಸೆಪ್ಟ್ ಮೇಲೆ ಪ್ರೊಸೀಡ್ ಆಗ್ಬಿಟ್ಟು ನಾವು ಅದನ್ನ ಆ ರೀತಿ ಮಾಡಲಿಲ್ಲ, ಸ್ವಲ್ಪ ಬೇರೆ ನಮ್ನಿ ಮಾಡಿ. ಅಲ್ಲಿ ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ದ ಲಾ, ಐ ಥಿಂಕ್ ವಿ ರೆಫರ್ ಟು Aaron Barak's Israeli Supreme Court's Chief Justice Aaron Barak's the purposive interpretation of law judgment and refer ಮಾಡಿದಂಗಿದೆ ಅಲ್ವಾ? Requires consideration. Requires consideration. If we say the object is to leave the citizen to sleep peacefully. ಯಾವಾಗ ಈ ಡೊಮಕಲ್ ಸ್ವರ್ಡ್ ಅನ್ನ ಅವ್ನ ಬೆಡ್ರೂಮ್ ನಲ್ಲಿ ಹ್ಯಾಂಗ್ ಮಾಡ್ಕೊತಿಡಕ್ ಆಗಲ್ಲ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಬರ್ದೇವು ನಾವು ಅದನ್ನ. That's how it was
here, on the very next day, the notice is issued. The officer makes a report to the.
ಅದು ಯಾವ ಪೀರಿಯಡ್ ನಲ್ಲಿದೆ? ಆ ರಿಪೋರ್ಟ್ ಯಾವಾಗ ಕೊಡ್ಬೇಕು ಅಂತ ಪ್ರಶ್ನೆ. ಆ ಪೀರಿಯಡ್ ನೀವು ರಿಪೋರ್ಟ್ 10 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ಕೊಟ್ಟು ಅದಾದ್ಮೇಲೆ ನೀವು ಕೊಟ್ಬಿಟ್ರೆ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ, ಐ ಥಿಂಕ್ ಕಮಿಷನರ್ ಅನ್ನೋ.
Here on the very next day it is issued.
That makes no sense. Up to next day, what all happened? What is the length of period?
My lord, in fact, it's not on the very next day, my lord. They indicate.
No, assuming next day.
Please, my lord.
What is the length till then, amount of time spent?
Assessment, my lord, of 2011 to 12 financial year.
Ah.
And assessment orders passed on 27/3/2015. Thereafter, my lord, he makes a reference to JCIT on 30/3/2015. Then they claim that on 1/4/2015, show cause notice is issued.
Which paragraph your contention will fit into of our judgment?
My lord, my lord, if I may point out page 3, my lord, if I may point out the sequence of events as is culled out.
We have read and come back.
My lord,
We have read the file and come back.
please, my
Therefore, read the law.
please, my lord, please. At para 6.5, my lord, page 12.
Read.
Please, my lord. The Parliament in its accumulated wisdom has enacted a limitation period in the subject provision of the 1961 Act. What is conspicuous is the absence of any provision for condoning delay or extending the limitation period. In jurisdictions built on the bedrock of separation of powers, ordinarily a judge is authorized to interpret an existing text of a statute but not to create a new one. Power to alter a statutory text belongs to the domain of its author, not of its interpreter. It hardly needs to be stated that their non-interpretive capacities, courts do go beyond the interpreting the text of a statute. Justice Felix Frankfurter of US Supreme Court in his article, some
Science.
reflections, please,
Okay.
my lord. Further, my lord, the court holds.
We have rejected your contention. Kindly see to 6.6.
Please.
The appeal is,
Please.
which is the question, substantial question of.
6.7, my lord, may 6.7, my lordships have noted the dates there
Yes.
in the case concerned, my lord. Here, in the present case, my lord, I will just mention 3-4 dates, my lord.
No, 6.7.
6.7, my lord.
Please,
My lord, from,
please understand.
Please.
You lack connect with the judge.
please,
Really, it should not happen.
my lord, I'm
Please, wait, hear us. 6.7 is case specific. Principles are laid down in 6.5,
Please,
6.6.
please. So dates are
Appeal,
mentioned, my lord, in
no, no, any
6.7.
appeal
Literally, my lord,
is
dates.
admitted on the following substantial question of law. Yaudadu.
My lord, the question of law framed was solely on service of notice, my lord, because initially notice also was not served. That was what was framed. However, your lordship may kindly peruse page 13, my lord, of my appeal. D, my lord, page 19D. Can a penalty order be passed after lapse of limitation period under section 271D, and whether there is no mandatory requirement to serve the
Madam,
penalty? Please.
appeal is admitted on the following questions of law by treating them as substantial questions of law. First of all, ಅಲ್ಲಿ ನೋಡಿ page 13, 14 ನಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ. ಜಸ್ಟ್ ಒಂದು hello flap ಅನ್ನು ಇಟ್ಟಿರ್ತೀನಿ. Requires consideration.
Please.
ಅಲ್ಲೇ the question, first of all, we have noted our decision. ಅದು ಹಿಂಗ್ ಮಾಡ್ಬೋದು. ಹಿಂಗ್ begin ಮಾಡ್ಬೋದು. After noting our decision in Principal Commissioner of Income Tax versus K. Umesh Shetty, ITA number 165 of 2020, disposed of on 17/1/2025, comma, this appeal is admitted in ಉಳಿದಿದ್ದೆಲ್ಲ ಸೇಮ್ ಇರ್ತದೆ.
Please. Wait.
My lord, transfer pricing matter, my lord.
Transfer pricing,
Matter. My lord, we had raised 3 questions of law, my lord.
which question is being debated?
My lord, first 2 questions can be admitted, my lord.
Two questions ಮೇಲೆ ಮಾಡೋಣ.
And we are filing also, my lord, additional questions, my lord.
You have filed additional questions.
Questions, I have given the copies, my lord.
Okay. That you can raise when the appeal is being heard at merits, na? Because section provides for that.
It
When
does
the
not.
appeal is being heard, you can raise the questions. It's on par with 100 of CPC,
Please.
which you have said that, this one, that Woodward's. No, no, appeal is admitted on the following substantial questions and also additional substantial questions now furnished. Following substantial questions of law framed at Roman para 6, page 7 of the appeal memo, and also the additional questions,
4 and
additional
5, 4 and
substantial
5.
questions of law now furnished by way of memo dated 6/2/2025. Idra nodkondu ಎರಡು number. First, next paragraph. Most of these questions are being debated in an ongoing matter before the coordinate bench, in which KSDJ is also one of the members, one of the judges. Okay.
This appeal.
Yes, Mahesh.
Husband of the SSC Mlad was working as chartered accountant abroad Mlad. He worked there for nearly 33 years. He used to remit money Mlad to my, I am a non-SSC Mlad. He used to remit money to my SB account Mlad for my maintenance and other things. Now Mlad, for this, whatever the amount deposited Mlad in my SB account, totally amounting to 21,79,000 was found to be unexplained money Mlad, and tax is ought to be levied on me. Now my difficulty is Mlad, my husband is now come back and he is suffering from dementia and he is taking treatment. The amount remitted by him, Lord, I am not in a position to explain, Lord, because I am a non-SSC and I was not, I have not remitted any amount, Lord, to my account, Lord. That's the difficulty.
But somebody has remitted money to you.
Lord, my husband has remitted, Lord.
Your husband has remitted money to you.
Yes, Lord. That's the problem, Lord.
If it were to be English law, perhaps we would have said, because in English law, wife is part of husband.
Yes.
At least up to 1890, Arun. up to 1891, till they amended the law. Husband, the wife was part of husband. And if husband were to kill wife, it was considered a half suicide. And there was no law for punishing half suicide. All husbands were acquitted. Then in 1891, they amended the law. Mr. Patil, they amended the law, saying that killing wife is also manslaughter. Anyway, that's what. But in law, in Indian jurisprudence, husband and wife are treated as two separate individuals.
Yes. But,
therefore, income coming from husband is income earned by the wife. What's the law on the point?
Your Lordship, here in this case, it's a cash deposit, whether there is nexus between the earning of the husband and the deposits made, that has to be proved. Cash deposit of 21 lakhs, whether the husband's money which has been earned, what the assessee's contention is not, that has to be supported with evidence. There is not even iota of evidence to show that it is husband's money which has been earned outside. And same is transferred to the wife.
If husband...
Source is not proved.
Suppose if husband, a chartered accountant, earns money.
Yes, ma'am.
And presents it to, he is better off.
Yes, ma'am.
All right, dear, you take this money. Whether that attracts income tax?
No, ma'am. That husband's earnings itself is not proved.
So wife's independent income.
Independent income ಆಗಿರಬಹುದು.
ಎಲ್ಲಿದೆ ಪ್ರೆಸೆಂಟ್ ಕಳಿಸಿದೆ ಯಾವ ರೀತಿ ಇದೆ ಮಟೀರಿಯಲ್ ಏನಿದೆ?
So far as impugned orders are concerned, there is no discussion on that.
That's all. You show it now.
ನಿಮ್ಗೆ
ಎಲ್ಲಿಂದ ಬಂತಪ್ಪ? ಹಸ್ಬೆಂಡ್ ಕಳಿಸ್ಯಾರ ಅನ್ಲಿಕ್ಕೆ ಹೆಂಗ್ ಅದನ್ನೇನು ಯಾವ್ದೋ ಪಾಕೆಟ್ ನಾಗ ಇಟ್ಟು ಕಳ್ಸಕ್ ಬರಲ್ಲ.
It is through account only, everything is through account only. He remitted directly from there to my SK account.
ಆ ಮಟೀರಿಯಲ್ ತೋರಿಸಿ. ಸ್ವಲ್ಪ ತೋರಿಸಿ ನೋಡೋಣ. Whether husband's gift of money to wife Does it attract income tax?
No, my lord.
It does not.
If it is earned money, my lord, he can give it to, within the
Anybody.
family members, he can give it to.
He can give it to, and no income tax is leviable. At least that's a good thing.
Lord, SB account extract I am having. Lord.
Buddy. ಅವ್ರ ಅಕೌಂಟ್ ಇಂದ ಬಂದಿದೆಯಾ? ಬಂದದ ಅಕೌಂಟ್ ಥ್ರೂ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದನ್ನೆಲ್ಲ ಏನು ತೋರಿಸಿಲ್ಲ ಅಲ್ಲಿ. ಆಲ್ ದಿ 3 authorities.
ಈಗ ನೋಡಿ ಸ್ವಲ್ಪ ನೋಡೋಣ. ಈಗ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಇದೆ ನೋಡೋಣಂತೆ. More whether it is earned or it is transferred ಅನ್ನೋದು, it's not a pure question of may not be. That's all right. But suppose if stares at you, ನಿಮ್ ಕಣ್ ಮುಂದೆ ಹಿಡಿತಾರಪ್ಪ ಅವರು, ಅದನ್ನು ಇಗ್ನೋರ್ ಮಾಡಕ್ ಬರ್ತದಾ?
ಇಲ್ಲ ಬರಲ್ಲ.
ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅದು. ಅವಾಗ ಅದು it partakes the substantial.
If all the authorities have ignored this material, my lord,
ರಿಮೆಂಡ್ ಮಾಡೋಣ, reconsider ಮಾಡ್ಕೊಳ್ಳಿ.
it may be sent back to the tribunal to reconsider and also to enable the assessee to produce additional document.
ಅಷ್ಟೇ. That's good actually.
In the meantime, if my husband recovers, my lord, it will be easy for me, my lord, to.
ಅಂದ್ರೆ ಈ ಅಮೌಂಟ್ ಅನ್ನು ನೀವು ಅಲ್ಲಿ ಖರ್ಚು ಮಾಡಿ.
No, if my husband recovers from his ailment, my lord, if he improves his memory power, not I can.
ಅವರು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸೋದೇ ಬೇಡ.
Please.
ಅವ್ರದ್ದೇನ್ ಬೇಡ. ಇದೇನ ಟ್ರಾನ್ಸ್ಫರ್ ಅಕೌಂಟ್ ಇಂದ ಆಗಿದೆಯಾ ಇಲ್ಲ, ಕ್ವಶನ್ ಆಫ್ ರೆಕಾರ್ಡ್ ಅಪ್ಪ. ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಮುಗಿದ್ ಹೋತು. ಬರ್ಕೊಳ್ಳಿ. A wife is grieving in the appellate jurisdiction of this court on the ground that whatever has been presented by way of gift by the husband who was working a chartered accountant on a foreign soil could not have been taxed under the IT Act 1961. First stop. The appellant assessee has framed the following substantial questions of law. ನೋಡಮ್ಮ, page 7 ನಲ್ಲಿ para 6 ನಲ್ಲಿ ಜಸ್ಟ್ ಒಂದು ಇಲ್ಲಿ ಪಿಂಕ್ ಇದನ್ನ ಹಾಕಿರ್ತೆ ನೋಡಿ. Next. Learned senior panel counsel appearing for the revenue vehemently resist the appeal, contending that none of these questions has trappings of law, much less substantial questions of law. First off, when we confronted him with the question whether the assessing office authority can ignore the evidentiary material that would have made all the difference to the finding of fact on which the impugned order is constructed, he very often, very fairly says, such a material cannot be ignored. First off, such a circumstance in our considered opinion would give rise to a substantial question of law, because that would be a case of finding recorded at least without evidence, if not contrary to. First, there is a lot of authority in support of this view. First, next paragraph. In the above circumstances, this appeal is favored, broadly answering the subject questions of law in favor of the assessee,
Your lordship,
only for the limited purpose of
the questions did not-
reconsideration.
Since it's a case of remand, your lordship is not answering any substantial question of law, my lord.
Can we retreat the remand without answering the question?
Yes, my lord.
No.
Because your lordship may can see the substantial question of law raised by the assessee is that whether.
Then only appeal. It is a precondition.
Question number 4, your lordship may can see, it is relating to the issue whether the assessing authority was right in not stating any provision relating to for making this addition. That question does not arise, my lord.
Anyway, we are saying, like Mr. Nagannan, even for sending the matter in remand, whether question of law has to be treated.
No, my lord.
Not
Remand
necessary.
Only if the honorable court is deciding the appeal, my lord, then question if the second.
Whether remanding the order matter, is it not deciding the appeal?
But my lord, the requirement of framing question of law is for the honorable court to decide whether the tribunal has reached a correct finding on fact or no. But on procedural issues, my lord, if the court finds that there is something which is not seen by the tribunal, then there are two courses, my lord. One is to remand, or second is to call for an additional statement of facts. That practice also has been followed in the past. If on some particular aspect there is no material, my lord, or there is no finding of the
There
tribunal,
we can call for
then
report.
an additional statement of facts can be called.
Thank you. Thank you. Alonam, in view of the above, these questions need not be answered at our hands at all, since we are taking the route of remanding the matter for consideration afresh. First, next part. In the above circumstances, this appeal is allowed in part. Impugned order is set at naught. Orders are set at naught. Matter is remitted to the portals of the assessing authority,
Assessing authority.
Assessing authority for consideration afresh in accordance with law, and after giving an opportunity of hearing to the appellant assessee. First, all contentions of the parties are kept open, courts made easy. All right.
And liberty is also reserved to the assessee to produce additional document.
Liberty is reserved to the assessee to produce additional documents, if any, relevant to the subject matter within reasonable time. Okay. Next.
It may be adjourned, the transfer pricing issues
My
are
lords.
adjourned for 4 weeks.
My lords, I appear for the respondents.
In Sanmati.
Yes.
Mr. Rao, we are hearing that one matter is ongoing, na?
I'm aware, my lord. I only want to draw my lord's attention to a very short point, if my lords want to consider. Kindly see the substantial questions of law. 1 and 2 don't arise because the matter is remanded back, and 3 is already decided by a decision of Honorable Supreme Court. So if still my lords want to keep it after 4 weeks, I go to the court. I have no problem. I leave it to my lords.
Remand.
Adjourn it for 4 weeks, because that whether remand is correct or not, my lord, I will argue the matter. It may be adjourned for 4 weeks, my lord. It depends upon the.
And third question is answered by the apex court.
Under Honorable Supreme Court. Yes, in
Second
Hindustan
question,
Liver.
whether that remand is correct or not, I can argue the matter.
All right. Adjourned by 4 weeks at the request of so and so, reluctantly. Yes.
Obliged to my lords.
My lord, on the issue of computation of capital gains, my lord, the tribunal relied upon its earlier order. My lord, the revenue could not come up in appeal, my lord, in the earlier order because of monetary limits. We were barred, my lord, so this.
Where appeal is held not maintainable because of monetary limit, that does not operate as res judicata at all.
So this issue has to be decided. Page number 8.
Notice ಮಾಡಂತ ನೋಡ್ಕೊಳ್ಳಿ.
Admit ಮಾಡಬಹುದು, because this is purely a legal issue, my lord.
Page number 8.
Page number 8.
Admitted on the following substantial question of law. Page 8 ನೋಡಮ್ಮ. Issue emergent notice. Yes.
But I've been instructed to appear, my lord. I'm
Yes.
a late entrant in this case, my lord.
Nice,
I'm
nice.
told that
Whoever.
my client has already finished his submissions. I think Mr. Patil has to argue. The first appeal, my lord, relating to the specific performance matter.
Yes. Mr. Nayak had argued
Yes,
this matter
Mr.
perhaps.
Ravi Nayak had appeared, my lord.
Huh.
He has some disability, my lord.
Is it? Okay. We can accommodate him because he argued so well other day. If I have no objection for you to appear, but he argued so well the other day. We made so many notes also. And we just refresh because let us begin that way.
Very well.
Okay.
Lord, I'm told that this matter had been heard, my lord, when your lordships were sitting in this combination very long time ago. And
Question is,
thereafter,
we remember, you remember. In fact, one question we posed to Mr. Naik also the other day, whether that amendment is retrospective in operation, because Mr. Patil raised that issue. And Rajgopal also perhaps.
that is now decided, my
Rajgopal
lord.
also
The latest decision of the Supreme Court
is
is
retrospective.
that amended law will apply to contracts entered into prior to the
So
amendment.
retrospective in operation.
Earlier, my lord, there was a view that had been taken that if the contracts had been entered into prior to amendment, that will not apply. The later decision, my lord, says it will apply.
It will apply. But it will have some, it will cast a shadow on this also.
Yes, in the sense, my lord, that the amendment is that specific performance cannot be denied.
It robs of discretion of the court,
Discretion
which otherwise was obtaining earlier.
available in that. Yes. My lord, if I can just state a few facts, my lord, just to refresh.
Yes, sir.
The appellant, my lord, before your lordships, was an agreement holder. The property, my lord, is 4 acres and 27 guntas of agricultural land. The agreement, my lord, was entered into on 17th of February 2001. It provided, my lord, that was Exhibit P2. It provided that the consideration would be 74,80,000.
Agreement is dated
17th February 2001. The price provided there is 74.8 lakhs.
acres.
Acres, 4 acres, 27 guntas. Survey number 33/2. Naganur village. Dasanpura Hobli, Nelmangla Taluk.
Nagarur village irukadu.
Nagarur, huh?
Nagarur.
Nagarur, yes.
ಅಲ್ಲಿ ಸಂಜಯ್ ಖಾನ್ ರಿಸಾರ್ಟ್ ಇದೆಯಲ್ಲ ಅಲ್ಲೇನೋ ಬರುತ್ತೆ
ಅದ್ರ ಹತ್ರನೇ
ಅಲ್ವಾ?
ಅದ್ರ ಹತ್ರನೇ.
All right. How much money was paid as on the date of agreement and how?
My lord, according to the my lord, 25 lakhs, 22 lakhs and 30,000 in cash.
22.30 in cash.
And 2,70,000 by check.
This was on
17th February 2001. There is a second agreement on the same day. That is Exhibit P4.
ಅದು ಮೊದಲನೇದು ಯಾವುದು?
P2, my lord. P2. The second agreement is also dated 17th of February 21. Where the price indicated is 52 lakhs 50,000.
Same day.
Same day. The reason, my lord, is this, that this 22,30,000 cash which was given, that is not reflected in this. So what they did was 74,80,000 ಅಲ್ಲಿ 22,30,000 ಕಳೆದ್ಬಿಟ್ರು. After deducting that, there was another agreement for 52,50,000.
ಅದೆಷ್ಟು ಗಂಟೆಗೆ ಆಯ್ತು? ಗ್ಯಾಪ್ ಅವರ್ಸ್ ಏನಿದೆ ಡಿಫರೆನ್ಸ್?
ಸೇಮ್ ಡೇ ಅಂತ ಇದೆ, ಪ್ಯಾರಲಲಿ ಅಂತ ಇದೆ.
ಇದನ್ನ ದಿಸ್ ಇಸ್ ಎಕ್ಸಿಬಿಟ್ P2 ನಾ?
This is exhibit
P4.
P4. The explanation is that the vendor did not want to show this cash component which was received. Therefore, at his request, we signed another agreement which showed the official amount to be payable. This 2 lakh.
ಇದು ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿದೆಯೇನೋ? ಇಲ್ಲ.
Both documents are admitted.
Are admitted.
Signatures are admitted.
Execution admitted.
Execution also admitted.
P2, P4 are admitted.
Admitted, the receipt of cash component is denied.
Execution is admitted.
Yes.
Execution of P2 is admitted. P4 is denied, saying it's not there was no such agreement, nor was any request made to exclude the cash component, etc.
All right.
Written statement, they deny. Cross-examination, he admits.
They have admitted.
Yes.
Just ಒಂದೇ ನಿಮಿಷ
Yes,
ತೋರಿಸಿ.
ma'am. Your lordships may take.
This
note.
only for focusing.
Page,
We'll hear you in detail on whichever way you want.
Volume paper 1, paper book ali, page 146 ali, the defendant, my lord, was not examined in person, but her husband, my lord, was a power of attorney, he was examined.
Page number?
His cross-examination, my lord, begins at page 170. 162, my lord, cross-examination. ಅದರಲ್ಲಿ page 166.
ದಿನಾಂಕ 17/2/2001 ರಂದು ಕ್ರಯಪತ್ರವಾಗುವ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಹೆಂಡತಿ.
Para number 6, page 166 ಅಲ್ಲಿ.
ತೋರಿಸಿದ ದಾಖಲೆ ಮೇಲಿರುವ ಅದು 2 ಕರಾರು ಪತ್ರ
ನನಗೆ ತೋರಿಸುವ
ನಡೆಯುತ್ತಾರೆ.
ನನ್ನ ಹಾಗೂ ನನ್ನ ಹೆಂಡತಿ ಸಹಿಗಳು ಎಂದರೆ ಸಹಿ. ನನಗೆ ತೋರಿಸುವ ದಾಖಲೆಗೂ ನಿಶಾನೆ P2 ಆಗಿದ್ದು, ಸಾಕ್ಷಿಯು ಗುರುತಿಸಿದ ಸಹಿಗಳನ್ನು ನಿಶಾನೆ P3 ಮತ್ತು ನಿಶಾನೆ P3D ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ P2 ಮೇಲಿರುವ ಎಲ್ಲಾ ಸಹಿಗಳನ್ನು ನಿಶಾನೆ P2A ಎಂದು PA ಎಂದು ಸಹಿಗಳನ್ನು ನನ್ನ ಹೆಂಡತಿ ಸಹಿಗಳನ್ನು ಎಂದರೆ ಸರಿ. ವಾದಿ 2 ಕರಾರು ಪತ್ರಗಳನ್ನು ಬರೆಸಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ಸ್ವತಃ ನುಡಿಯುತ್ತಾರೆ.
ಏನಿದು?
ದಟ್ ಈಸ್
ಇದು ಕೋರ್ಟ್ ವರ್ಷನ್ ಅವ್ರ ವರ್ಷ ಯಾರು? ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಇದೆ.
ಅವ್ರ ಕ್ವೆಶ್ಚನ್, ಅವ್ರ ಆನ್ಸರ್ ಇದು. ವಾದಿಯು 2 ಕರಾರು ಪತ್ರಗಳನ್ನು ಬರೆಸಿಕೊಂಡಿದ್ದಾರೆ ಎಂದು ಸ್ವತಃ ನುಡಿಯುತ್ತಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. He's saying
in his cross-examination.
He is volunteering to say that plaintiff claims that there is 2 agreement.
ಅರ್ಥದಲ್ಲಿ
52,50,000 ರೂಪಾಯಿಗಳಿಗೆ ಮಾಡಿರುವ ಕರಾರು ಪತ್ರಕ್ಕೆ ಮಾತ್ರ ಸಹಿ ಮಾಡಿರುತ್ತಾನೆ ಎಂದು ಮಾಡಿರುತ್ತೇನೆ ಎಂದು ಮುಂದೆ ಬರೆದು ನುಡಿಯುತ್ತಾರೆ.
ಈ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ he says like this ಅಂತ ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಇದೆ. ಅದನ್ನ ಅಟ್ ಲೀಸ್ಟ್ ಇದು ಕೋರ್ಟ್ ವರ್ಷನ್ ಇರ್ಬೇಕು. ದಟ್ ಮೀನ್ಸ್ he is saying that
ವಾಲಂಟರಿ ಅಂತ ಏನಾದ್ರು ಹೇಳ್ಬೋದಾಗಿತ್ತು.
either way effect will be same ಅನ್ನೋದು.
He is saying that I have signed it. ಇನ್ನೊಂದು ಕರಾರು ಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡಿದ್ದು ಅದನ್ನು ನಮಗೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಸಹಿ ಮಾಡಿದ್ದಾರೆ, ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ, ಅದು P2 ಆಗಿಬಿಡ್ತದೆ.
ಅಲ್ಲ, ಇನ್ನೊಂದು ಅಂದ್ರೆ ಎರಡನೇದು
P2
and P4.
ಅದು ಯಾಕೆ P2 ಆಗ್ತದೆ ಅಂದ್ರೆ, ಅಲ್ಲಿ ನೋಡಿ 52,500 ಇದೆಯಲ್ಲ, ಅದು ಅವ್ರು ಒಪ್ಪಿಟ್ಟಾರೆ ಈಗ ಅದನ್ನ. ಹಂಗಾಗಿ ಇದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ಇನ್ನೊಂದಕ್ಕೆ ಸಹಿ ಮಾಡಿಸ್ಕೊಂಡಾರೆ ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ
ಆಗಿರ್ಬೋದು.
ಪ್ರಿಸ್ಯೂಮೇಬಲಿ P2 ಆಗಬಹುದು.
ನನಗೆ ತೋರಿಸುವ ಮತ್ತೊಂದು ದಾಖಲೆಯ ಮೇಲೆ ನನ್ನ ಹಾಗೂ ನನ್ನ ಹೆಂಡತಿಯ ಸಹಿಗಳು ಇವೆ ಎಂದರೆ ಸರಿ.
ದಾಖಲೆ ಯಾವುದು?
ಸದರಿ ದಾಖಲೆಗಳನ್ನು ಈಗಾಗಲೇ ನಿಶಾನೆ P4 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. That is the second agreement.
Second agreement. Therefore, second ಸಹಿ ಮಾಡಿತ್ತು ಅದನ್ನು ನಮಗೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಸೆಕೆಂಡ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತನಾ?
ಅಲ್ಲ,
ಎಷ್ಟು ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಇದರಲ್ಲಿ.
52,50,000 ಇದ್ದಿದ್ದನ್ನ ನಾವು ಸಹಿ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಒಪ್ಕೊಂಡ್ಬಿಟ್ರು ಅವರು. ದಟ್ ಇಟ್
ಆಮೇಲೆ
ಸೆಕೆಂಡ್ ಅಂತ ನೀವು.
ಈ P4 ಅಂದ್ರೆ P4 ಇಸ್ ದ ಸೆಕೆಂಡ್ ಒನ್. ಅದನ್ನ ತೋರಿಸ್ತೀವಿ. ತೋರಿಸಿದ್ರೆ ಈ ತರ ಆನ್ಸರ್ ಮಾಡ್ತಾರೆ. ನನಗೆ ತೋರಿಸಿರುವ ಮತ್ತೊಂದು ದಾಖಲೆಯ ಮೇಲೆ ನನ್ನ ಹಾಗೂ ನನ್ನ ಹೆಂಡತಿಯ ಸಹಿಗಳು ಇವೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ದಾಖಲೆಗಳನ್ನು ಈಗಾಗಲೇ ನಿಶಾನೆ P4 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಸೊ ಡಾಕ್ಯುಮೆಂಟ್ ಕನ್ಫ್ರಂಟೆಡ್. ದೆನ್ ನಿಶಾನೆ P ರ ದಾಖಲೆಯನ್ನು ನಮಗೆ ತೋರಿಸಿಲ್ಲ,
ಸಹಿ ಮಾತ್ರ
ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ, ಮುಂದುವರೆದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ P4 ಕೂಡ ನಾನು ಸಹಿಯನ್ನು ಹಾಕಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ P2 ಮತ್ತು 4 ನಾನು ಸಾಕ್ಷಿದಾರನಾಗಿ ಸಹಿ ಮಾಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಯು ಗುರುತಿಸುವ ಸಹಿಗಳನ್ನು ನಿಶಾನೆ P2 ಸೋನ್ಸೋ ಮತ್ತು ಮೀ ಸೋನ್ಸೋ ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಬಿಕಾಸ್ ಹಿ ಇಸ್ ಹಸ್ಬೆಂಡ್ ಮೈ ಲಾರ್ಡ್, ಹೂ ಇಸ್ ಆಲ್ಸೋ ಎ ಟೆಸ್ಟಾರ್ ಅಂಡ್ ನೌ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಆಲ್ಸೋ.
ಏನ್ ಕಲ್ತಾರ ಅವ್ರಿಬ್ರು? ಎಜುಕೇಶನ್ ಏನು?
ಡಿಗ್ರಿ. ಅವರು ಐ ಆಮ್ ಗ್ರಾಜುಯೇಟ್ ಅಂತ ಏನೋ ಹೇಳಿದ್ದಾರೆ.
ಹೇಳಿದಾರ?
ಪೇಜ್ 163 ತಾವು ನೋಡಿದ್ರೆ ಮಧ್ಯದಲ್ಲಿ ನನ್ನ ಹೆಂಡತಿ 8ನೇ ತರಗತಿವರೆಗೆ ಓದಿರುತ್ತಾರೆ. ಅವರಿಗೆ ಇಂಗ್ಲಿಷ್ ಓದಲು ಬರುವುದಿಲ್ಲ, ಆದ್ರೆ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಸಹಿ ಮಾಡಲು ಮಾತ್ರ ಕಲಿತಿರುತ್ತಾರೆ. 163 ಮಧ್ಯದಲ್ಲಿ, ಪೇಜ್ ಮಧ್ಯದಲ್ಲಿ ಲೈನ್ ಮಧ್ಯದಲ್ಲಿ ಶುರು ಆಗುತ್ತೆ. ನನ್ನ ಹೆಂಡತಿ
ಡಿಗ್ರಿವರೆಗೆ ಓದಿರುತ್ತಾರೆ.
ಹೌದು. ಅವರಿಗೆ ಇಂಗ್ಲಿಷ್ ಓದಲು ಬರುವುದಿಲ್ಲ, ಆದ್ರೆ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಸಹಿ ಮಾಡಲು ಮಾತ್ರ ಕಲಿತಿರುತ್ತಾರೆ.
ಇವ್ರೇನು ಓದ್ತಾರೆ?
ಡಿಗ್ರಿ. ನನ್ನ ಹೆಂಡತಿ
ಅಲ್ಲ, ಅವರು ಹೆಂಡತಿ ಆತ, ಗಂಡ ಎಂಬುದೇ
ಗಂಡ. ಇವ್ರದ್ದು ಎಜುಕೇಶನ್ ಕ್ವಾಲಿಫಿಕೇಶನ್. I told my lord that he has said that he is a graduate. I'll chief ಹೇಳಿದಾರ. The trial court, my lord, accepts this evidence and comes to the conclusion that P2 is a genuine document, and the denial of the receipt of cash consideration is not believed, and the court accepts the contention that cash was given, and consequentially, my lord, denying specific relief to me, directs that that money should be refunded to them.
ಏನು ಟಾಕ್ಸ್ ಸಾಧ್ಯ ಇಲ್ಲನು? ಟಾಕ್ಸ್ ಏನ್ ಸಾಧ್ಯ ಇಲ್ಲ.
ಟಾಕ್ಸ್ ಇವಾಗ ಏನಾಗಿದೆ, ಬೆಲೆ ಅಂತರಿಕ್ಷಕ್ಕೆ ಹೋಗಿದೆ. ಅವರು the person who has bought it, my lord, owns a large extent of land behind this land. ಈ ಜಮೀನಲ್ಲಿ ಅವರು ರೋಡ್ ಬೇರೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. In spite of an interim order granted in the appeal, there's a contempt proceeding that was filed. ರೋಡ್ ಮಾಡಬಾರ್ದು, ಏನು ಮಾಡಬಾರ್ದು ಅಂತ ಅದಕ್ಕೆ ಉಲ್ಲಂಘನೆ ಮಾಡಿದ್ದಾರೆ. Commissioners appointed, then the registrar, my lord, went and inspected and found that the road is newly laid. Unless they are able to, my lord, give up that land to us. And the sale, my lord, is contrary. It was supposed to be sold to second defendant during the pendency of the suit, violating status quo order. There is a status quo order made, 15/305. On 26/11/05, they violate it and execute a sale deed in favor of second defendant, who was then subsequently impleaded.
ಅಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ಟು ರಿಸ್ಟ್ರೇನ್ ಟು ಎಲಿನೇಷನ್ ಇಲ್ಲ.
ಸ್ಟೇಟಸ್
ಇದೆ.
ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಸ್ಟೇಟಸ್ ಕೋ ಅಂದ್ರೆ ಅದನ್ನು ಮಾಡಬಾರ್ದು ಅಂತ ಆಗ್ತದೆ.
ಹೌದು. ಸ್ಟೇಟಸ್ ಕೋ ಇಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಟೈಟಲ್, ರಿಗಾರ್ಡಿಂಗ್ ಪೊಸೆಷನ್, ರಿಗಾರ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್. ಯಥಾಸ್ಥಿತಿ ಹೆಂಗಿದೆಯೋ ಹಂಗೆ ಅಂತ. ಇಫ್ ಎ ಇಸ್ ದ ಓನರ್, ಬಿ ಬಿಕಮ್ಸ್ ಓನರ್, ಯಥಾಸ್ಥಿತಿ ಆಗಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. That's one aspect, my lord. I'm not saying that that is the only aspect, but that is one aspect which bears, my lord, consideration. And innondu, my lord, they enter into an agreement. She purports to enter into an agreement with one E. Krishnappa. ಅದು ಯಾವಾಗ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ತಾರೆ, ಎಷ್ಟು ಕನ್ಸಿಡರೇಷನ್ ಮಾಡ್ತಾರೆ, ಆಲ್ ದಟ್ ಇನ್ ದ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದ ಸೂಟ್. ಅದೇನು ನಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್. Then E. Krishnappa joins in the sale deed executed by her in favor of second defendant as a confirming party.
In that it is reflected.
There is a reference to it. Agreement madidvi anta. The main bone of contention, my lord, is this. None of these things are much of controversy. The main controversy is, ಅವ್ರು ಹೇಳೋ ಪ್ರಕಾರ, I did not have money, readiness and willingness. ಅದಕ್ಕೆ there is evidence. I'll point out that there is enough evidence to show that. Divorce this transaction, there was some other transaction between the parties for which a check had been given by me to them. That was a check of a different number. So they present that check, and that check is dishonored. So the court comes to the conclusion that the check which you gave for this transaction is dishonored.
It's not this transaction.
This is not this transaction. Pleading alli adar ಬಗ್ಗೆ ಏನು ಇಲ್ಲ. Then, my lord, they tried to introduce it by an amendment. That amendment was contested. The lower court, my lord, rejected that amendment. It comes to this honorable court. That order is sustained. Then the matter, my lord, was disposed of by the lower court initially. It comes up in appeal.
Now, whether court upheld it subject to, because
No, it was not upheld. An ex parte decree was passed. Writ petition was presented. There was a notice was ordered. By the time it could come up again, the ex parte decree was passed. Therefore, the court said it is infructuous. The writ has become infructuous. Ex parte decree was set aside, matter was sent back.
ಅವಾಗ ರಿವೈವ್ ಮಾಡಿಕೊಳ್ಳಿಲ್ಲ.
ಆವಾಗ ನಾವು we filed application for revival in the writ petition. The court said that's a matter you should agitate in your appeal, and this thing, it's not, the writ petition is already disposed. Therefore, we have filed a cross appeal which is before the court.
But no application is filed even till today to amend their written statement. My lord, they can amend, they sought amendment.
ಅಲ್ಲ ಅದು ರಿಜೆಕ್ಟ್ ಆದಾಗ ಹೆಂಗ ಅಮೆಂಡ್?
ಅಲ್ಲ, ರಿಮ್ಯಾಂಡ್ ಆಗಿ ಯು ಕ್ಯಾನ್ ಎಜಿಟೇಟ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಹಾಕ್ಬೋದಾಗಿತ್ತು, ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಹಂಗ ರಿಪೋರ್ಟ್ ಆರ್ಡರ್ ತೋರಿಸಿ. ಬಿಕಾಸ್ ಅಂಡರ್ ಆರ್ಡರ್ 43 ರೂಲ್ 1 capital A of CPC as amended, read with 103 no 104, I don't remember. It is not an appealable order.
No, that's why the writ petition was filed.
ಆವಾಗ ರಿಟ್ ಪಿಟಿಷನ್ ಅನ್ನು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೋಲ್ಡ್ ಮಾಡಿ, ಇಲ್ಲ ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ರಿಜೆಕ್ಟ್ ಆಯ್ದು ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರೆ ಒಂದು ಆಸ್ಪೆಕ್ಟ್. ಇಟ್ ಅಟೈನ್ಸ್ ಫೈನಾಲಿಟಿ. ಪಾಟೀಲ್ ವರ್ಸಸ್ ಪಾಟೀಲ್ ಕಮ್ಸ್, ರೆಸ್ ಜುಡಿಕೇಟ್ ಆಪರೇಟ್ಸ್. ಇಫ್ no order is passed on merits and matter is simply disposed of, then in the event decree suffered by him, he can make it one of the grounds to attack the decree, is what the apex court has said.
He can make it a ground.
Provided it went against him.
No, what I'm saying is, Lord, today, if this honorable court has to now decide which is this check, for
everything
which,
will be clear.
for which transaction it was given, there is no pleading.
No, you gave the check.
No, you know, if he had raised that plea to say that the check number given in the agreement is different from the check number which we have referred to in the plea, because our defense al heltare yav check number anta, reply to legal notice al check number heltare.
Correct.
Now they want to go back from that to say a tappu.
Understood. If check is, you have given the check.
Yeah.
So 106 or 7, I do not remember, Evidence Act It is a matter especially within your knowledge.
Yes, my case is that that is not the check given for this transaction, which is corroborated by their stand.
In the pleadings.
They also
In the
say,
evidence.
evidence ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಮತ್ತ legal notice ಅಲ್ಲೂ ಹೇಳ್ತಾರೆ. Termination.
ಅದ್ರ ಮೇಲೆ issue frame ಮಾಡಿರ್ಲಿಲ್ಲನು?
ಅದೇ ಯಾಕೆ issue ಯಾಕೆ ಫ್ರೇಮ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ there was no such plea before the court.
Okay. Only in evidence it all came out ಅಂತ.
If they wanted to raise a plea, my lord, it is well settled that even in an appeal, you can seek leave of the court to amend your plea.
That's right.
ಅದ್ ಮಾಡಿಲ್ಲ. ಒಂದೊಂದ್ಸತಿ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನೋ ತಪ್ಪಾಗಿರುತ್ತೆ, ನಾವು ಅಪೀಲ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇರೋ ನೋಟಿಸ್, ದೆನ್ ವಿ ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಪರ್ಮಿಟ್ ಮಿ ಟು ಕರೆಕ್ಟ್ ದ ಪ್ಲೇಂಟ್ ಅಂತ. ಅದು ಇಲ್ಲ, ದಟ್ ಇಸ್ ನಾಟ್ ಹ್ಯಾಪನ್.
ನೀವು ಆ ಚೆಕ್ ಅನ್ನ ನಾನು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ, ಆ ಚೆಕ್ ಅನ್ನ ಯಾಕೆ ಕೊಟ್ಟಿದ್ರಿ ಅವ್ರಿಗೆ ಕೃಷ್ಣಪ್ಪ?
ಅದು my lord, that was relating to certain other transactions that were entered into. Since they did not plead anything, there was no burden on me to explain anything. Check number ಹಾಕಿದ್ದಾರೆ, ಹಾಕಿ ಡಿಸಾನರ್ ಆಗಿದೆ. And there is also endorsements on the check. All that evidence, if it is seen, and one more aspect, my lord, is that on the date on which this payment was to be made, I have produced a bank statement to show that I had 41.5 lakh rupees credit in that account. I had to pay 50 lakhs.
ಅದು ರೆಡಿನೆಸ್ ಸಿಗಾಯ್ತು,
ಎಲ್ಲ ಇದೆ.
ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಸಿಗಲ್ಲ.
ಅಲ್ಲ, ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಗೆ ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಏನಂದ್ರೆ, ದಿ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರೊವೈಡೆಡ್ that they will take all steps to get this land converted. I'm a company, so the old regime under 79AB was there. So there is a specific provision to say they will get it converted, and after that only sell. That conversion never took place. Conversion takes place after they terminate my agreement, and they find a new suitor who is E. Krishnappa, and then they get it converted. And then they sell it to this second defendant.
ನಿಮ್ಮ ಇದರಲ್ಲಿ ಕಂಡೀಷನ್ ಅಲ್ಲಿ ಕನ್ವರ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕೊಡಬೇಕು ಅಂತ ಏನಾರ
ಇದೆ.
ಇದೆಯಾ?
ಇದೆ, ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲೇ ಇದೆ. P2 may be seen. There are two documents which will show that.
P2, P4 ಒಂದ್ಸರಿ ನೋಡೋಣ.
P2, page 209. At 214. Para 3. We read para 3.
So non-conversion ಮಾಡ್ಕೋಬೇಕು, so that the restriction would not apply.
And one more portion is last portion of para 3. They have to do three things. One is
IT Act ಕೆಳಗಡೆ ಇರುವಂತ ರಿಕ್ವೈರ್ಮೆಂಟ್.
ಒಂದು IT Act. IT Act ಅಲ್ಲಿ ಎರಡು ಪ್ರಾವಿಷನ್. Yesterday, my lord, I made a submission. This chapter 20C is that form 37I. That is preemptive purchase ಮಾಡಕ್ಕೆ. Both sides have to give an agreement. And if revenue wants, they'll buy it at that price. If they don't want, then they'll approve. Say, we are not interested. Then you are permitted to sell. The other one is 230A, which is you have to go to your income tax officer, not to appropriate authority. And you have to convince him that ಈ ಪ್ರಾಪರ್ಟಿ ನಂದು, ನಾನು ಮಾರ್ತಾ ಇದ್ದೀನಿ, ನೀವು no objection ಕೊಡಿ ಅಂತ. They have to give that form.
No objection ಕೊಡಬೇಕು.
ಹೌದು. Once they give that is the obligation of the vendor. Because supposing is some benami property ಇದೆ, record ಅಲ್ಲೇ ಇಲ್ಲ, document is nowhere shown that is property belonging to him. So this is like a check. Those two things plus conversion, all the three are narrated here. Within a period of 7 days from the date of receipt of no objection under chapter 20C and certificate under 230A and order of conversion under 95, whichever is later.
P4 ನಲ್ಲಿ ಏನಿದೆ? P4.
P4 ಅಲ್ಲೂ P4 ಅಲ್ಲೂ same thing. No change at all, except that consideration change. P4 is at page 253. No. 239. No? Typed version, my lord, is at 239. For completeness, my lord, they've also filed the photostat copy because sometimes court may want to see it. The original, of course, is there. The Xerox version is at 253. So verbatim the same, except consideration.
ನೋಟ್ರೈಸ್ ಆಗಿದೆ ಏನದು?
Notarize ಇಲ್ಲ. Attestation by witnesses. Two witnesses have attested.
Condition ಎಲ್ಲಿದೆ page number?
If your lordships are having
Para 3, 2, 3, 5, 6.
ಅದೇ ಅಲ್ಲ ತಾವು if you are
256 ಅಲ್ವಾ?
256 ಅಲ್ಲಿ that is a Xerox version.
Xerox version.
Para 3 ತಾವು ನೋಡಿದ್ರೆ and compare
duplication. Duplication of that condition.
Exactly the same, verbatim. The only change we find is if your lordships should compare page 226 and 256. A consideration amounts matra change ಆಗುತ್ತೆ. ಅಲ್ಲಿ total consideration 7480 ಅಂತಾರೆ, ಇಲ್ಲಿ 5250 ಅಂತ.
ಅಲ್ಲ, kindly see 256 ನಲ್ಲಿ
Yes.
paragraph 1 ನಲ್ಲಿ ಚೆಕ್ ರೆಫರ್ ಆಗಿದೆಯಲ್ಲ?
Yes.
ಇದು 2 lakh ಆರ್ಡರ್ ನೀವೇನ್ ಹೇಳಿದ್ರಲ್ಲ ಆ ಚೆಕ್
ಇದಕ್ಕೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
This is it.
2,70,000.
They have encashed that.
Encashed, no dispute at all.
Under the second agreement itself.
Yeah.
First agreement ನಲ್ಲಿ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ.
Same thing. ಒಂದೇ ಒಂದು 955 ಚೆಕ್ ನಂಬರ್ ಇದೆ. ಪೇಜ್ 2.
ಅದು ಡಿಸೈನರ್ ಆ ಚೆಕ್ ನಂಬರ್ ಏನು?
ರಿಟರ್ನ್ ಆಗಿದ್ದ ಚೆಕ್. Your lordships will get that document. It's produced as D3 is page 322.
Exhibit D4 is a bank ಇದು ಅನ್ನೋದು.
D3 is a copy.
D4.
D3 is a copy of the check. ಅಲ್ಲಿ on top, that photocopy is there. ಅದ್ರ ಕೆಳಗಡೆ your lordships will get the number 786491.
You are right. ಅಲ್ಲೇನು 2 ನಂಬರ್ ಇರ್ತದಲ್ಲ ಮಿಸ್ಟರ್ ನಾಗಾನಂದ, ಈ ಕಡೆ
ಲೆಫ್ಟ್ ಸೈಡ್ ಲೆಫ್ಟ್ ಇರೋದು ಸೀರಿಯಲ್ ನಂಬರ್ ಆಫ್ ದ ಚೆಕ್, ರೈಟ್ ಇರೋದು that is the identity of the bank issuing it.
Okay.
IFSC ಕೋಡ್ ಅಂತ ಬರುತ್ತೆ.
Okay. ಆ ನಂಬರ್ ಆಯ್ತು.
5600240161 ಅಂದ್ರೆ ಆ ಬ್ರಾಂಚ್ ಐಡೆಂಟಿಫಿಕೇಶನ್.
Okay.
The left side number is the serial number.
ಅಲ್ಲ, ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಇನ್ನೊಂದು ನಂಬರ್ ಇದೆ.
ಅದು ಸೀಲ್ ಹಾಕಿರೋದಾ 6634 ಅಂತನಾ?
ಅಲ್ಲ, 0298.
ಎಕ್ಸ್ಟ್ರೀಮ್ ರೈಟ್ ಅಲ್ಲಿ ಇರೋದು
ಅದೇನದು?
This must be some form of identification of for the bank as to which area zone this relates to.
This is 29,80,000.
29,80,000.
How, whether this figure matches with the amount of price in the first P2?
No.
Second P4?
This check, my lord, was never a part of the agreement. It was not a document which was given. My lord, your lordships may now see, my lord, one more document will be clear. Page 234 may now be seen.
234.
234. The Xerox version is at page 237. 237. What happened, my lord, was after the agreement was signed, they could not get all the permissions. So parties agreed to extend the time and consideration was increased by
P3.
P3. At page 237 is the...
Is disputed or admitted?
This is admitted. No dispute on this.
ಅಲ್ಲಿ ಚೆಕ್ ನಂಬರ್ ಇದೆ ಅಂತನಾ?
ಅಲ್ಲಿದೆ. Your Lordship, please see, the date now is 25th December 2003. ಅಷ್ಟೊತ್ತಿಗೆ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿ 1.5 ವರ್ಷ ಆಗಿರುತ್ತೆ. 2.5 years. Because agreement was February 2001. This endorsement is December 2003. So nearly 2 years and 10 months or so are over. In this interregnum, they have not been able to obtain conversion. They have not been able to give 230A certificate. They have not been able to obtain Form 37I under Chapter 20C. Our stage discussion ನಡೆಯುತ್ತೆ. And this endorsement is now entered. Please see what it says now, my lord. The conversion of the scheduled property to non-agricultural use is not yet completed. The parties have not been able to complete the sale deed in favor of the purchaser. Parties, after mutual discussion, have agreed to extend the time for completion of the sale deed, transferring the scheduled property in favor of the purchaser. In view of the delay in
P3, Mr. Patil, admit ಆಗಿದೆ ಏನಿದು P3?
Exhibit P3 is
admitted. ಮತ್ತೆ ಅಡಿಷನಲ್ 5 lakhs ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳದಿದ್ರೆ ನೀವ್ ಯಾಕೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ರಿ?
ಅವ್ರು ಕೇಳಿದ್ರು ಅಂಡ್
ಅಲ್ಲಿ C2 ಕ್ಲಾಸ್ 8 ಓದ್ಲಿಲ್ಲ. ಆ ಕ್ಲಾಸ್ 8 ಓದಿದ್ರೆ ಯಾಕೆ ಕೊಟ್ರು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. P2 the clause 8.
Page
231.
ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೇಜ್ 231 ನಲ್ಲಿ ಸಿಗುತ್ತೆ.
The vendor hand over all the original documents of title relating to the purchase property and grant a power of
attorney in favor of the purchaser or their nominees, authorizing them to apply for conversion of the land and to do all acts necessary in that regard before appropriate authorities on receipt of the second installment of 34,80,000.
ಹಂಗಾಗಿ
ಸೆಕೆಂಡ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ ಅವ್ರು ಕೊಡೋದಕ್ಕೆ ರೆಡಿ ಇದ್ರಂತೆ. ಈ ವೆಂಡರ್ಸು 2 ವರ್ಷ ಎಬ್ಸ್ಕಾಂಡ್ ಆಗ್ಬಿಟ್ಟಿದ್ರಂತೆ. ಅದಕ್ಕಾಗಿ ಅವರಿಗೆ ಕೊಡೋದಕ್ಕಾಗ್ಲಿಲ್ಲ.
Lord, this clause 8 if you read clause 8, my lord, it has 2 portions. One, the vendor has handed over documents and grant a power of attorney in favor of purchaser or their nominees, authorizing them to apply for conversion and do all necessary acts in that regard. Then, before the appropriate authorities, on receipt of second installment of 34.80, as stipulated in clause 2 above. 2.2 nalli, that is at not page 226.
ಇದೇನು ಆನ್ ರಿಸೀಟ್ ಅಂದ್ರೆ ಇಸ್ಕೊಂಡೇವಿ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಏನಿದೆ, ಹೆಂಗ್ ಏನು ತಿಳಿತಾ ಇಲ್ಲ. ಅದು ಕೊಟ್ರೆ
ಎರಡನೇದ್ರದ್ದು ಆನ್ ರಿಸೀಟ್ ಆಫ್ ದಟ್ ಅಮೌಂಟ್ 2.2 ಆ ಅಮೌಂಟ್ ನ ಇಂಥ ತಾರೀಕಿಗೆ ಕೊಡ್ತೇವೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದನ್ನೆಲ್ಲಿ ಹೇಳಿದ್ರು ಅವರು?
ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ 226 ಕ್ಲಾಸ್ 2.
26.
The consideration amount shall be paid by the purchaser to the vendor as under a sum of 22,30,000 by cash. B, a sum of 2,70,000 is paid by check dated so and so on Bangalore. the receipt of which total sum of 25 lakhs as advance, the vendor hereby adjusts and acknowledges. Then Roman 2, a sum of 34 lakh 80,000
ಅದು ರಿಲೇಟಿವ್
on or before 5/3/2001.
ಅದು ಕ್ಲಾಸ್ 80 ರಿಲೇಟಿವ್.
ಹೌದು, ಕ್ಲಾಸ್ 80 ರಿಲೇಟ್ ಆಗಿರೋದು. ಆನ್ ಆರ್ ಬಿಫೋರ್ 5/3/2001 34 lakh 80,000 ಕೊಡಬೇಕಿತ್ತು.
ಹಂಗಲ್ಲ, ಕನ್ವರ್ಷನ್ ಆದರೆ not, we can't read one clause like that, my lord.
ಅಲ್ಲ, that's all right. Whole everything has to be read is one thing.
Yes.
ಬಟ್ ಕನ್ವರ್ಷನ್ ಆದ್ರೆ ಅನ್ಲಿಕ್ಕೆ ನಿಮ್ಗ ಪವರ್ ಕೊಟ್ಬಿಟ್ಟಾರ ಅವ್ರು ಕನ್ವರ್ಷನ್.
ಅದಲ್ಲ, ಅದ್ ಯಾವಾಗ? ಪ್ಲೀಸ್ ಸಿ ನಾವು 227 my lord. 220 my lord, the question of
on the obtaining of the above,
yes,
the vendor shall intimate the purchaser of the same in writing and also furnish a copy of the certificate so and so so and so.
ಇಲ್ಲಿ at page 227 ಅಲ್ಲಿ this all relates to time frames, my lord.
There are 3.
My lord, may I just, my lord, take your lordships through the time frames that they're talking about. At page 225, my lord. Clause number 1. Now this agreement anta shuru agutte. Vendor agrees to sell the land bearing survey number so and so, and purchaser agrees to purchase the same for total consideration. Consideration amount shall be paid by the purchaser as under. Then A, B, 3 and 4.
Then 74 lakh 80,000 ಆಗಿದೆಯಲ್ಲ.
ಅದೇ ಟೋಟಲ್ 7480.
ಆ 5250 ಸೇರ್ಕೊಂಡ.
ಅಲ್ಲ, ಇದು ಫಸ್ಟ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ 7480 ಅಂತ ಹೇಳ್ತಾರೆ. ಆ 22,30,30,000 ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಟ್ಟ ನಂತರ ವಾಟ್ ರಿಮೈನ್ಸ್ ಈಸ್ ರಿಫ್ಲೆಕ್ಟೆಡ್ ಇನ್ P4 52.5.
ಆ ರೀತಿ ಮಾಡಿದ್ರ.
ಕ್ಯಾಶ್ ಕಾಂಪೊನೆಂಟ್ ಏನ್ ಕೊಟ್ಟಾಯ್ತಲ್ಲ
25 ಕೊಟ್ಟಾಯ್ತು.
ಅಲ್ಲ 25 ಅಲ್ಲ,
ಹೌದು 22 330 plus 2.7.
yes my lord, 25
ಆಗತ್ತೆ.
ಕ್ಯಾಶ್ ಕಾಂಪೊನೆಂಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ 22.30. if you deduct 22.3 from 74.8, then we come to 52.5.
2.70 ಚೆಕ್ ಕೊಟ್ಟು ಅದು ಎನ್ಕ್ಯಾಶ್ ಆಗಿತ್ತು.
ಅದಾಗಿದೆ, ಅದು ಇದ್ರಲ್ಲಿ ಬರುತ್ತೆ.
ಅದು ಎರಡರಲ್ಲೂ ಬರ್ದಿದ್ದಾರೆ.
ಎರಡರಲ್ಲೂ ಬರ್ತಾರೆ.
ಹಂಗಾಗಿ ಅದು that goes common.
ಕ್ಯಾಶ್ ಮಾತ್ರ ಬಿಟ್ರು. ಸೊ my lord, ಈ ಕ್ಲಾಸ್ ನಂಬರ್ 1 ನಲ್ಲಿ
for a total consideration so and so,
then
how amount should be paid? 2.
Correct. First payment of 2230 cash, they say paid now ಅಂತ ಹೇಳ್ತಾರೆ. 2,70,000 paid ಚೆಕ್ ಅಲ್ಲಿ. ದೆನ್ ಅಂದ್ರೆ 25 ಲಕ್ಷ ಅವ್ರಿಗೆ ಮುಟ್ಟಿದೆ ಔಟ್ ಆಫ್ 74.8. Then 3480 should be paid before 5/3/2001. The issue between us now, ಅವ್ರು ಹೇಳೋದು ನೀವು ಏನೇ ಆದ್ರೂ without linking it to any condition, you should have given me this
ಪೇಮೆಂಟ್ ಮಾಡಿಬಿಡ್ಬೇಕು ನೀವು
5/3/21 ಅಲ್ಲಿ ಅಂತ.
ನೀವು ಅನ್ನೋದು ಇದನ್ನ this should be read along with 3 ಅಂತ ನಿಮ್ ಕಂಟೆಂಟ್.
Exactly. Because ಅಲ್ಲಿ ಟೈಮ್ ಫ್ರೇಮ್ ಹಾಕಿದ್ದಾರೆ. If there's no time frame in 3, it would have been read differently. 3 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? The sale deed shall be executed within 60 days from the date of execution, or within a period of 7 days from the date of receipt of the no objection certificate. And within a period of 7 days from the date of receipt of no objection certificate under chapter 20C and certificate under 230A of Income Tax Act and order of conversion to non-agricultural use under 95 of the Land Revenue Act, whichever is later. On obtaining the above, vendor shall intimate the purchaser of the same in writing and also furnish a copy of the certificate. So
ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಎಲ್ಲಿದೆ? ಎರಡಕ್ಕೂ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇಲ್ಲ. They can coexist.
No, what I am submitting, my lord, is this, that if you read this agreement as a whole, this time limit that is stipulated in 3 has to be read and given some meaning. So it doesn't mean that I have to give this money even before. And how the parties understood it in the same way as evidenced by P3. P3, your lordships may now see how they look at it.
Let us see this one. I'm just applying my minimum exposure to interpretation of document by Oger and by Bindra. Whether Bindra says If two clauses in a conveyance can exist together, operate together, they should be interpreted that way.
Yeah.
If they cannot coexist, then synthesis has to happen.
Yeah.
Now let us see.
Yeah.
From that way.
Yes.
Simple. Wren and Martin. 34,80,000 payment.
Yes.
For this, the cutoff date is 5/3/2001.
Yes.
This is not conditional. Number one. Going by literal interpretation.
Yes. Yes, no.
3 speaks of conditions for execution and registration of the sale deed.
Yes.
Payment of 34 lakh odd has nothing to do with the cutoff date and conditions which are sine qua non for execution and registration of sale deeds. Veendra, volume 2.
My lord, my submission is that on a proper reading of this document, that could never be the intention of the parties. For this reason, my lord, you cannot forget, my lord, that this preemptive purchase was there. That preemptive purchase is noted, my lord, in the agreement itself at clause number
Chapter XXC.
Adunna idral refer ಮಾಡಿ
30 capital A.
Yes. Your lordships will get that. At page 227, clause 4.
Clause 3 also.
Clause 3 ನಲ್ಲಿ permission ಬರೋದು, 4 ಅಲ್ಲಿ application ಹಾಕೋದು. Statement we have to
file necessary statement.
Yes.
37I. Under the IT Act.
So, my lord, immediately on the signing of this agreement, along with Form 37I, parties had to file it before the appropriate authority. Then they had to get 230A. Now, without, and your lordships, if you compare against the total agreed consideration, Lord, the full price is paid when the property is ready to be transferred. In this case, without any of those things happening, if you read this clause 2 as an independent provision, then out of 75 lakhs of rupees, my client would have had to pay 60 lakhs without any statutory compliances.
Out of 75.
7480 ಅಲ್ಲಿ registration time ಅಲ್ಲಿ ಉಳಿದಿದ್ದು ಬಾಕಿ 15 ಲಕ್ಷ ಅಷ್ಟೇ. So the interpretation of the other side is you had to pay me nearly 85% or so of the entire price without anything happening which is legally required. So my submission is that is not the intention. ಇದೆಲ್ಲ ಮಾಡಬೇಕು. ನೀವು ಒಂದು ಸ್ಟೆಪ್ ಮುಂದೆ ತಗೊಂಡ್ರೆ ನಾವು ಒಂದು ಸ್ಟೆಪ್ ಮುಂದೆ ಬರಬೇಕು. Reciprocal promises. Why did they not file Form 37I? If so, when did they file? 230A is their obligation, because the minute, my lord, this goes to a public authority, then there is a safety also. The minute they file 37I, then the law required that no transfer shall be done until they decide that.
That condition.
Yes.
It's the statutory part.
Yes.
ಯಾವ section ಅದು?
So 269
ಕೊಡಿ. As it then was.
Yes. 269 UC ಅಂತ ಕಾಣುತ್ತೆ.
Notwithstanding anything contained in the Transfer of Property Act, any other law for the time period. No transfer of any immovable property in such way exceeding so and so shall be effected, except after an agreement for transfer is entered into between the person who intends transferring the immovable property of the transferor and the person to whom it is proposed to be hereafter transferee in accordance with the provisions of at least 4 months before the intended date of transfer.
So if we had, supposing one day after this agreement, they had filed this form,
4 months, they cannot do anything.
nothing can be done. So if you read the agreement in the manner they are saying, ಏನಾದ್ರೂ ಹಾಕೊಂಡು ಹೋಗ್ಲಿ ನಂಗೆ ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ, ಕನ್ವರ್ಷನ್ ಆದ್ರೂ ಆಯ್ತು ಆಗದೆ ಇದ್ರೂ ಆಯ್ತು. And if conversion doesn't happen at all, then I cannot purchase at all because I'm a company.
But that power to apply for conversion is delegated to you only.
No, my lord, kindly my lord see now 230,
your
what they say in the agreement, page 230, clause number 11. The vendor undertakes to apply for conversion of the scheduled property for non-agricultural commercial use immediately after the execution of the agreement and to take all steps to expeditiously get such conversion. All expenses including conversion fine, betterment charges legally payable if any in this regard shall be paid by the purchaser to the authorities or if so paid by the vendor shall be reimbursed by the purchaser. And purchaser shall assist.
Now read it.
Now, my lord, if they had applied, they must apply. And for that purpose of application, if he gives me power of attorney, I can apply also. But this clause, there was a requirement, a promise, a reciprocal promise, that's what I'm saying, from his side, with agreement signed, Takshna I will make application for this. Law requires me immediately to file Form 37I. We will do that. Then we will apply for 230A. 230A is nanen madostilla or vendor madಬೇಕು. Kindly see section 230 capital A. Income Tax Act. It's now not on the statute book, but the relevant time.
Page number ಏನು ನಿಮ್ದು?
ಇದು I have not 24 edition. No?
ಇದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಕ್ಟ್ ಅಂದ್ರೆ
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್
ಹೋದಂಗೆ
ಹೌದೌದು
ದಾರಿ ತಪ್ಪಿ ಗೊಂಡಾರಣ್ಯ ಇವ್ ಗೊತ್ತೇ ಆಗಲ್ಲ ಯಾವ ಸೆಕ್ಷನ್ ಹುಡ್ಕಕ್ಕಾಗಲ್ಲ
ಇದರಲ್ಲಿ ಸೆಕ್ಷನ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಆಗಿಲ್ಲ. It was deleted in
and many a times they refer it as Finance Act of 21, Finance Act of 24
to confuse it, to confound the confusion.
ತಮ್ಮ ಪುಸ್ತಕದಲ್ಲೂ ಅದು ಇಲ್ಲದೆ ಇರಬಹುದು because ಅದು 2001 it was omitted.
ಅದಕ್ಕಿಂತ ಇದು 16/2001
ಈ agreements are all before that.
2001 ಇರೋದಕ್ಕೆ ಅದು ಅಪ್ಲೈ
ಆಗತ್ತೆ
17 February.
Yes. ಸೊ ಅವರು ಈ 3 ತಿಂಗಳಲ್ಲಿ ದುಡ್ಡು ಕೊಡ್ಬೇಕು.
Omitted ಅನ್ನೋ ಶಿರ್ವಾಯಿ is of opinion. Even omitted clauses of statute should be reprinted there.
What they normally do, footnote ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ. As prior to amendment it was like this ಅಂತ ಹಾಕ್ತಾರೆ, but ತುಂಬಾ ಹಳೇದಾಯ್ತಲ್ಲ ಅಂತ I think they will let it out now. It's now 24 years.
That's what. The Finance Act 2001.
So February agreement ಆಗುತ್ತೆ, ಅವರು 230 ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
ಆ ಸೆಕ್ಷನ್ ಏನಂತ ಇದೆ?
230A simply said that no registration of any document relating to transfer of movable property where the property value is above certain notified amount will be registered unless the registering authority gives the income tax authority gives a no objection certificate. I'll make available that section.
Section.
ಈ ಪುಸ್ತಕದಲ್ಲಿ ಇಲ್ಲ, I'll make available.
Anyway, you have one advantage over persons like me.
ಇಲ್ಲ.
Do not like my brother. Is that you come from chartered accountant, as a chartered accountant also, perhaps.
ಹಳೆ ಅವತಾರ ಮರ್ತೋಗ್ತಾ ಇದೀವಿ.
ಅದು ಒಪ್ಪಕ್ಕಾಗಲ್ಲ, ನೀವು ಏನು ಮರೆಯಲ್ಲ ನೀವು. ನೀವು ಬಂದಾಗೆಲ್ಲ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಟೆನ್ಷನ್.
There was a book ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ some tax matter was being argued and one of the advocate on either of the side made some interjection and some comment. Then the court said, you are facing an advocate who is initially chartered accountant and then has become advocate. Therefore, don't do it.
You are also like that only. Maybe you are less of that in other branches of law, but you are more of that in cooperative matters. Whenever you appear in cooperative matters, we always we will put the judges to go back in their chair. Yes.
So not on a taking note of the legal position and the requirements of law. When parties said takshana id madbeku, next id madbeku, and law requires you to do it, and within this time, and the sale is also linked to it, substantial part of the consideration is paid. Except not this 34.
Contemporaneous expositio ಇದೆಯಲ್ಲ, ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ಸಿಗೂ ಅಪ್ಲೈ ಮಾಡಬೇಕು ಅನ್ನೋದೇನಾರ ಇದೆಯಾ?
Reciprocal promises, and I would put it like this, Manoj. I would say that when an agreement consists of several covenants, one from the other, I say
conflict with each other.
They not conflict agalla. What will happen is, Manoj, that you have to follow the sequence. Manoj, I say I want to buy 100 kgs, 100 bags of rice. The seller says, ನಾನು ಇವಾಗ ತಾನೇ ನೆಟ್ಟಿದ್ದೀನಿ, ಅದನ್ನೆಲ್ಲ ನಾನು ನೋಡ್ಕೊಳ್ತೀನಿ ಅಂತ. Then he says, you give me all the money for fertilizer and labor. Then I say, okay, I'll give you that. So ಈ ತರ reciprocal promises ಇದ್ರೆ, in this case, agreement is signed, advance is given. First covenant from them is he has to take his step. He has to apply for this clearance. He has to get application for conversion. Then both of us have to apply under Form 37I for clearance under Chapter 20. Thereafter, one by one, that permission will come. Once that happens, then this further payment, because otherwise, Manoj, it sounds a bit odd that in an agreement of this kind, when land is not freely saleable, it is agricultural, buyer is a company, parties contemplated conversion and sale, and there is some cash component of it also. And they have paid, Manoj, more than 70% of the price at that stage. This last covenant is not something which we can read divorced other provisions, is my submission. After all, not every agreement will have to be read as a whole. The sense of the parties will not let be gathered from it. Now please see, Manoj.
ಈ rule of last antecedent apply ಆಗಲ್ಲ, no?
ಅದು in wills, the rule, Manoj, is interpretation of a document alli, will alli last covenant will prevail over the earlier. In contracts, earlier will prevail over later.
Exactly reverse.
Anta atara ide. This is very old propositions, Manoj. I don't know to what extent and what is the logic behind them also. But one proposition is very clear, that when interpreting any document, you have to read it as a whole. And we have to step into the shoes of the person who made it to see what is it that parties intended. But if there is some evidence which shows what it intended, it becomes very clear, my lord, in 2003, 2 years later, when they signed the endorsement. My lord, we have to now see, today it suits them to say, you didn't give this money on this day, therefore you committed breach. But how did they look at it at that time? How did they look at it after that time? That is evidenced, my lord, by the endorsement, which is P3 at page 237. This is coming nearly 1 year, 2 years and several months after that. Now, if the understanding was, naan nimage power of attorney kodbididini, nan hane bara mugitu, you go and do whatever you want. Andidre, in 2003, the vendor would have said, why are you troubling me with all these things? I've given you whatever power attorney. You do your business, you should have gone and done what you wanted. Why you didn't do? ಇವಾಗ ನಾನು ಯಾಕೆ ತಲೆ ತಿಂತಾ ಇದ್ದೀರಾ? He could have said it, she could have said it, but adilla. This evidence is what happened in 2003 December. The conversion schedule property to non-agricultural is not yet completed. Parties have not been able to complete the sale deed in favor of the purchaser. They are still willing, but not yet done. Parties, after mutual discussion, have agreed to extend the time for completion of sale deed transferring scheduled property in favor of purchaser. In view of the delay in completion of sale, purchaser agreed to pay additional sum of 5 lakhs. The purchaser has this day handed over the following checks for rupees 54,80,000 in full payment of the sale price of scheduled property.
cash agideno?
That is where the mischief arises. This check 342, there is no evidence of it being dishonored. This check is not produced. The check is not presented. The check is not dishonored. ಅದಕ್ಕೆ ತಮ್ಗೆ ಅವತ್ತು I showed.
Check is not dishonored. Of course, that concept also is relevant. It may not be presented at all.
It's not presented. No evidence of presentation.
So it will be a valid tender ಆದಂಗ ಆಗ್ತದೆ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್.
ಅದೇನೆ ಈ ಚೆಕ್ ನ ಎಲ್ಲಾ ಕಡೆ ಇದೇ ಚೆಕ್ ನಂಬರ್ ಹೇಳ್ತಾರೆ, ಬಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡೋಕ್ ಮಾತ್ರ ಬೇರೆ ಚೆಕ್ ತೋರಿಸ್ತಾರೆ.
ಅದ್ಯಾವುದು?
ಪೇಜ್ 322. That number which your lordship saw at the bottom, 786491.
ಇದು 786342 ಇದು.
ಇದು 42. 786342 ಇದು. ಅಮೌಂಟ್ ಅಷ್ಟೇ ಇದೆ.
ಪೇಜ್ ನಂಬರ್?
Page 237 ಅಲ್ಲಿ endorsement. Your lordships may please compare 237 and 322.
This is 786491.
786491.
786342 ಬೇರೆ ಇದು.
ಬೇರೆ ಚೆಕ್, ಅದೇ ನಾವು ಹೇಳ್ತಾ ಇರೋದು.
ಡೇಟು? ಆ ಚೆಕ್ ಡೇಟ್ ಏನು?
My lord, your lordships may see 237 ಅಲ್ಲಿ it says 786342 dated 25/2/04.
25/2/04.
Whereas if your lordship would please turn to page 322, it is 786491 dated 15/2. Date ಬೇರೆ, ನಂಬರ್ ಬೇರೆ.
ಡೇಟ್ ಎಲ್ಲಿದೆ ಇದಕ್ಕೆ?
ಡೇಟ್ ರೈಟ್ ಸೈಡ್ ಟಾಪ್ ಅಲ್ಲಿ ಇದೆ, 322 ನಲ್ಲಿ ಟಾಪ್ ರೈಟ್ ಹ್ಯಾಂಡ್ ಕಾಲಮ್ ಇನ್ ದ ಚೆಕ್. ಪೇಜ್ 322 ನಲ್ಲಿ ಆ ಚೆಕ್ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆಯಲ್ಲ,
ಅದ್ರ ಮೇಲೆ ಅದು ಫುಲ್ ಸರಿಯಾಗಿ ಬಂದಿಲ್ಲ.
ಇಲ್ವಾ?
ಅದು ಜೆರಾಕ್ಸ್ ಮಾಡುವಾಗ ಒಂದ್ ಸ್ವಲ್ಪ ಪೇಪರ್ ಅವನು ತಿಂದೇ ಬಿಟ್ಟ. ನಾವು
LCR ಇದೆ ಮೇಡಮ್, ಫೋಟೋಸ್ LCR ಇದ್ರೆ
LCR ತೋರಿಸಿ ಜಸ್ಟ್.
ಡೇಟ್
ಇಂಥವೆಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಹಾಕುವಾಗ ಬಹಳ ಮುತುವರ್ಜಿ ವಹಿಸಿ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಹಾಕ್ಸ್ಬೇಕು.
ಸಾರಿ ಮೇಡಮ್.
ಅಲ್ಲ ಇಟ್ ಹ್ಯಾಪನ್ಸ್. ಪಾಪ ನಿಮ್ಮ ಬ್ರೀಫಿಂಗ್ ಪಡೀಲಿ
ನೋಟಿಸ್ ಅಲ್ಲ,
ಅಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವ್ರಿಗೆ ತೋರಿಸ್ಕೊಡು ಅಂತ ಹೇಳಿ ಚೆಕ್. ಅದೇ
ಹೇಳಿದೆ.
15/2/2004.
Now, yes, now Lord, your lordships may now see in December 25th, 2003, the endorsement says that I'll give additional 5 lakhs and I'm giving you the full price by these checks. Baki entire price, in addition to 5 lakhs. 29 lakh 80,000 plus 20 lakhs.
15 to 2004,
2004, yes, ma'am. If 5 additional. So it is 5 is additional.
Also 5 is additional. Yeah. Perhaps others may not wait. Come afternoon. It will take some time. Yes.
So, my lord, sequence you have noted, February 2001 agreement.
Yes.
Then cash payment, check payments all made. Rest of the proceedings not done. And conversion didn't happen. So it's
ಈ ಚೆಕ್ ಅನ್ನು ಯಾರು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರು?
ಇದು ಚೆಕ್ ಪ್ರೆಸೆಂಟೇ ಮಾಡಲಿಲ್ಲ. This page 237
ಅದು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಅದ್ರ ಬಗ್ಗೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಲ್ಲ.
ಇಲ್ಲ.
ಈ ಚೆಕ್ ಇನ್ನೊಂದು ರಿಫಂಡ್
ಪ್ರೆಸೆಂಟ್ ಮಾಡಿರೋದು ಡಿಫೆಂಡೆಂಟ್.
It was drawn in whose favor?
It is drawn in favor of defendant only.
Who drew that?
We have given the check. It was nothing to do with this. I'll tell you, Lordship, why I'm saying that. Please notice the sequence, Lord. At page 237, this check, 2 checks are given. One for 2980, another one for 20 lakhs. The first check, that is 2980, is dated 25/2/2004.
Correct.
On 25/2/2004, she terminates this agreement without presenting this check. Your Lordship will get it as P7, page 271. Same day. She could not have presented the check before that date.
Because of termination. If you terminate, you would not put it for presentation at all. Easy or
no, if she had presented the check.
Where is the question of termination?
It would have been honored. It may not have been honored. Whatever might have happened is different.
No, whether for termination, what is the reason given? Dishonor of check?
No, reason is that that other check 741.
Same check 735.
Kindly see, not this check which they never presented 342. They say the check is dishonored.
Based upon this.
Yes, this check 7342, my lord, which is dated 25/2/24. They say that check was presented and is dishonored. Therefore, I'm terminating the agreement.
25/2/2004.
Whereas the fact is that this check of 25/2/2004 was not presented. It could have only been presented on 25th.
Now, how that check came into her hands?
This check, this is given under this endorsement, my lord. Page 237 ali, December 2023, parties agreed to extend the time.
No, that check is dated 786, number 786342.
Yes, my lord.
But the check that has been dishonored.
Yes.
Is a different check.
Different check. According to us, the check which he presented had nothing to do with this suit transaction.
No, we are asking how that check came into her hands.
We had other transactions with her. This is not that check anta nav helodu. If she had pleaded, my lord, that I had got a check like this, is it 26 or 25?
25/2/0.
Typing as well.
78634. Let's look at the original itself.
That was also for the same amount.
Same amount.
Did not explain it. No single question and cross also. For the dishonored check number.
Legal notice allunu, they are referring to the check of 342 dated 25/2/24, the 2004. And the allegation is at page 272, ನೀವು ನನಗೆ ಈ ಚೆಕ್ ಕೊಟ್ಟಿದ್ರಿ.
ನಿಮ್ ರಿಪ್ಲೈ ಏನದು?
I presented it.
Dishonored.
ಹಾ.
ನಿಮ್ ರಿಪ್ಲೈ ಏನು?
ನಮ್ ರಿಪ್ಲೈ, ನಮ್ answer, my lord, is page 277. What we say is that this check was dated 25/2/2004. Question of it being dishonored before that doesn't arise.
That is not the answer.
Please see, my lord, at page 277. Two answers are given there.
It has to be presented after 25 to what date? That's because of the date of the check is 25. Say that is 25.
If they had told me in the notice,
ಅಲ್ಲ, ನಾವು ಕೊಟ್ಟ ಚೆಕ್ ನೀವು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ ಚೆಕ್ ಬೇರೆ ಬೇರೆ ಅನ್ನೋ ರಿಪ್ಲೈ ಎಲ್ಲಿದೆ ನಿಮ್ದು?
hangalla, what I'm saying, my lord, is this: I am replying to their notice. Their lawyer gives me a notice to say that this check dated 25/2 ನಾನು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ ಡಿಸಾನರ್ ಆಯ್ತು ಅಂತ.
ನಂಬರ್ ಯಾವುದು ಅಂತ ಹೇಳಿಲ್ಲ.
ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ ನೋಟಿಸ್ ಅಲ್ಲಿ ನಂಬರು.
ಈ ಚೆಕ್ ಯಾವುದು? ಇದು ಡಿಸಾನರ್ಡ್ ಚೆಕ್.
ಡಿಸಾನರ್ಡ್ ಚೆಕ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಅವರು. ಅವ್ರ ನಂಬರ್ ಹಾಕೋದು ಕರೆಕ್ಟ್ ಚೆಕ್ ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ.
ಯಾವ್ದು ಪ್ರೆಸೆಂಟ್ ಆಗಿಲ್ಲ ಅದು?
ಹೌದು. Page 271 is a legal notice. At 272, this is what he says. Last 4 lines. You had also handed over 2 post-dated checks. One bearing number 786342, dated, ಇಲ್ಲಿ ತಪ್ಪು ಮಾಡ್ತಾರೆ, 15/2 ಅಂತ ಬರೀತಾರೆ. ಅಲ್ಲಿ then he adds, wrongly typed as 25/2/04 in the endorsement ಅಂತಾರೆ. ಅದು ತಪ್ಪು. ಅದು ಟೈಪ್ ಅಲ್ಲಿ 25 or 26 ಅಂತ ಟೈಪ್ ಆಗಿದೆ. In the paper book copy,
correct,
it should be 25.
786342.
Yes, it is correctly dated 25/2/04, my lord. Check is before your lordships.
15/2/2004 ಅಲ್ವಾ?
ಅಲ್ವೇ ಅಲ್ಲ. 15/2/2004 is a different check. But ಅವ್ರು ಹೇಳ್ತಾರೆ ಈ 786342 it is really dated 15/2, but ತಪ್ಪಾಗಿ 25/2 ಅಂತ ಬರ್ದಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಾರೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಆ ಚೆಕ್ ತಪ್ಪಾಗಿಲ್ಲ ಅನ್ನೋದು ನಿಮ್ದು?
ತಪ್ಪಾಗಿಲ್ಲ,
ಆ ಡೇಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ.
ಕರೆಕ್ಟ್ ಇದೆ.
ಬಟ್
322 ನಲ್ಲಿ D3
ಅಲ್ಲ, ಅಲ್ಲಿ ಯಾಕೆ ಇಲ್ಲಿ ಬರಿ ಪೇಜ್ 235 ಬನ್ನಿ.
235, yes. Yes, ಅಲ್ಲೂ ಕರೆಕ್ಟ್ ಅದೇ ನಂಬರ್ ಇದೆ.
786342.
Yes,
dated 25/2/2004.
ಹೌದು.
ಇವ್ರು ಯಾಕೆ ಹಿಂಗೆ ಹೇಳ್ತಾರೆ?
So the two arguments that follow from this, my lord, is this: that the check which was given to them as per this endorsement at page 237 is not the check which they presented. If they had written to me, and one more thing, my lord, is it's all carefully planned. If the check, according to them, the check is wrongly dated as 25/2, then they could not have presented it on 25/2, on 15/2.
So they should have waited till
They
then.
should have wait 25th ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು? ಈ ಚೆಕ್ 25-2 ಇದೆ, ಅವ್ರ ಹತ್ರ receipt ಅಲ್ಲಿ ಇದೆ. They should have presented it on 25th. Then if the check was dishonored, then the question of my not paying and whether that one check dishonor is ground enough for termination is another argument. But that's not what happens. They present another check which is of a different date, 15-2, and that check is first dishonored as awaiting funds, then says exceeds arrangement.
ಅದ್ಮೇಲೆ pleadings ಏನಿದೆ?
ಏನೂ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ, ಅವ್ರು ಏನೂ ಹೇಳಿಲ್ಲ.
Amendment ಏನ್ ಮಾಡಿದ್ರು?
Amendment ಅಲ್ಲಿ they want to correct this, correct it to say that I want this correct check which was given to me, this check was returned and in lieu of it another check was given. ಅದು
ಅಮೆಂಡ್ಮೆಂಟ್ ನಲ್ಲಿ
ಹೆಸರು
ನಾವು
ತಪ್ಪಾಗಿದೆ.
ಹೇಳಿರೋದು ಅಮೆಂಡ್ಮೆಂಟ್ ನಲ್ಲಿ ಶಾಂತ ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಅಂತ ಹೇಳಿ ಚೆಕ್ ಬರೆದು ಕೊಟ್ಟಿದ್ದೀರಿ. ನೇಮ್ ಇರೋದು ಶಾಂತ ಶ್ರೀನಿವಾಸ್ ಅಂತ ಅಷ್ಟೇ. ಅದನ್ನ ತೋರಿಸಿದಾಗ ಆ ಮೊದಲಿನ ಚೆಕ್ ಅನ್ನ ವಾಪಸ್ ತಗೊಂಡು ಬೇರೆ ಚೆಕ್ ಅನ್ನ 2 ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ ಶಾಂತ ಶ್ರೀನಿವಾಸ್ ಅಂತ. ಆ ಚೆಕ್ ಅನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರಿ. ಆ ನೋಟಿಸು ಅವರು ರಿಪ್ಲೈ ನೋಟಿಸ್ ಕೊಡ್ತಾರಲ್ಲ, ಅದರಲ್ಲಿ ಪ್ಯಾರಾ 4 ನೋಡ್ಬೇಕು ತಾವು. ರಿಪ್ಲೈ ನೋಟಿಸ್ ಇನ್ ಪ್ಯಾರಾ 4.
Before that, I'll tell you lordships, this intriguing thing what happened in this case. Why all the story they are bringing out? My lord, when they did not produce the 786342 check, it was not presented, it was not dishonored anywhere. We filed an application IA number 20, calling upon them to produce this check of 786342 which they have acknowledged.
ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿ ಏನ್ ಹೇಳಿದ್ರು?
Objection ಅಲ್ಲಿ, then they realized that they don't have the check. They said ನಮ್ಮ ಹತ್ರ ಚೆಕ್ ಇಲ್ಲ. ಆ ಚೆಕ್ ಏನಾಯ್ತು ಅಂದ್ರೆ, then they say this check was returned to me.
ನೇಮ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಕೊಡ್ಲಿಕ್ಕೆ ನಾವು
ಅಂತ
ಕೊಟ್ಟಿದ್ವಿ
ನಾವು ಕೊಟ್ವಿ ಅಂತ. ಅದು that explanation they tried to give. Then only they filed the application for amendment. So my answer, my lord, is that when the termination notice has to be read on its face value, could they have terminated the agreement on that day? For 2 reasons, I respectfully submit it could not have been done. First reason is you did not present the check which was given. Secondly, if this check had been switched, this is a solemn document signed by everybody.
ರಿಪ್ಲೈದಲ್ಲಿ ಹೇಳಿದ್ರ ಹಂಗೆ?
Reply, what we have said, my lord, is this.
ನಾವು ಕೊಟ್ಟ ಚೆಕ್ ಇದೆಯಲ್ಲ ಅದನ್ನ ಹಾಕೊಳ್ಳಿ, ನೀವು ಅದನ್ನ ಬಿಟ್ಕೊಂಡು ಯಾವ್ದೋ ಒಂದು ಹಾಕೊಂಡ್ರಿ, ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರಲ್ಲ. ಎಲ್ಲರ
Please see, my lord, what this, the stand you have taken is this. At page 277, you say, the date, may I read, my lord, page
Yeah.
277, para 3, bottom only.
In your claims, the check bearing number.
The check bearing number 786342 dated 25/2/04 was for a sum of rupees 29,80,000. The date has been mentioned as 25/2/2004 because both the parties are agreed that the check is to be presented only on or after 25/2/2004 for encashment. However, your client did not comply with the terms of the said agreement and has not so far applied for conversion of the land for non-agricultural commercial purposes to enable collection of the sale transaction. Then
ಅಲ್ಲ, ಒಂದ್ ಸೆಕೆಂಡ್. In the light of this, ನಿಮ್ಮ ಸ್ಟೋರಿ ಸ್ಟ್ಯಾಂಡ್ ಆಗುದಿಲ್ಲ.
Allah, my case is that this check is dated 25/2 and your termination cannot be based on 15/2. And so far as the second payment is concerned, I have obtained a demand draft for 20 lakhs. Endorsement ಅಲ್ಲಿ ಎರಡಿದೆ ನೋಡಿ. ಒಂದು 2980 at page 237. ಇನ್ನೊಂದು ಚೆಕ್ 20 at 20 lakhs.
ಎರಡು ಚೆಕ್.
ಹಾ.
ಒಂದು 25/2, ಇನ್ನೊಂದು 15/3.
ಅಲ್ಲ, ಎರಡನೇದು ಚೆಕ್ 20 ಲಕ್ಷ. At page 237.
Correct. That is 15/3/2004.
Yes, 15/3. ಅದಕ್ಕೆ we take another DD for 20 lakhs.
ಅದೆಲ್ಲಿದೆ?
ಅದು page 272 ನಲ್ಲಿ.
272.
Yeah. That is our reply.
272 is their notice.
No, no,
Our reply is
sorry, my reply is at
275.
278 ಅಲ್ಲಿ ಹೇಳ್ತೀರಿ.
278.
278. This is our reply. Last 4 lines. Our client
Purchase
had-
a demand draft payable to you so and so for 20 lakhs.
Yeah. In spite of your client not taking any step for conversion of the land.
ಇದನ್ನ ಪರ್ಚೇಸ್ ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ರಿ? ಎಲ್ಲಿ ಕೊಟ್ರ ಅದನ್ನ ಅವರಿಗೆ?
ಅಲ್ಲ ಅವರು they are not.
ನಾವು ಆ ಪ್ಯಾರಾ 4 ಇನ್ ಓಪನಿಂಗ್ ಸೆಂಟೆನ್ಸ್ ನೋಡ್ಬೇಕು.
Our client specifically instructed your client not to
Present the check for encashment before 25/2/2004. If check was dated 25/2/2004, question of asking us not to present before 25/2/2004 would not have arisen.
That's what it
As referred to in the endorsement receipt. However, your client had, contrary to the undertaking between the parties, presented the check earlier. In between check.
When it was 25, whether he says it or not.
ಹೌದು.
ಅಲ್ಲಲ್ಲ 25/2 ಇದ್ದಿದ್ರೆ ನಾನು ಮೊದಲು ಕೊಡೋ ಪ್ರಶ್ನೆನೇ ಇರಲಿಲ್ಲ. ನಾವು ನಮ್ಮ ಪ್ರಕಾರ ಈ ಚೆಕ್ಕು 25/2 ಅಂತ ಹೇಳಿ ಬರೆದಿರೋ ಚೆಕ್ಕು ಶ್ರಾಂತ ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಅಂತ ಬರೆದಿದ್ದಕ್ಕಾಗಿ ಅದನ್ನು ವಾಪಸ್ ಕೊಟ್ಟು 15/2 ಚೆಕ್ಗಳನ್ನ 15/2 ಚೆಕ್ ಕೊಟ್ರು. ಅದಕ್ಕಾಗಿ ಅವ್ರು ಹೇಳೋದು contrary to our undertaking and the understanding, you have presented it earlier.
ಹಂಗಂತ ಇಲ್ಲ. There is no plea, my lord.
That's what your reply says.
No, you can explain, but you should not, you should plead and then explain. Lord, this whole story is incredible for this one more reason, my lord. Please turn to page 285, my lord. This is a bank statement.
ಈ ಡಿಡಿ ಬೈ ಮಾಡಿದ್ರಾ?
ಹೌದು, ಡಿ ತಗೊಂಡಿದೀವಿ.
ತಗೊಂಡು
ಅವ್ರು ಕೇಳಿದ್ರೆ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ. ಅಷ್ಟೊತ್ತಿಗೆ ಏನ್ ಮಾಡಿದ್ರು? ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಟ್ರು. 25ಕ್ಕೆ she terminates my contract.
ಅಗ್ರಿಮೆಂಟ್ ರಿಸಿಂಡ್ ಮಾಡಿಬಿಟ್ರು.
ರಿಸೆಂಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ನೀವು ಡಿಡಿ ಬೈ ಮಾಡಿದ್ದೆ ಅವತ್ತೇ.
ಹಾ,
25/2 ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ?
ಹಾ, ಅದಕ್ಕೆ kindly not see 282.
15 lakh, 5 lakh.
ಎರಡು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಅಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ.
ಅದನ್ನ ಯಾವತ್ ತಗೊಂಡು ಯಾವತ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರಿ?
ಅದೇ ಡೇಟಾ ಎಲ್ಲಿದೆ ಸ್ವಾಮಿ. ದಿಸ್ ಇಸ್ ಪೇಜ್ 282 ನಲ್ಲಿ. ದಿಸ್ ಇಸ್ ಟು ಸರ್ಟಿಫೈ that the DD dated 25/2/2004 for an amount of 15 lakhs favoring Mrs. Shanta Srinivas has been issued from the account of Golden Palms, which held with account with the bank. The DD was subsequently cancelled and credited to the current account of Golden Palms on 8/3/2004. Because they issue made termination notice. ಅದು ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ಇದು 15 ಲಕ್ಷ.
15. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 283. Your lordships will get the bank statement debit of 15 lakhs. ಮಧ್ಯದಲ್ಲಿದೆ 25th February for yourself DD ಅಂತ.
This is debited on
25th February. ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಕಾಲಮ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್.
ನಿಮ್ಮ ಅಕೌಂಟ್ ನಿಂದ
ನಮ್ಮ ಅಕೌಂಟ್ ಡೆಬಿಟ್ ಆಗಿರೋದು.
ಡಿಡಿ ಬೈ ಮಾಡಿದ್ದಕ್ಕೆ.
Yes, yourselves for DD ಅಂತ 15 ಲಕ್ಷ.
Correct.
This is in conformity certificate.
ಹಾ.
The next page, 284.
8th March. ಅಲ್ಲ, ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಡಿಡಿ ಅಂತಿದೆ ನೋಡಿ.
ಅದು ಆಮೇಲೆ ಆಗಿರೋದು.
8th
March. ಅದು ಕ್ರೆಡಿಟ್ ಬಂದಿದೆ.
So not same day.
No. They bought it, my lord. The DD was purchased on 25th February.
Give only.
Give. Meanwhile, ಅವ್ರು ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಟ್ಟು. ನಾವ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು then we cancel the DD and return. ಇದು 15 ಲಕ್ಷ.
ಇನ್ನೊಂದು 5 ಲಕ್ಷ.
Then next page, 284 ಗೆ P11. This is a bank certificate.
ಅಲ್ಲ, ರೈಟ್. ನಿಮ್ಮ
The statement is at page 285. ಅದು 5 ಲಕ್ಷಕ್ಕೆ. Lord, please see this statement, my lord. ಇದರಲ್ಲಿ on 25/2 there is a statement. Purchase order favoring Shanta Srinivas 5 ಲಕ್ಷ. ಅವತ್ತು kindly see the balance in the account, my lord. After that 54 lakhs balance ಇದೆ. Then ಅದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ 28/2/2004 ಥ್ರೂಔಟ್ ಬ್ಯಾಲೆನ್ಸು 50 ಲಕ್ಷಕ್ಕೆ ಮೇಲಿದೆ. Now this is completely ignored by the court. Why will a person, I ask myself a question. In December 2003, we agreed to pay extra price. We give checks. We have the money. And the date on the check given to him was 25/2.
ಆ ಅಕೌಂಟ್ಸ್ ಚೆಕ್ ಕೊಟ್ಟ ಕಂಪನಿದಲ್ಲ. Of course, they say,
Seri.
I have several companies, other company would have given the money.
My lord, if
The accounts which they have produced
to
is
answer-
not of Sanrama
my lord,
plaintiff.
the
Indian contract law, unlike in English law, consideration can move from others also.
Sir, ಅಲ್ಲ ನಾನು ಅದು ಅಂದ್ರೆ
ನಾನ್ ದುಡ್ಡು
ಅವತ್ತು ಇತ್ತು ಅಂತ ಹೇಳಿ
argument
ಹೇಳ್ತಾರೆ.
is, ಇವ್ರಿಗೆ ದುಡ್ಡಿರ್ಲಿಲ್ಲ, ರೆಡಿನೆಸ್ ಇರ್ಲಿಲ್ಲ, ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಇಲ್ಲ, ಚೆಕ್ ಡಿಸನ್ ಆಗೋಯ್ತು ಅಂತ. That's all. Now, my lord, I am a person, I have several accounts. Now, my lord, if I am able to show, my lord, very rarely in my experience we find in these specific performance suits that on the due date for performance, the plaintiff purchaser will show to the court, nodi ನನ್ನ account ಅಲ್ಲಿ ಇಷ್ಟು ದುಡ್ಡಿತ್ತು ಅಂತ. The law also is developed like that. The courts don't expect you to show that you had actual balance in your account.
If you have
ನಿನಗೆ
capacity to raise it, that is sufficient.
ಬಿಸ್ನೆಸ್ ಇರ್ಬೋದು, ಓವರ್ ಡ್ರಾಫ್ಟ್ ಕ್ರೆಡಿಟ್ ಲಿಮಿಟ್ ಇರ್ಬೋದು, ಅಷ್ಟು ತೋರಿಸಿದ್ರೆ ಸಾಕು ಅಂತ. Here is a case where the money is available in the account, my lord. I ask myself, if I had to pay the money and I had balance in my account, why would I, my lord, not have honored the check? My case is that the date is 25/2. ನೀವು ಮುಂಚೆ ಯಾವ್ದೋ ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ, ಆಮೇಲೆ I'm now demonstrated that the second payment which was due in March, ಅದಕ್ಕೂ ನಾನು ರೆಡಿ ಆಗಿ ಡಿ ತಗೊಂಡಿದ್ದೀನಿ. ಆ ಡಿ ತಗೊಂಡ ನಂತರನೂ I had 51 lakhs.
ಆ ಡಿ ತಗೊಂಡು ಅವ್ರಿಗೆ ಏನಂತ ಹೇಳಿದ್ರಿ?
See, Lord, I take the DD. Same day I receive a notice from her to say I'm terminating the agreement. Same day.
ಆ ಡಿ ಬೈ ಮಾಡಿದ್ರಲ್ಲ, ಆ ನೋಟಿಸ್ ಬಂದ ಮೇಲೆ ಬೈ ಮಾಡಿದ್ರ ಮೊದಲ ಬೈ ಮಾಡಿದ್ರ?
Notice is dated 25/2.
Correct.
I have received it a couple of days later.
ಬೈ
Postal ಬಂದಿದೆ.
ಹಂಗಾಗಿ ನಿಮ್ಗೆ ಅವ್ರು ಹಿಂಗ್ ಮಾಡ್ತಾರ ನಿಮ್ಗೆ ಗೊತ್ತಾಗಿ ಆ ನೋಟಿಸ್ ಬರೋಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲೇ ಬೈ ಮಾಡಿ ಆಗಿದೆ.
Because we were anxious to go on with the property transaction. But why would somebody having paid 70 or 80%, 60 or 70% of the price, having money in his account, waiting for them to comply what they were supposed to comply? This is an incredible story, my lord, which to blame my client for saying that you didn't do what you were supposed to do. Forget about what I was supposed to do. Whether I did it or no, I gave power of attorney. What happened to Form 37I? ಅದೇನು ಇಲ್ಲ. Then they say this. And Lord, now please see the conduct. This is an interim order granted at 4:58.
And they sell the property on?
The date of sale, my lord, is 26/11/2005. P13 at page 286.
ಈಗ ಬೈಯರ್ ಅನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ನೀವು?
ಅವಾಗ ಏನಾಯ್ತು, ಮೊದಲು ಸೂಟ್ ಹಾಕ್ದಾಗ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ. ಇವ್ರು ಈ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡಾಗ then we made him a party. He is, my lord, respondent number 2 before your lordship.
He holds in trust for you ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
He is now the alienee pendente light. So section 52 will apply. Page 286, my lord. This is the sale deal. Now please see the averments also, very interesting. 26th November 2005. The interim order date, my lord, is 15/3/2005. Agreement is sale alli. Now a new person comes. Shanta Srinivas and E.
That is defendant number 2.
Yeah, no, Shanta
The
Srinivas is the
buyer.
defendant one. No, E. Krishnappa, my lord, is a third person who's not a party. He is a prior agreement holder. So ನಮ್ಮ ಹತ್ರ agreement ಮಾಡಿ ದುಡ್ಡು ತಿಂದು ಎಲ್ಲ ತೇಗಿ ಎಲ್ಲ ಹೊಟ್ಟೆ ತುಂಬಿತು. ಮತ್ತೆ ಸ್ವಲ್ಪ ಹಶ್ವಾಯ್ತು. ಮತ್ತೆ ಕೃಷ್ಣಪ್ಪ ಅವ್ರು ಬಂದ್ರು.
That agreement is, the sale deed is dated what?
This sale deed is dated 26/11/2005. The suit was filed on 14/3/2005. Interim order on 15/3/2005. My lord, your lordship asked me a question about status quo, my lord. It's on the part of the record. I may just read, my lord. Direction is, both parties are directed to maintain status quo.
That is 15/3/2005.
Yes. Hence, both plaintiff and defendant are directed to maintain status quo regarding title of the property till the next
Very
date.
title itself.
The record LCR ಅಲ್ಲಿ ಇದೆ ಅಂತೆ. Exhibit ಆಗಿದೆ.
Order sheet of the
Trial court order sheet, my lord. Trial court order sheet.
ಅದೊಂದು flap ಹಾಕಿ. Yes.
So, my lord, this sale deed now comes. E. Krishnappa is the confirming party. I'll not read, my lord, the recitals. At page 289, Kata, etc. Therefore, last para in 289. That's where, my lord, now conversion. Whereas the vendor has applied for conversion the scheduled land, bearing old number so and so, new number so and so, measuring 4 acre 27 guntas non-agriculture purpose before the special DC Bengaluru. Whereas the vendor has remitted necessary conversion fee of so much, vide Chalan dated 9/6/2004. So, my lord, that means on the
ಅವಾಗ
date
IT ರಿಕ್ವೈರ್ಮೆಂಟ್ ಎಲ್ಲ ಡಿಲೀಟ್ ಆಗಿತ್ತನು?
1981 ನಲ್ಲಿ 230A ಹೊಟ್ಟೋಯ್ತು. 230A was not there.
ಅಲ್ಲ ಅದು ನಿಮ್ಗೆ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ.
But 37I was there.
37I was
there. Now, it is interesting date, my lord, here. The date of termination of the agreement was 25/2/2004.
Correct.
Now, in this document, for the first time, it transpires that subsequently she has applied for conversion, which she didn't do during my agreement period. Nam agreement cancel ಮಾಡಿ revocation ಮಾಡಿ ಆಮೇಲೆ an agreement is entered into with Mr. Krishnappa, and at page 290.
That conversion order came to be passed on 10/6/2004.
Yeah. ಚಲಾನ್ ಕಟ್ಟಿದ್ದು 9/6
ಗೆ,
ಆರ್ಡರ್ 10/6/2004. ಇದೇ ನಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಪೀರಿಯಡ್ ಮಾಡಿದ್ದಿದ್ರೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮುಗಿತಾ ಇತ್ತಲ್ಲ. ದುಡ್ಡು ಜಾಸ್ತಿ ಆಗಿದೆ. 1 crore 20 lakhs is the sale price under this.
1 crore 20 lakhs. Yes, sir.
Then, my lord, at page 290, she says at the last recital, vendor is in uninterrupted possession, peaceful enjoyment, paying property taxes, exercising all rights of ownership, etc. since the date without any claim, objection or hindrance from any quarter till now. Please see this recital. Top of page 291. Can she say this? When there is a suit,
Order.
there is an order saying maintains title.
List
So
pendants.
it's apparent that there is collusion. And another factor is this purchaser, my lord, Mr. E. Krishnappa, my lord, from the evidence that is there, is a very powerful land developer. And we can be assured that he is not some gullible small 1 acre landowner who wants to buy some land, ಅಲ್ಲೆಲ್ಲೋ compensation ಆಗಿ ಒಂದಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ, ಅದನ್ನ ಬೇರೆ ಕಡೆ ಜಮೀನ್ ತಗೊಂಡ್ಬಿಡೋಣ.
But courts are more powerful than the most powerful man in the
Respectfully agree.
Indian soil.
Respectfully and humbly agree.
Yes.
Everybody, my lord, is to be treated in the same way. No difficulty. Why I am mentioning that, my lord, was this. A person like that, who is well known in the real estate market, will he buy a property without basic precaution of a public notice? And if his vendor, that is the first defendant, has suppressed these facts, can we believe it? And neither and the interesting thing is, they do not disclose the date on which this first defendant entered into an agreement with Mr. Krishna. For all you know, she might have done it even before February 24, 2004.
Sir, the vendor entered witness box.
Our vendor barlila, our ganda bandru. And evidence is that she's quite all right and she's healthy, adella yenilla, but nan vyavara gottu anta nan bartini ante. Same thing with second defendant also. He didn't come. He also sent a power attorney. And Krishnappa not examined.
During the pendency of the suit, alienation ಆಗಿತ್ತು.
Absolutely.
39(2)A ಇಂಥವು ಏನಾದ್ರೂ ಮಾಡಿದ್ರೆ ನೀವು?
ನಾವು ಹಾಕ್ಲಿಲ್ಲ, not because that again ಸುಮ್ಮನೆ ಡಿಲೇ ಆಗ್ತಾ ಹೋಗುತ್ತೆ. ಅದ್ರ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಇದು ಅದು. So anyway, my lord, it is list pendant. So what we did was, we made him a party. We filed an application. He was permitted. He was added on 10/2/2009.
All right.
My lord, against him also, after he was impleaded, we moved an application that he should not do anything. So the Honorable Court passed an order.
Non-alienation.
17/8/2009. An injunction was granted against him from alienating the property.
ನೋಡೋಣ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅನ್ಕೊಂಡು. Anything else you want to say?
My lord, my lord, just 2-3 things in this document, my lord. At page 292.
ಊಟ ಮುಗಿಸ್ಕೊಂಡ್ ಬರೋಣ. ಒಂದು ಸಣ್ಣ ಮೀಟಿಂಗ್ ಎಲ್ಲ ಇರ್ತದೆ, ಸಿಗ್ನೇಚರ್ ಮಾಡೋದಿರ್ತದೆ.
Mention, my lord. Serial number 38 and 39. Next week is also fine.
ಯಾವ್ದು?
ITA. Serial number 38.
Your lordship, small mention, your lordship.
Wait.
Lord, I have one case in which I might have to reply in another court, my lord, in the afternoon. It may take about 15-20 minutes, my lord. If I can be excused till then, my colleague will be here.
Very good. No
my learned friend.
ಅವ್ರು ಸ್ಟಾರ್ಟಿಂಗ್ ಮಾಡ್ಲಿ.
Please.
ಗೊತ್ತಾಯ್ತು ನಂಗೆ ಸ್ಟ್ರಕ್ಚರ್ಡ್ ಏನು ಅಂತ ಗೊತ್ತಾಯ್ತಂಗ.
Grateful.
Yes, brother.
38 and 39.
38, 39. All right, ಯಾವಾಗ ಬೇಕು?
Any date, my lord.
2 weeks at the request of counsel for the.
Serial number 32, next matter.
ಯಾವ್ದಮ್ಮ?
32.
I appeal for the petitioner in that matter.
The LCR has been received, my lordship. I am not keeping well.
You're not well.
Any short date, sir.
Which date will be?
Only
20th,
question,
my lordship, 20th of this month.
20th we'll have that.
only short day question is whether it suit for bare injunction transferred from Tumkur court to the special court. Land grabbing issue will arise in that matter.
Not,
Please,
not, call this matter on 20th, as suggested by both the sides.
Right.
Your lordship,
ಏನಮ್ಮ?
sorry, your lordship. Serial number 35, your lordship. Your lordship, a short accommodation. Yes, your lordship. Actually, you can post it next week only, your lordship, because of today's personal inconvenience. It is like
You are for
appellant, your lordship.
appellant.
Yes, your lordship.
Good. 2 weeks at the request of. All.
Much obliged, your lordship.
ಅದು ಯಾವಾಗ ಹೇಳ್ತೀರಾ? ಅದು ಆರ್ಡರ್ ಜಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. No objection overrule. Acknowledgement ಬರ್ಬೇಕು. 31 ಮುಗೀತಾ ಇದು? ತಿರ್ಗಾ ನಡೆಯತ್ತಾ? ಸರ್ ಅದು ಯಾವಾಗ ಅಪ್ಡೇಟ್ ಆಗ್ಬೋದು ಸ್ವಲ್ಪ ಟೈಮ್? ಓಕೆ.
ಸರಿ ಸರಿ. Okay.
ಸರ್ ರಾಘವೇಂದ್ರ ಸರ್ ಇಲ್ಲಿ ಊಟ ಮಾಡಿ.
ಮಧ್ಯಾಹ್ನ
ಅಪ್ಡೇಟ್ ಮಾಡ್ತಾರೆ. ಇವಾಗ ಅಪ್ಡೇಟ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ 3-4 as sure. ಅದೇ ಅವ್ರು ತಪ್ಪಾಗಿ ಮಾಡಿದ್ದಾರೆ. Thank you, sir.
26 of 2012. 31/1/12 ಫೈಲ್ ಮಾಡಿದ್ರೆ
ನಾವು 1617 ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿ ಅದು 26
ಫೈಲ್ಡ್ ಎಂದು
ಅದೇ 31
ಮತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ಡ್ ಅಂತ
ಡೇಟ್ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದು ಡೇಟ್ ಇಲ್ಲ
ಡೇಟ್ ಇಲ್ಲ.
ಈಗ 26 ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು 4/2/2000
4/12.
ರಿಕಾಲಿಂಗು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದು 3/12.
ಕರೆಕ್ಟ್.
ಈ ಅಬ್ಜೆಕ್ಷನ್ ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕೋದು ಸ್ಟೇಜ್ ಯಾವಾಗ ಬಂತದು? ವಿಟ್ನೆಸ್ ಕ್ವಶನ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ಬಂತ? ಎಂತದಕ್ಕಾಗಿ ಬಂತು?
ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆ ಅವಾಗ.
ಹೌದು, ಟ್ರಯಲ್ ನಡೀತಾ ಇತ್ತು. ವಿಟ್ನೆಸ್ ಏನೋ ಕೇಳ್ತಾ ಇದ್ರಿ.
ಆ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಬಂದಿದ್ದು.
ಅವ್ರಿಗೂ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೆ.
2 ಫೈಲ್ ಇದ್ದಾವೆ, ಎರಡ್ರಾಗ ಯಾವ್ದಾರು ಒಂದ್ರಾಗ ಇತ್ತು. ಅಲ್ಲ, ನಾ ಯಾಕೆ ಕೇಳ್ತಾ ಇದ್ದೇನೆ ಇದನ್ನೆಲ್ಲ ಅಂದ್ರೆ, ನಾವು ಶುರು ಮಾಡ್ಬೇಕಾದ್ರೆ ಈಗ ಇದನ್ನ ಶುರು ಮಾಡೇ ಬಿಡ್ಬೇಕು ಅಂತ.
ನಾವು ಫೈಲ್ ಈ ಕಡೆ ಕೊಡೋ ನಿಮಿಷ
ಆ ಕಡೆ Rule 17 ಅಪ್ಲಿಕೇಶನ್ ಇದು
26 of 2011.
ಹೌದು.
ಏನಂತ ಕೇಳಿ ಅಮೆಂಡ್ಮೆಂಟ್? Check bearing number so and so was drawn on Punjab Insurance. Name was issued in the name of first defendant, but the name of first defendant was wrongly shown as Shanta Srinivas Murthy as against Shanta Srinivas. It's upon pay check. While the check was written in the name of Shanta Srinivas Murthy, another check was issued on by written the same bearing number so and so. When the check was handed over to the defendant, the husband of the defendant, who in fact enlightened the plaintiff that the aforesaid checks were drawn in wrong name of the defendant, it is allowed to the plaintiff in the same style if the instrument represented to honor client cannot be honored at all because of showing the defendant, which naturally does not tally with the name of understanding. Therefore, it was necessary to give back the original instrument to the plaintiff, and alternatively, plaintiff was asked to issue new checks upon showing the name of defendant number 1 correctly. Plaintiff accordingly have taken back the original instruments, and Xerox copies of those checks are still with the defendant number 1. Produce ಮಾಡಿದವನ ಇದನ್ನ the original instruments are handed over to plaintiff, and therefore it was necessary plaintiff to issue 2 other checks for 20 lakhs and 29 lakhs 8,000. Each check bearing numbers and
ಅವ್ರು ಹೇಳೋದು ಇದು ಬೇರೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಕೊಟ್ಟಿದ್ವಿ ಅಂತ.
Respectively, out of the aforesaid 2 instruments, one of the checks was presented for the 29 to the plaintiff banker, but he said return on wrong name. Those checks are held within the knowledge of him, but it was intentionally suppressed and in the plaint. Upon an application was moved in the suit, direction was sought for production of the same, but said application came to be rejected by this honorable court. ನಾವು ಅರ್ಜಿ ಹಾಕಿದ್ವಿ,
ನಮ್ದೇ ಅಪ್ಲಿ
ಅವನ ಆ ಚೆಕ್ಗಳನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಕರೆಕ್ಟ್.
ಏನ್ ಅವ್ರ ಅರ್ಜಿ ಹಾಕಿದ್ರ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಅಂತ? ಇಲ್ಲಿ ನೋಡ್ರಿ, though these facts were well within the knowledge of the plaintiff, but it was intentionally and deliberately suppressed by the plaintiff in the plaintiff. Upon suppressing these facts, an application was moved in the suit. Therein, the direction was sought for production of the ಅವರೇ ಹಾಕಿದ್ರು, ನಮ್ ಕಡೆಯಿಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಅಂತ ಆಗ್ಲೇ ಹೇಳಿದ್ರು. Said application came to be rejected by this honorable court.
Therefore, the plaintiff filed an application before this court to summon the check bearing number so and so. His objection is like our actual objection. Para 5 ಒಳಗೆ they are admitting that. Para 5 ಈ ಕಡೆ ಅಲ್ಲಿ therefore ಅಂತ ಶುರು ಆಗುತ್ತೆ. Para 5 ಒಳಗೆ 6ನೇ ಲೈನ್ 7ನೇ ಲೈನ್ 786342 ಆದ್ಮೇಲೆ therefore the plaintiff filed an application before this honorable court to summon the check number so and so as in the custody was admitted by defendant number 1
in a rejoint or a reply notice of the places to the document, think the issue, it is clearly mentioned, reverse the check that it should be presented and so and so.
Number 22 ಏನು ಹಾಕಿದ್ರಿ? IA number 20.
IA number 20,
ಅವ್ರು
it is for
ಹಾಕಿದ್ದು.
summoning the document.
ಹೌದು.
ಅದು dispose ಆಗಿದ್ದು ಈ ತರ ಬರ್ದಿದ್ದಾರೆ.
ಬರ್ದಿರೋ IA number 22 ಯಾರು ಹಾಕಿದ್ರು?
IA number 22.
Defendant remained absent and therefore it was dismissed ಅಂತ.
ಇದು ಇದೊಂಚೂರು ನೋಡ್ಬಿಡಿ ಸರ್. IA number
ನೋಡಿದೆ ನಾನು.
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಏನಂದ್ರೆ
ಅವ ಎಲ್ಲ ವ್ಯವಹಾರ ಕರೆಕ್ಟೇ ಮಾಡ್ಕೊಂಡಿದ್ದ, ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡಿ ಮುಗಿಸ್ಬೇಕು ಅಂತ.
ಹೌದೌದು.
ಅಡ್ವರ್ಸ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಡ್ರಾ ಮಾಡಕ್ ಆಕತಿ, ನೀವೇನ್ ಯೋಚನೆ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ ಅವ್ರಿಗೆ ಹೇಳಿದೆ.
ಕರೆಕ್ಟ್. ಇವ್ರು ಮುಗಿಸಿದ್ರ ನಾಗಾನಂದ್ ಈಗ? ಇಲ್ಲ ಇನ್ನೇನಾರ ಆಯ್ತಂತ.
Filed 3 applications seeking to reopen the evidence to recall the order dismissing IA number 22. ಏನಿತ್ತು IA number 22?
ಪಿಟಿಷನ್ ಬರ್ಬೇಕು. ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ವಾ ಬಸವರಾಜ ಪೂರ್ತಿ? ಪಡೀಲಿ IA number 23.
ನೀವು 3 ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ. Three applications seeking to reopen evidence 1, recall the order dismissing IA number 22, and the case was adjourned to 20 for objection. 3 ಅಂದ್ರೆ 2 ಸುದ್ದಿ ಹೇಳ್ತಾರೆ. The aforesaid IAs were registered as 23 to 25. On 27 and 20, the statement of objections when the case was proceeded. On 31, arguments on 23 were heard by honorable court, and on that day also filed present application seeking amendment of the written statement. So recalling ಇದನ್ನ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಈ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ. Totally new case.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ ಬೇರೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
15/2 ಒಂದು ಬೇರೆ ಚೆಕ್ ಇತ್ತು, ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಎಲ್ಲೂ ಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಎಲ್ಲೆಲ್ಲೂ ಬರಲಿಲ್ಲ. They also proceeded on the assumption this is the check, everything. And in the reply notice also they said ಅದನ್ನ date dispute ಮಾಡಲಿಲ್ಲ 15th. On the other hand, you had we had understood that it should be presented after 45.
ಇದು senior file ಇಂದ ಬಂದಿದೆ.
ಇದು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ರಿ, IA ನಂಬರ್ 26 ಇದು
ಅಮೆಂಡ್ಮೆಂಟ್
ಅಲ್ಲಿವರೆಗೆ ಇದು ಮಾಡಿದ್ದು. ಇದು ಫಾಲೋವಿಂಗ್ ಅಮೆಂಡ್ಮೆಂಟ್. ಇದು 7(3) ಅದೇನೋ ಚೇಂಜ್ ಮಾಡಬೇಕು ಅಂತ. And I make a word for 23 new sentences to be as follows. It is submitted ಅಂತ objection. Even in the on 2 occasions, it is specifically mentioned on the reverse of the aforesaid check that it should be presented for realization on 25/2. ಇಲ್ಲ ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಏನೋ ಇತ್ತು.
ಡಿಫೆನ್ಸ್ ಆ ಚೆಕ್ ಒಳಗೆ ಹೆಸರು ಬದಲಾಗಿದ್ದರಿಂದ ಬೇರೆ ಚೆಕ್ ಇಸ್ಕೊಂಡ್ವಿ ಅಂತ.
ಅದಾಯ್ತು. ಅವನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಅಂತ ಕೇಳಿ ನೀವು ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಟ್ಟು ಆವಾಗ ನೀವು ಫೈಲ್ ಮಾಡ್ಲಿಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್. ಅವಾಗೂ ಮಾಡ್ಲಿಲ್ಲ.
ಅವಾಗ ನಾವು ನಡೆಸ್ತಾ ಇರ್ಲಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಬೆಳಕಿಗೆ ಬಂದಾಗ ನಾವು ಹೋಗಿದ್ವಿ. ಆಮೇಲೆ ಈ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ ನಾವು. ME ಅಲ್ಲ, ME ಆಮೇಲೆ ಬಂದಿರೋದು. ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್ಗೆ ME ಬಂದಿದ್ದು, ಕೋರ್ಟ್ ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋ ಸ್ಟೇಜಿಗೆ ಬಂದಿದ್ದು. ನಮ್ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೀನಿ. ಊಟ ಮಾಡಿ ಬಂದಿರ ನೀವು?
ಬರ್ತಾನ 2:20.
ಏನಾರು ಮುಂದಕ್ಕೆ ಹೋಗಿದಾರೆ ನಾಳೆ ಗೀಳ ಹಾಕ್ಬೇಡ, ಸೋಮವಾರಕ್ಕೆ ಹಾಕ. ಭಾನುವಾರ ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು ಬಂದ್ರೆ ಸೀನಿಯರ್ಗೆ ಹೇಳ್ಬಿಡಿ, ಭಾನುವಾರ ಆಫೀಸಿಗೆ ಬಂದು ಅದೆಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಡ್ತೀವಿ. ಸ್ವಲ್ಪ ಹೈಟ್ ಎಲ್ಲಾರ ಇಡ್ಬೋದ ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್. ಇದು ಮರೆ ಆಗುತ್ತೆ, ಈ ಕಡೆ ಇದ್ದವ್ರಿಗೆ ಅದು ಕಾಣಿಸಲ್ಲ, ಆ ಕಡೆಗೆ ಇಟ್ರೆ ಆ ಕಡೆಗೆ ಇಟ್ರೆ. 9:32. ಏನ್ ದಿವಸ ನೋಡ್ಬೇಕು, ನಿಮ್ದು ಮುಗಿತಾ ಎಲ್ಲ?
2-3 things of saibro, but in relation to subsequent schedule in your point of view.
ನೋಡ್ಬೇಕು, 3-4 ಗಂಟೆ ಆಗುತ್ತೆ. ಅವ್ನು ಸರ್ವೇಶ್ ಕೊಟ್ಟು ಅವರಿಗೂ ಫೈಲ್ ವಾಪಸ್ ಕಟ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲಾರಿಗೂ ಕೊಟ್ಟು ಕಡೆಗೆ ಈಗ ಕೇಶವ್ ಭಟ್ ಅಂತ ತಗೊಂಡೋಗಿದ್ದಾರೆ. ಕೇಶವ್ ಭಟ್ ನನಗೆ ರಾಜಗೋಪಾಲ್ ಹೇಳಿದ್ರೆ ನಾನು ನಡೆಸ್ತೇನೆ, ಅವ್ರ ಆಫೀಸಿಂದ ಸಾಮಾನ್ಯ ಯಾರು NOC ತರಲ್ಲ, ನೀನೇನೋ ಮಾಡಿದೀಯ ಅಂತ ಅವನಿಗೆ. ಅದಕ್ಕೆ ನೀವು ಫೋನ್ ಮಾಡಿ ಸಾರ್ ಅಲ್ಲಿ. ನಾನು ಹೋಗಿಲ್ಲ ಪಕ್ಕದ ಕೊಟ್ಟಿಗೆ. ಇವ್ರು ಬರೋದು ಲೇಟ್ ಏನೋ ಒಂದು ಕಾಲ್ ಗಂಟೆ. ಅವನಿಗೆ ಪ್ರಾಣೇಶ್ ಇಲ್ಲಿಗೆ ತಂದ್ಬಿಡೋನು ಕೋರ್ಟಲ್ಲಿ. ಒಂದು 5 ನಿಮಿಷ ಲೇಟಾಗಿ ಬರ್ತಾರೆ ಸರ್ ಈಗ. ನಾಲ್ಕನೇ ಕೋರ್ಟು ಟೈಮ್ ಹೋಗಿದೆ ಬರೋದೇನೆ. ನಾನು ಹೋಗಿ ಈಗ ಮೆನ್ಷನ್ ಮಾಡಿದೆ. ಸಂಬಡಿ ಹ್ಯಾವ್ ಟೇಕನ್ ಟೈಮ್ ಮಿಸ್ಟರ್ ರಾಜಗೋಪಾಲ್ ಅಂದು ಕಡೆಗೆ ಇವಾಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ M.R. Rajagopal appeared and is informed by the court that matter have already adjourned at 10:30 ಅಂತ ಬರೆದು ರೆಕಾರ್ಡ್ ಮಾಡಿ. ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ. ಈಗ ನಾನು ಆ ಕಡೆ ಹೋಗೋವಾಗ 20 ನಡೀತಾ ಇತ್ತು. ನಾನು ಒಳಗೆ ಹೋದೆ, ಅವಾಗ 20 ನಡೀತು. ಅದೇ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು. ಆಮೇಲೆ ನನ್ನನ್ನು ಕೇಳಿದ್ರು ವಾಟ್ ಸರ್. ಅವಾಗ ಹಿಂಗೆ ಅಂದೆ. ಅದಕ್ಕೆ ಐಮನ್ ಮೈ ಎಲೆಕ್ಷನ್ ಕೋಟಾ ನಂಬರ್ 7 ಮೇಲೆ ನೋಡ್ಬಿಟ್ಟು ಯಾರೋ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ. ಇವ್ರು ಯಾರು ನನ್ನ ಜೊತೆಗೂ ಇರಲಿಲ್ಲ, ನಾನೇ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ. ಸರಿ, ಪಕ್ಕಕ್ಕೆ ಹೋಗಿ ಬರ್ತೀನಿ.
ಸಿರಲ್ ನಂಬರ್ 43 ಐತೆ. ಅರ್ಜುನ್ ಆಗಿದೆನಾ? ಥ್ಯಾಂಕ್ ಯು.
ನೀವು ರೇಟ್ ಎಂದ ಹಾಕಿದ್ರಿ ಇದು ಪೆಂಡಿಂಗ್ ಇತ್ತ ಆಲ್ರೆಡಿ ರಿಮಾಂಡ್ ಆಗಿತ್ತು ಬಟ್ ಸೆಟಿಸೈಡ್ ಆಗಿರ್ಲಿಲ್ಲ ಇಲ್ಲಿ ಮುಗಿಸ್ಕೊಳ್ಬೇಕು ಅಲ್ಲಿ ಬರೋ ಹಾಗಿಲ್ಲ ಯಾಕಂದ್ರೆ ಹಳೆ ಆರೋಗ್ಯ ಆಗಿದ್ದಕ್ಕೂ ಅದಕ್ಕೂ ಎಷ್ಟು ಡಿಫ್ರೆನ್ಸ್ ಇತ್ತು ಜಡ್ಜ್ಮೆಂಟ್ ಡೇಟ್ ಸುಮಾರು ಟ್ರಯಲ್ ಕೋರ್ಟಿಂಗ್ ಡೇಟ್ ಇಲ್ಲಿ ನಾವು ರೆಕಾರ್ಡಿಂಗ್ ಕೇಳಿದ್ದು ಯಾವುದು ಸಮ್ಮರಿಗೆ ಸಮ್ಮರಿಲಿ ಎಂದಾಗಿತ್ತು 6. 2012. Mm, 13 to ಇದು ಇದಿಲ್ಲ ಡೇಟ್ ಎಷ್ಟು ಓಹೋ ಎನಿವೇ ಇದರೊಳಗೆ ರೂಲ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಯಾವುದೋ ಒಂದು ಪೇಪರ್ನ ನೋಡಿದ್ವಿ, ಸೆಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ವಿ. ನಮ್ಮ
ಸುಭಾಷ್ ಬಿ ಆಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಐತಾ ಅದೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಇದಾಯ್ತಲ್ಲ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಅದ್ರ ಬಗ್ಗೆ ನೋಡ್ರಿ ನಿಮ್ಮ
ಇದ್ರಾಗಿಲ್ಲ.
ಇಲ್ವಾ ಡೇಟ್ ಕೊಡಿ ಹೋಗಿ ಆಯ್ತು ಬಿಡಿ ಇಲ್ಲ ಆಯ್ತು ಬಿಡ್ರಿ ಆಯ್ತು ಆಯ್ತು 23
23
ಹಾಂ
ಅವತ್ತೇ
ಅದಕ್ಕೆ ನಾವು ಮೂವ್ ಮಾಡಿದ್ವಿ. ಅವರು ರಿಸರ್ವ್ ಮಾಡಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರು, ಮೂವ್ ಮಾಡಿದ್ವಿ ನಾವು.
ಕಮಿಂಗ್ ಹಾಕಿದ್ರ ನೋಟಿಸ್
Yes.
Serial number 33, my lords.
33.
Please, my lords.
Any.
My lords, it's a department appeal. Wanted week's time, my lords.
2009 matter.
Please, my lords. It's a reallocated matter. That is the only issue, my lords. Otherwise, I don't.
Call next week. Reluctantly adjourned by 1 week at the request of. Okay. All right.
My lords, may I request for a date? My lords, I appear for the respondent in this matter. Counsel from out of station is traveling.
He's coming.
For this matter.
Okay. Which date ಯಾವ್ದಾದ್ರು date ನೋಡಿ?
13th or 14th, my lords.
13th? All right, call on 13th. But tell him that even on 13th matter may reach, may not reach. Therefore, he comes here to wait also. Huh? Okay.
Obliged.
Lord, serial number 34.
34.
Lord, that's a
Ah,
Supreme Court, transfer pricing remanded matter.
amended matter. ಅದಾದ್ಮೇಲೆ ತಗೊಳ್ಳೋಣ.
ತಗೊಳ್ಳೋಣ.
Ongoing matter ಇದೆಯಲ್ಲ. Call after 4 weeks ಅಂತ ನೀನು ನೋಡು. Yes.
And serial number 17, my lord, it's a passed over matter, my lord. IA for continuation of delay.
Huh.
My lords, I appear for the respondents. The
Yes,
delay
sir.
is 307 days. I filed a written objection. My lords will consider it.
You want to file the objections?
I have already, my colleague is there in the court. He is handing over. Kindly take on record. I have included 2025 decisions of the Supreme Court also.
All right.
My lords may consider it accordingly.
All right. Application, appeal is filed with delay. And an application is filed seeking its condonation. Full stop. It is supported by an affidavit. Full stop. Learned counsel representing the respondent SSC has filed a detailed objection supported by a plethora of decisions.
Page 42 is the relevant page, my lord. The latest decision, para 13 onwards.
Including the latest one in H. Guruswamy versus Krishnaya, 2025 SCC online, SC 54. First, next one. Having heard learned counsel appearing for the parties and having glanced the decisions, copies whereof are produced along with the objections to the IA. Most of these are already seen by us in other matters. We are of the considered view that delay application needs to be allowed and delay needs to be condoned unconditionally. First off, ordered accordingly and IA is disposed of. Next.
Lord, transfer pricing matter, my lord. Page number 7 is a question of law.
Question of law
There
is
is
not yet
similar-
framed. We'll see after that one. Yes, next. Yes. Which are the password matters? Yes. ಏನಿದೆ?
Some portion, Kannada portion was extracted in the order, mail.
ಅಲ್ಲ, dispensed it. ಏನಿದು?
The land in question was granted in favor of the petitioner, in favor of the appellant, because he was the ex-serviceman and his land was, he lost the land in the submerged water of Harangi Dam. And therefore, as per the government scheme, he is entitled to 4 acres of land. He lost 4.37 acres of land. As such, he is entitled to 4 acres, out of which the government has.
What is the value of the land lost and now value of the land he wants? 4 acres ಈ ಬೆಂಗಳೂರಲ್ಲಿ ಹೋದ್ರೆ ಬೇರೆ ಆಗ್ತದೆ.
ಅಲ್ಲ, ಅದಲ್ಲಿ adjacent land, man. Adjacent agricultural land. Adjacent agricultural land.
ಮುಂದೇನು?
ಅಲ್ಲಿ. What happened was initially the government was pleased to grant under rehabilitation scheme 2.75 acres of land was granted in survey number 151 and 152. Whereas therefore he filed application for a grant of remaining portion of 1 acre 25 cents of land, agricultural land. Whereas the subsequently, because it was not considered, I approached this Honorable Court, filed writ petition in 2002. In that writ petition, there was a direction to consider my application, but not considered. They proceeded little further, but after getting certain reports from the Tahsildar and all that, kept quiet. Yet again, I filed writ petition in 2009 before this Honorable Court, and there is a direction. Based on the direction, the Deputy Commissioner was pleased to grant the land in my favor. Kindly see annexure F at page number 105, Mela.
Land is granted now.
Please, in my favor. 85 cents of land was granted. This order was challenged by the first respondent, Mela.
ಮುಂದೇನಾಯ್ತು?
He challenged the same.
ಮುಂದೇನಾಯ್ತು? ಚಾಲೆಂಜ್ ಏನಾಯ್ತು?
Challenge that appeal was dismissed.
Appeal was dismissed.
Actually, he filed application for cancel of grant. That application was rejected. As against, he preferred writ petition before this Honorable Court. This Honorable Court was pleased to set aside the order and directed to reconsider the matter afresh by virtue of the impugned order.
Remand ಆಗಿದೆ.
The remand. In the sense, set aside the grant order. My submission is that based on.
One second. Order ಏನಂತಾಗಿತ್ತು? ತೋರಿಸಿ. Where is that order?
Remand order, my lord.
112 ಬನ್ನಿ. ಇದಲ್ಲ ನಿಮ್ WP ಏನಾಗಿದೆ? Set aside ಆದ WP ಎಲ್ಲಿದೆ?
That is at page number 16 onwards, my lord. Learned single judge's order, my lord.
Operative portion ಎಲ್ಲಿದೆ?
As there is a para number 12 at page number 24, my lord. As a result, the order of the grant made in favor of the petitioner, wide annexure F and K shall stand quashed. The Deputy Commissioner is directed to ascertain from the decree that the petitioner has obtained from the trial court and which is affirmed by the appellate court, and thereafter determine whether any extra bit of land was available for the purpose of granting it to the respondent number 5. If there is an extra bit of land available, the Deputy Commissioner may then proceed to pass the order of the grant in favor of the respondent number 5. My lord, the learned single judge has proceeded on the footing that there is a decree, injunction decree against me. That is in respect of the land granted in his favor. The copy of the decree was produced. That is only in respect of the land. Kindly see, my lord, the decree was produced before the.
Decree against whom?
Against me. He has filed a suit for injunction in respect of different bit of land which was granted in his favor. That is the house site was granted in his favor. It is situated in survey number 1/1.
As of now, the grant is set aside.
Please, my lord.
Grant is set aside.
Grant is set aside.
Set aside. That
Please.
is subject matter of challenge.
Please, my lord. He has alternative remedy of filing appeal before the Karnataka Appellate Tribunal under section 49 of the Karnataka Land Revenue Act.
Did you take up that contention in your WS, in your SO?
Please, appeal I have taken, my lord. I have taken because.
You appeal ನಲ್ಲಿ resist ಮಾಡ್ತೀರಾ? Petition resist ಮಾಡೋದು ಯಾವಾಗ?
Allah, I have filed the, I am the respondent before the.
Correct. ಅವ್ರು only ಅವರೇ ಮಾಡ್ಬೇಕು ಈ contention, ಬೇರೆ ತೊಳಿಕ್ ಬರಲ್ಲ. Petitioner cannot take that.
I have made oral submission before the court that I have got.
Makes no sense.
He has got alternative remedy of filing appeal before the.
Oral submission ಮಾಡೇವಿ ಅಂತಂದ್ರೆ ಅದು ಅರ್ಥ ಬರಲ್ಲ. ಯಾಕಂದ್ರೆ ಎಲ್ಲ ರೈಟಿಂಗ್ ನಾಗ ಗೊತ್ತಿಲ್ಲಪ್ಪ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಓರಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
My lord, one submission, the submission, my submission is that, my lord. Earlier, what happened was the.
Where have you stated that I had orally submitted the appeal ನಲ್ಲಿ ತೋರಿಸಿ? Where have you stated I have orally submitted like this and learned judge did not consider that? Where have you ever that? ಅವ್ರ ಜಡ್ಜನ್ ಕರ್ಕೊಂಬಂದು ಅಫಿಡೇಟ್ ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿಕ್ ಬರ್ತದ ನಮಗೆ? ಮತ್ತೆ ವೇರ್ ಹ್ಯಾವ್ ಯು ಸ್ಟೇಟೆಡ್? ಅಟ್ ಲೀಸ್ಟ್ ಶೋ ದಟ್. ಅಲ್ಲಿ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಮಾಡಿ ಅಲ್ಲಿ ಅಡ್ವರ್ಸ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಮೋಸ್ಟ್ಲಿ ಆ ಜಡ್ಜ್ ಏನೋ ಅಡ್ಮಿಷನ್ ಟೈಮ್ನಾಗ ಅಥವಾ ಏನೋ ಒಂದ್ ಕಡೆ ಒಂದ್ ಸ್ವಲ್ಪ ಹೌದು ಇದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡೋಕೆ ಅನ್ನೋ ಇಂಪ್ರೆಷನ್ ತೋರಿಸಿರ್ತಾರೆ. ಅದನ್ನ ಇಟ್ಕೊಂಡು ನೀವು ಇದನ್ನೆಲ್ಲ ಹೇಳಿರಲ್ಲ. show that. If you show, I will give interim order to you.
My lord, I have stated like this, my lord. In page number 11.
11. Yav sentence.
That is para number 7. That is the last bottom portion 8. Last 6 lines in the previous para. The learned deputy commissioner considered the contention of the parties and rightly dismissed the petition filed by the respondent by the order dated so and so. It is relevant to note that as against the order of the grant order passed by the deputy commissioner, an appeal is provided under section 49 of the Karnataka Land Revenue Act. If the respondent agreed by the same, he should have preferred an appeal under section 49 of the Karnataka Land Revenue Act. Apart from that, the respondent has not challenged the Sakvali cheat issued in my favor.
ಇದನ್ನು ಓರಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ವಿ ನಾವು ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ ಈಗ. ಹೌದಾ? ಇದನ್ನೆಲ್ಲ ಇಡೀ ಲೋಕದ ಜನ ಎಲ್ಲ ನೋಡ್ತಿರ್ತಾರೆ. ಅದು ಜಡ್ಜ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋ ಇಂಪ್ರೆಷನ್ ಕೊಡ್ತದೆ. ನಂತರ ಏನೇನೋ ಇನ್ಫರೆನ್ಸ್ ಅನ್ನು ಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಸ್ಕೋಪ್ ಅನ್ನು ಕೊಡ್ತದೆ.
My lord, my submission is this. I am not I am stick on to the other submission, my lord.
It's all right. We are sticking on to that submission. Because again, you may go to other court and you may take my appeal and say many things against me. Where do I go? We are not made parties to the appeal. Fortunately or unfortunately, judges are not, our views are not called for. You can say anything behind us. And advocates will be different. Judges who are hearing them will be different. Papers also will be different. Although these parts may be part of that paper record book. Anything can be said against any judge. ನಾಳೆ ಹೆಂಗೆಲ್ಲ ಆಗ್ಬಿಟ್ರೆ ನಾವೇನ್ ಮಾಡ್ಬೇಕು? ನಿಮ್ಗೆ ಸಿಂಪಲ್ ಆಗಿ ಕಾಣ್ತದೆ. ಬಟ್ ನೀವು ಹೇಳಿದ್ರು ಇರ್ಬೋದು, ಇಲ್ಲ ಅಂತ ನಾ ಹೇಳಲ್ಲ. ಅಥವಾ ಅದು ರೆಕಾರ್ಡ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ನಾವೆಲ್ಲ ಹೆಂಗ್ ಮಾಡೀವಿ ಅಂದ್ರೆ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ಬೇಕು ನಮ್ಮ ಕೋರ್ಟ್ನಲ್ಲಿ. ಓಪನ್ ಕೋರ್ಟ್ ಇದು. ಲೆಟ್ ಪೀಪಲ್ ಸಿ, ಲೆಟ್ ಮಿಲಿಯನ್ಸ್ ಆಫ್ ಪೀಪಲ್ ಸಿ ವಾಟ್ ಈಸ್ ಹ್ಯಾಪನಿಂಗ್, ಹೌ ಲಾಯರ್ಸ್ ಫಂಕ್ಷನ್, ಹೌ ಜಡ್ಜಸ್ ಫಂಕ್ಷನ್ ಗೊತ್ತಾಗ್ಲಿ ಅನ್ನೋದಕ್ಕೆ. ಬಟ್ ಅನ್ಲೆಸ್ that judge who heard this matter had this facility, now we cannot ascertain the truthfulness or otherwise of your submission that you had orally opposed it. You would have taken up that contention. Any writ lawyer would take it. Alternative remedy, send him to the alternate remedy. ಆ ರೀತಿ ಏನು ತೊಗೊಂಡಂಗಿಲ್ಲ ನಿಮ್ಮ objection ದಲ್ಲಿ.
I have not, even the appellant herein has not filed the objection. My submission is this, my lord. The learned single judge has proceeded on the basis that earlier there was an injunction decree against me in respect of the same property. The copies of the decree and appeal, in the appeal, I have preferred appeal as against that. That was confirmed. Both have been produced before this honorable court. That is in the writ petition, my lord. I have produced the annexure. Kindly.
That was recall of grant. Recall of grant was challenged. To cancel, he had sought for cancellation of grant made in your favor.
No, he filed application for rule 25. He has filed application for cancellation of the grant before the learned deputy commissioner.
Correct.
He has rejected that application filed by him.
Correct.
As against, he preferred writ petition before the honorable court. That writ petition was allowed. Initially, he filed application. The grant was made in my favor. He files application before the deputy commissioner for cancel under section rule 25 of the land grant rule.
On what ground cancellation was not allowed by the deputy commissioner?
Please, my lord, the reason is this: because the land granted in my favor and what he has challenged is in his possession is entirely different land. Kindly see annexure K, which is the order passed by the deputy commissioner as against his application.
All right. Show that you are the land loser, that you lost land in Hemavati project.
My lord, the order itself, the order states so, my lord. Kindly see, my lord.
Grant order.
ಹೌದು, the annexure F,
Page.
page number 105 ಮೇಲೆ. ಕೊಡಗು ಜಿಲ್ಲೆ ಪ್ರಸ್ತಾವನೆ. ಕೊಡಗು ಜಿಲ್ಲೆ ಸೋಮವಾರಪೇಟೆ ತಾಲೂಕು ಹಾರಂಗಿ ಜಲಾಶಯಕ್ಕೆ 4 ಎಕರೆ ಹಿಡುವಳ್ಳಿ ಜಮೀನು ನೀಡಿದ ಬದಲಾಗಿ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ BK ಅಚ್ಚಯ್ಯ ಈ ಹಿಂದೆ ಕುಶಾಲನಗರ ಹೋಬಳಿ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ 151 140 ಮತ್ತು 152 135 ಎಕರೆ ಜುಮ್ಲಾ 275 ಎಕರೆ ಮಂಜೂರಾತಿ ನೀಡಿದ್ದು ಸದರಿ ಜಾಗಕ್ಕೆ ತಹಸೀಲ್ದಾರ್ ಸೋಮವಾರಪೇಟೆ ಅವರು ಈಗಾಗಲೇ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡುತ್ತಾರೆ. ಬಿ ಅಚ್ಚಯ್ಯವರಿಗೆ ಹತ್ತೂರು ಗ್ರಾಮದ 1.1ರಲ್ಲಿ 0.85 ಎಕರೆ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ನಂಬರ್ 7 ಆದೇಶದಂತೆ ಸಮಿತಿ ಅಸ್ತಿತ್ವದಲ್ಲಿ ಇಲ್ಲದ ಕಾರಣ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮದಂತೆ ಜಮೀನು ಮಂಜೂರು ಮಾಡಲು ಕಡತದೊಂದಿಗೆ ತಹಸೀಲ್ದಾರ್ ಸೋಮವಾರಪೇಟೆ ಇವರ ಪತ್ರ ನಂಬರ್ 7ರಲ್ಲಿ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿ ಕಚೇರಿ ಹಾರಂಗಿ ಯೋಜನೆ ಹುಣಸೂರು ಇವರಿಗೆ ಪತ್ರ ಬರೆಯಲಾಗಿದ್ದು ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ಈ ಹಿಂದೆ ಸರ್ಕಾರದ ಪುನರ್ವಸತಿ ಸಮಿತಿ ರಚನೆ ಮಾಡಿದ್ದು ಸದರಿ ಸಮಿತಿಯು ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು 86ರ ನಂತರ ಸಮಿತಿಯು ಅಸ್ತಿತ್ವದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಜಮೀನು ಮಂಜೂರಾತಿ ಕೋರಿ ಬರುವ ಯಾವುದೇ ಅರ್ಜಿ ಬಗ್ಗೆ ಸಮಿತಿ ಮುಂದೆ ತಂದು ಕ್ರಮ ವಹಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ ಎಂಬ ಕಾರಣ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮದಡಿ ಮಂಜೂರು ಮಾಡಲು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ.
ಕಳ್ಕೊಂಡಿಲ್ಲ, ನೀವು ಸಂತ್ರಸ್ತರು, ಅಲ್ಲಿಂದ ನಿಮ್ ಡಿಸ್ಪ್ಲೇಸ್ಡ್ ಪರ್ಸನ್ಸ್ ನೀವು.
ಹೌದು, 4.37 acres I have lost, my lord.
ಎಲ್ಲಿದೆ ಅಂತ?
ಅಲ್ಲ, ನಾನು even earlier stated in my earlier writ petition that is extracted, my lord, in the writ petition order which is produced before this honorable court.
ಎಲ್ಲಿದೆ?
That is page number 97, my lord. 97 ಅಲ್ಲಿ there is a mandamus we have filed in that. The petitioner has sought for issuance of writ of mandamus, direct the respondent number 2 to 5 authorities to grant 85 cents of land in survey number in so and so village. The facts of the case: the petitioner is an ex-serviceman served in Kargil sector from 1969 to 1971, and the petitioner originally
ex-serviceman.
How's ex-serviceman?
To issue emergent notice. ಎಲ್ಲಿದೆ ಎಕ್ಸ್-ಸರ್ವಿಸ್ಮನ್ ಅಂತ ತೋರಿಸಿ ನೋಡೋಣ, ಎಲ್ಲಿ ರೆಕಾರ್ಡ್ ತೋರಿಸಿ ಮಿಲಿಟರಿ ಸರ್ವಿಸ್ ಅದ.
Page number 97, my lord. 97 annexure E, para 1 ನಲ್ಲಿದೆ. Page number 99, relevant portion. 99 ಅಲ್ಲಿ. The facts of the case: the petitioner is an ex-serviceman served in Kargil sector from 1969 to 1971.
All issue emergent notice. Interim order as prayed for.
Delayed 98 days.
Status ಕೊತ್ತಳಿ. Status ಕೊತ್ತಳಿ. Please, status quo. Till next date of hearing, learned AGA is requested to accept notice for respondents, official respondents, 2 to 4, emergent notice to response number
1.
Status quo. This interim protection is granted on the assertion of counsel for the petitioner that his client happens to be an ex-serviceman who served in Kargil sector during the period between 1969 and 71, and that he has lost land of the family in Hemavati
Harangi dam
project. First, all right.
Kind permission of this court, my lord. We have purchased the book.
ಅಲ್ಲಿ ಕೊಡಿ, ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು. Did you ascertain why Pandit Nehru said that way?
No, no, because the East India Company, right from the East India Company, 1857 itself, the Christianity came into India. That is
what I said to you.
But
do you remember what I told you?
So Nehru said that Christianity has come.
Christianity came to India
After
before it went to the shore of ಯುರೋಪ್ ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ. ಇದು
That's all.
ಟ್ರೂ ಅಂತ ನಾನು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೆ.
That I'll find out. Please.
ಏನ್ ಕೇಸ್ ಇದು?
Coincidentally, just now my learned brother, just now he left. He is also ex-serviceman, served the country, he's Air Force officer. Now he is struggling hard to retain his a shelter. Here earlier, when I challenged the order passed by the DRT, I approached the Honorable DRT, which is page number annexure C, page number 22, my lord. Page number 22 and 23 operative portion, wherein the DRT set aside the order passed by the DRT and remanded back the matter to DRT. In the 23, paragraph number 23, when I challenged before the order passed by the DRT in DRT, they imposed some conditions, pre-deposit condition. And I complied the 10 lakhs rupees I deposited, which page number 25, my lord. 10 lakhs rupees I already deposited. When I challenged the surpassing proceedings under section 18, there also I deposited a sum of rupees 7 lakhs, which is also available to your lordship.
ಟೋಟಲ್ ಅಮೌಂಟ್ ಡ್ಯೂ ಎಷ್ಟು?
ಅಲ್ಲಿ 40 lakhs claim ಮಾಡ್ಬಿಟ್ಟು, that my amount is laying there. Along with interest, 17 lakhs is available. And 7 lakhs, it's also available with the bank. Kindly see the order passed by the DRT, my lord, for a moment. Which is annexure 8, page number 14, I may permit to read your lordship. In spite of my making submission that my 10 lakhs rupees is already pre-deposit amount is laying in the DRAT with the registry that is not refunded at para number, last page, page number 14, or mentioned is filed challenging the order passed by, so it is also submitted that according to the calculation memo filed before DRT, total amount calculated by the bank comes to rupees 40 lakhs.
ಅದನ್ನೆಲ್ಲ ತಗೊಂಡ್ರೆ 50% ಎಷ್ಟಾಗ್ತದೆ?
40 lakhs ಗೆ 50% ಅಂದ್ರೆ 20 lakhs ಆಗುತ್ತೆ. But DRT has ordered to deposit page number 15, 10 lakhs 13,004 ಆಗುತ್ತೆ. Page number 15. My submission, my humble submission, Lord, when my amount is lying to the extent of 17 lakhs rupees there only, which is carrying interest of 6%, whereas this court has given order to 12%. And moreover, the parallel proceedings also, when I challenge before your before the DRT, there 7 lakhs is also pending. And your lordship kindly see the
All right.
principal amount 550 rupees, my lord. Annexure 46, K 46 page number.
Emergent notice.
Principal 550.
Emergent notice. Interim order as prayed for till next date of hearing. This copy of this order shall be released only after petitioner produces the proof of presentation of the book to the advocates library.
Today, tomorrow is the last day. Today I have to comply this order. Today I have to supposed to comply. Other tomorrow it will be dismissed. Today still I will go.
ಕೊಟ್ಟು ಬಂದ್ಬಿಡಿ.
ಈಗಲೇ ಓಡ್ತೀನಿ. Because I have to protect the shelter of an ex-serviceman, my lord.
All right, on the condition. Petitioner's assurance that today the book would be presented to the Advocates Association Library in the court below at Bangalore is noted. Okay. In the meanwhile, office objections also to be complied with.
Status.
In the meanwhile, the office objections also need to be.
Status.
Status quo. Stay. ನೀವು ಕೇಳಿದ್ರೆ Yes.
Degree holder, PA holder.
Others perhaps may not wait unless very urgent. It's a very little. Okay. Yes, sir. Yes, sir. ಇನ್ನೊಂದು 3-4 ಪಾಯಿಂಟ್ ಇದೆ ಅಂತ ಏನೋ ಹೇಳ್ತೀನಿ ಅಂತ ಅರ್ಥ ಆಯ್ತು.
ಅಲ್ಲ ನೋಡಿ, ಐ ವಾಸ್ ಓನ್ಲಿ ಟ್ರೈಂಗ್ ಟು ರಿಫ್ರೆಶ್ ಸಮ್ ಪಾಯಿಂಟ್ಸ್ ಅಷ್ಟೇನೆ. ತಾವು ಕೇಳಿದ್ರೆ ಅವರು ಡಿಗ್ರಿ ಏನು ಓದಿದ್ದಾರೆ ಅಂತ, ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಅವರು ಡಿಗ್ರಿ ಓದಿದ್ದೀನಿ
ಐ ಎಮ್ ಎ ಗ್ರಾಜುಯೇಟ್ ಅಂತ ಅನ್ಕೊಂಡೆ ಒಂದ್ ಕಡೆ. ಇವ್ರು ಹೇಳಿದ್ದಾರೆ ಶಿ ಇಸ್ ಎ ಗ್ರಾಜುಯೇಟ್ ಅನ್ಕೊಂಡು.
ಅಲ್ಲ, ಅವರು ಅಪ್ ಟು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್, ಹಸ್ಬೆಂಡ್ ಇಸ್ ಎ ಗ್ರಾಜುಯೇಟ್. ಕೇಸ್ ಲಾ ಎಲ್ಲ ಐ ಥಿಂಕ್ ಮೈ ಲಾರ್ಡ್ ದೇ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಗಿವನ್ ಅ ಕಂಪೈಲೇಷನ್ ಅಂತ ಕಾಣುತ್ತೆ.
ಕೊಟ್ಟಾರ?
ಕೊಟ್ಟಿದೆ.
ನೋಡಿ.
Prior court holds, my lord, that these two agreement explanation is there. So we must go by the fact that they've admitted signing, we must go by what is contained in it. And that first agreement contains a clause that cash has been paid. And to that.
P3 is also admitted.
Yes, both are admitted. And
P3 also.
P3 is also, that is endorsement, that is also admitted. That's how it is gone. Only on this question, my lord, of
Readiness and
check
willingness.
dishonor and absence have been denied. Lord, one other factor, my lord, it's already there. In the earlier round, my lord, when the matter had come up before the dishonorable court and been remanded, at that time, my lord, the court, honorable court had
deposit,
directed us to deposit. That has been done also.
Yes.
Please. Your Lordship, may kindly take page 271, exhibit P7, that is the notice issued by the defendant number 1.
$271,
Page 271.
D1's notice,
How D1's notice? Terminating the agreement. Adರಲ್ಲಿ kindly go to 272, last 4 lines.
wrongly typed as.
You
You
had
had also handed over
handed
two
over
post-dated checks.
Post-dated checks bearing number dated 15/2/2004, wrongly typed as 25/2/2004 in the endorsement for 29,80,000, and the other bearing number so and so dated 15/3/2004 for 20 lakhs towards the second installment. You had further agreed to pay balance amount at the time of registration of the sale deed. My client had signed the above endorsement in good faith, hoping that check will be cash on the due dates. However, my client regrets to state that first of the above checks, when presented for realization, was returned unpaid with the banker's endorsement dated 17/2/2004 with remark, effects not yet clear.
No, wrongly typed as 25/2/2004 ಅಂದ್ರೆ ಏನದು?
ಅದ್ ನಾನು ಹೇಳ್ತೇನೆ with
Effects not yet.
not yet clear. Please present again. Accordingly, check was presented again. But the second time, check was again returned unpaid with the banker's endorsement dated 21/2/2004 with remark, insufficient funds. My client's efforts to contact you till today has been futile. My client has completely lost faith. As such, she wishes to revoke the agreement.
Yes.
Your Lordship may kindly see, check dated 15/2 is something that is specifically mentioned. Then it is also mentioned that it was presented and returned on 17/2, not on the ground that check is presented prior to the date
Let us see the check,
Yes, inscribed or not.
original check ಕೊಡಿ. Documents. $25 ಅದು.
ಅವರು 25 ಚೆಕ್ ಕೊಟ್ಟಿದ್ರು. ನಮ್ಮ ಪ್ರಕಾರ 25 ಚೆಕ್ ಕೊಟ್ಟಿದ್ರು. ಶಾಂತಾ ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಅಂತ ಬರೆದಿದ್ರು. ಹಾಗಾಗಿ ಅವು ಎರಡೂ ಚೆಕ್ ಅನ್ನು ಅವ್ರಿಗೆ ರಿಟರ್ನ್ ಕೊಟ್ಟು ನಮಗೆ ಮತ್ತೆರಡು ಚೆಕ್ ಕೊಟ್ಟು ಆ ಚೆಕ್ ಅವ್ರ ಡೇಟ್ 15/2 ಇದ್ದು. ಅದಕ್ಕಾಗಿ ಅವ್ರ ನೋಟಿಸ್ ರಿಪ್ಲೈನಲ್ಲಿ ಕಾಂಟ್ರರಿ ಟು ಅವರ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಅಂತ ಹೇಳ್ತಾರೆ.
15/2.
ಹೌದು, 15/2 ನಂಬರ್ ಬೇರೆ ಇದೆ. There is no, I am not denying that. This check number is different. It was 15/2. It was presented.
ಇಲ್ಲಿವರೆಗೆ ನೀವು ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದೆ ಎಷ್ಟು?
ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದು ಕ್ಯಾಶ್ ಅನ್ನು ತಗೊಂಡಿದ್ದೇವೆ ಅಂತೇಳಿ ಫೈಂಡಿಂಗ್ ಇದೆ. ಸೊ ಲೆಟ್ ಅಸ್ ಟೇಕ್ ಕ್ಯಾಶ್ ಇಸ್ ಆಲ್ಸೋ ಪೇಡ್. ದಟ್ ಈಸ್ 25 lakhs.
25 ಲಕ್ಷ ಮಾತ್ರ.
25 ಲಕ್ಷ ಮಾತ್ರ.
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ? 20,000 ಚೆಕ್ ಅಷ್ಟೇ. 25 lakh is admitted. ಅಲ್ಲಿ ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ is there a clause for forfeiture if there is non-compliance?
Non-compliance ಗೆ ಇದೆ, ತೋರಿಸ್ತೇನೆ, ಅದನ್ನು ತೋರಿಸ್ತೇನೆ. ಒಂದೇ ನಿಮಿಷ, ನಾನು ಇದನ್ನೊಂದು ಈ ಪಾಯಿಂಟ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. This is the specifically saying ಇಂಥ ಚೆಕ್ಕು ಇಂಥ ದಿವಸ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದೇವಿ, ಇಂಥ ದಿವಸ ಇದೆ. Now your lordship may kindly see the reply.
Yes.
Our reply, it starts at page 275.
You are right.
3/3/2004. ಅದರಲ್ಲಿ your lordship may kindly see para 3.
277
ಹೌದು,
ಅಲ್ಲಿ ಸ್ವಲ್ಪ
277
ಅರ್ಧದಿಂದ ಸ್ವಲ್ಪ ಕೆಳಗಡೆ ಬನ್ನಿ.
ಹೌದು, ಕೆಳಗಡೆ para 3 and 4, 3, 4 and 5.
Correct. Pursuant to.
Please, madam. Pursuant to the same, our client issued 2 post-dated checks in your client's favor. Checks bearing number so and so, dated 25/2/2004 for a sum of so and so. The date has been mentioned as 25/2/2004 because both the parties had agreed that the check is to be presented only on or after 25/2. 25/2 ಅಂತ ಬರೆದ್ರೆ ಅದಕ್ಕಿಂತ ಮೊದಲು ಕೊಡೋ ಪ್ರಶ್ನೆ ಅಂತೂ ಬರೋದೇ ಇಲ್ಲ.
Correct.
On or after 25/2/2004 for encashment. However, your client did not comply with the terms of the agreement and has not so far applied for conversion of the land for non-agriculture commercial purpose to enable the completion of the sale transaction. Our client specifically instructed your client not to present the check for encashment before 25/2/2004. This sentence would not have been there if there was no check of an earlier date.
Yes.
Our client specifically instructed your client not to present the check for encashment before 25/2/2004 as referred to in the endorsement dated so and so. However, your client had, contrary to the undertaking between the parties, presented the check earlier and got the same return twice prior to the said date with ulterior motive. ಬೇರೆ ಏನೋ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದೆ ನಮ್ಮಲ್ಲಿ, ಯು ಹ್ಯಾಡ್ ಅಂಡರ್ಟೇಕನ್ ನಾಟ್ ಟು ಪ್ರೆಸೆಂಟ್ ಇಟ್
ಆ ಕ್ವಶನ್ 15/2 ಇದ್ರಷ್ಟೇ ಆ ಕ್ವಶನ್ ಹೇಳ್ತದೆ. ಅದರ್ವೈಸ್ ವುಡ್ ನಾಟ್.
ಅದರ್ವೈಸ್ ಇದು ಯಾವುದೂ ಹೇಳೋ ಪ್ರಶ್ನೆನೇ ಬರ್ತಿರ್ಲಿಲ್ಲ. ಅಂದ್ರೆ ಈ ವಿಷಯ ಅವರು ಪ್ಲೇಂಟ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡೋದಕ್ಕಿಂತ ಮೊದಲೇ ಅವರಿಗೆ ಈ ವಿಷಯ ಗೊತ್ತಿತ್ತು ಇಲ್ಲ ಅನ್ನೋದು ಒನ್ ಆಫ್ ದಿ ಕ್ವಶನ್ ದಟ್ ಮೈಟ್ figure. Therefore, this is what is the answer. Then, my lord, in the plaint, how it is put up is, it starts from page 1. Kindly go to page 6. After 4 lines, the defendant tried to encash one of the checks aforementioned without even applying for conversion of lands and without fulfilling her part of the obligation. In fact, she presented the check contrary to the agreement between the parties. The plaintiff on 25/2/2004, in order to cajole the defendant, even purchased a demand draft for rupees 20 lakhs, favoring the defendant, and called upon her to collect the said amount of said demand draft, in spite of her not fulfilling her obligations. However, defendant failed and neglected to collect the demand draft. Thereafter, the defendant herein got issued a completely untenable legal notice dated so-and-so through her advocate purporting to terminate the agreement of sale. Such purported termination is wholly untenable. A previous sentence ನೋಡಿದ್ರೆ ಚೆಕ್ 25/2 ನೀವು ಮೊದಲೇ ಕೊಟ್ರಿ ಅಂತ ಹೇಳಲ್ಲ, ಕಾಂಟ್ರರಿ ಟು ದಿ ಅಗ್ರಿಮೆಂಟ್ ಅಂತ.
Yes.
Untenable and is impermissible since law does not permit unilateral termination of a solemn agreement. Plaintiff sent a reply to the notice. Copies of legal notice dated 25/2/2004 and reply notice is produced. It is submitted that in the notice, defendant mischievously alleged that the check issued by the plaintiff was returned. This happened as check was presented before the date inscribed on it. Further, without bothering to contact the plaintiff to ascertain the correct legal position, defendant got issued the said untenable legal notice.
ಅಲ್ಲ, ನಿಮ್ ನೋಟಿಸ್ ನಲ್ಲಿ ನಾವು ಆ ಮೊದ್ಲಿದ್ದಂತ ನೋಟಿಸ್ ಚೆಕ್ ಗಳನ್ನ ನಿಮ್ಗೆ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಇದು ಅಂತ ಅದೆಲ್ಲಿದೆ ಅದು
ಇದು ಬಂದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಈ ಚೆಕ್ ಆ ಚೆಕ್ ಅವ್ರಿಗೆ ರಿಟರ್ನ್ ಕೊಟ್ಟು ಅವ್ರು ನಮಗೆ ಇದನ್ನ ಕೊಟ್ರು
ಅಂತ ಎಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್
ಅದು ನೋಟಿಸ್ ನಲ್ಲಿ ಬಂದಿಲ್ಲ. ಬಟ್ ಡೇಟ್ 15/2 ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದ್ದಂಗೆ 25/2 ಅಲ್ಲ ಅಂತ ಬಂದಿದೆ.
ನಿಮ್ಮ ನಿಮ್ WS ನಲ್ಲಿ ಎಲ್ಲಾರ ಒಂದ್ ಕಡೆ ಹೇಳಿದಿರ ಅದನ್ನ?
WS ಇದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೆ ಬರಲ್ಲಿವರೆಗೆ ಈ ಪಾಯಿಂಟೇ ಇದಾಗಿರ್ಲಿಲ್ಲ. ದೇರ್ ವಾಸ್ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಅಬೌಟ್ ದಿ ಚೆಕ್. ಇದು ಆಗಿದ್ದು ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಲ್ಲಿ ಈ ಕ್ವಶನ್ ಕೇಳೋದಕ್ಕಿಂತ ಮೊದಲೇ an application was made by them putting the date, check number and the date, and to calling upon me to produce it. We filed objection saying those are already returned to you. You are in the custody. ಅದ್ರ ಬದಲು ಬೇರೆ ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಿ, ಇಂಥ ಮಿಸ್ಟೇಕ್ ಆಗಿತ್ತು, ಅದ್ರ ಬಗ್ಗೆ ಬೇರೆ ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಿ ಅಂತೇಳಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು. ಅದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ಬೈ ದಿ ಲರ್ನೆಡ್ ಜಡ್ಜ್ ಸೇಯಿಂಗ್ they are saying it is in your possession, you are saying it is in their possession. Ultimately, it's a matter which will be considered, whatever it is, adverse inference can be drawn against any of the parties. Until that application was rejected. It is only at that stage it came to the Avaga. We filed an application and evidence at that stage was closed. PW1 evidence cross-examination was closed and put to defendant's evidence. We made application for recalling the PW1 and also recalling that order rejecting the one application, some application. Those were rejected on 3/2/21. They were rejected on 3/2/2012. In the meanwhile, we filed the application for amendment, IA number 26. to amend the written statement to state this fact that original checks were returned because name was wrongly shown, etc. That application was filed on 31/1/2012. Other applications for recalling, etc. were also filed. First, the other applications to recall was rejected on 3/12 and on 4/12/2012.
3/2/2012 ಅಲ್ವಾ?
3/2/2012 earlier decree
Rejection.
ಆಗೋದಕ್ಕಿಂತ ಮೊದಲೇ.
ಅದೇ ರಿಕಾಲ್ ಆಫ್ ವಿಟ್ನೆಸ್ಗೆ ಅವ್ರದ್ದು ಡಿಡ್ ನಾಟ್ ಅಗ್ರಿ ವಿತ್
3/12ಕ್ಕೆ ಇದು ಮಾಡಿದ್ರು. ಈ ಅಪ್ಲಿಕೇಶನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನ 4/2/2012ಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ದಟ್ ಇಸ್ 617.
ಹೌದು, ಆರ್ಡರ್ 6 ರೂಲ್ 17.
On
4/2/2012.
That was challenged in WP.
That was challenged in WP, filed on 13/2/2012.
WP dated, the number?
49562, 4959.
Four nine five six two two
56.
two.
ಅಲ್ಲಿಂದ 4959. TO2.
9562 ದಿಂದ
9562 ಅಲ್ಲ, 4956.
56.
ಅಲ್ಲಿಂದ 4959. 3 ನಂಬರ್. ಯಾಕಂದ್ರೆ ಆ ರಿಕಾಲಿಂಗ್ ದಿ ವಿಟ್ನೆಸ್ ಅವು ಮೂರು ಐಯನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು.
ಆಫ್ 2012.
2012 on 13/2/2012.
ವೆರಿ ವೆಲ್. ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸೈಡ್ ಆಯ್ತಾ ಇದು?
ಇಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡು. ಇಟ್ ಹ್ಯಾಡ್ ಅಲ್ಲಿ ವಿಟ್ನೆಸ್ ಇದ್ರೊಳಗೆ ಇದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗಿಗೆ ಪೋಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ. It was posted for preliminary hearing on 23/2/2012.
Filed on 13.
Filed on 13/2.
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಯಾವತ್ತು ಬಂತದು?
23/2/2012ಕ್ಕೆ ಬಂತು. ಅದವತ್ತು ಸುಮಾರು 12 ಕಾಲಿಗೆ ರೀಚ್ ಆಯ್ತು. ಅಷ್ಟೊತ್ತಿಗೆ ರಿಸ್ಪಾಂಡೆಂಟ್ ಮೇಡ್ ಎ ಸಬ್ಮಿಷನ್ ದಟ್ ಮಾರ್ನಿಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಸ್ ಪ್ರೊನೌನ್ಸ್ಡ್, ಸೂಟ್ ಇಸ್ ಡಿಕ್ರೀಡ್.
ಹಂಗಾಗಿ ಇದು ಇನ್ಫೆಕ್ಚುಯಸ್ ಅಂತ ಮಾಡಿ.
On preliminary hearing itself, it is on that day itself order is passed saying it has become infructuous.
ಇಷ್ಟೇ ಆರ್ಡರ್.
It was rule was not issued, it was not admitted or anything. They had appeared by filing caveat.
ಅದು ಡಿಗ್ರಿ ಯಾವತ್ತಾಗಿತ್ತು?
ಅದೇ 23/2/2012 ಅವತ್ತೇ. ಅವರು ಬೆಳಿಗ್ಗೆ ಪ್ರೊನೌನ್ಸ್ ಆಯ್ತು, ಸೂಟ್ ಡಿಗ್ರಿ ಆಗಿದೆ ಅಂತ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು. ಇಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ಇನ್ಫ್ರಕ್ಚುಯಸ್. Against the decree, we preferred RFA 852 of
ಅದೇನೋ ರಿಮ್ಯಾಂಡ್ ಆಗಿ ಸೂಟ್ ರಿವೈವ್ ಆಗಿ
2012 ರಿಮ್ಯಾಂಡ್ ಆಯ್ತು. ರಿಮ್ಯಾಂಡ್ ಆಗ್ಬೇಕಾದ್ರೆ ಬಹಳ ದಿವಸದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ ಇದು ಸೂಟು. ಇವರಿಗೆ ಯು ಗಿವ್ ಅಪಾರ್ಚುನಿಟಿ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ PW1 and to adduce their evidence and complete it within 3 months ಅಂತ ಹೇಳೋ ಏನೋ ಒಂದು ಇದನ್ನ ಮಾಡಿದ್ರು. RFA 852 of 2012. Order 24/6/2013.
Opportunity to cross examine
PW1 and to adduce evidence ಅಂತ ಹೇಳಿ ಕೊಟ್ಟು. ಅಂದ್ರೆ ಆ ಅಬ್ಸರ್ವೇಷನ್ ಬಂತು, ಅದಕ್ಕೆ ಕನ್ಫೈನ್ ಮಾಡ್ರಿ ಅಂತೇಳಿ ಹೇಳಿದಾಗಲ್ಲ, But that observation came, give opportunity to cross-examine. So ಈ ಐಎದ ಬಗ್ಗೆ ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಕೇಳೋದಕ್ಕೆ ಹೋದಾಗ ಈ ಐಎ ರಿಜೆಕ್ಟ್ ಆದ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿಲ್ಲ. Therefore, I cannot take up that IA afresh. Was the
ನಿಮ್ಮ
Order 6 Rule 17.
ನಿಮ್ಮ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ did you ever in terms of order 43 rule 1 capital A saying the rejection of order 6 rule 17 application is bad ಅಂತ ಎಲ್ಲಾದ್ರೂ ಹೇಳಿದ್ರ? ತೋರಿಸಿ. ಅವಾಗ ಈ ಪ್ರಶ್ನೆ ಬರ್ತದೆ.
ಅದನ್ನ ನಾನು ನೋಡಿ ಹೇಳ್ತೇನೆ. ಐ ಆಮ್ ನಾಟ್ ಶೂರ್. ಅಲ್ಲಿ ನಾವು ಹೋಗಿ ಈ ಐಎದ ಬಗ್ಗೆ ಮಾತಾಡೋದಕ್ಕೆ ಹೋದಾಗ ಈ ಐಎದ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬಂತು. ಅದು ಬಂದಿದ್ದಕ್ಕಾಗಿ we made an application for recalling the order, dismissing it as infructuous. WP ಅಲ್ಲಿ we made an application.
ಅದರಲ್ಲಿ ಇದು ರಿಸ್ಟೋರ್ ಆದ್ಮೇಲೆ
WP ಅಲ್ಲಿ now that the suit is restored, please
Consider it.
recall the earlier
WP order recall ಮಾಡಿ
recall ಮಾಡಿ matter may be taken up.
ಅವ್ರೇನು
Amendment application ಅನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ that was rejected, saying you go and if at all you are aggrieved, it is to be raised in the appeal to be filed.
So 43 1A ಬಿಟ್ರು.
That
was reserved.
That happened on recalling application 26/8/2004 order ಆಯ್ತು. ಅದನ್ನ ಅವಾಗ ಒಂದ್ಸಲ ಕೊಟ್ಟಿದೆ. ಇಟ್ಸ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ರೆಕಾರ್ಡ್. ಬಟ್ ಎನಿವೇ ಇದು just for the
ಮೆಮೊ ಜೊತೆ ಫೈಲ್ ಮಾಡಿರಾ?
ಫೈಲ್ ಆಗಿದೆ. ಅವು ಎಲ್ಲ ಆರ್ಡರ್ಸ್ ಇದಾವೆ.
ಅದು ಆ ರೀತಿನ ಆರ್ಡರ್ ಮಾಡ್ಯಾರ ಅವ್ರು ಹೇಳ್ದಂಗೆ ಅಲ್ವಾ? ಸೊ 43 1A ಇಂಟ್ಯಾಕ್ಟ್ ಆಗ್ತದ ಅವಾಗ.
ಹೌದು. ಇದು ಅದರಲ್ಲಿ ಪ್ಯಾರಾ 4 ತಾವು ನೋಡ್ಬೋದು ಈ ಆರ್ಡರ್ ನಲ್ಲಿ.
That did not plead any ground, my lord, in the first appeal, as far as amendment is concerned. Cover
Para 4, your lordship may kindly see. It is the case of Shri
Considered by the court is not tenable. The remedy, if any, is for the petitioner to approach this court in its applied jurisdiction to any further direction. So 43 1A is kept intact.
Kept intact would be our submission. Then ultimately, suit was dismissed on 13/1/2015, the present appeals. In the present, when this present appeal was filed, apart from raising that as a defense that could be raised, etc., I have filed an appeal seeking that this amendment should have been allowed.
Appeal ಹೆಂಗ್ ಮೇಂಟೈನ್ ಆಗ್ತದೆ?
ಯಾಕೆ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ ಅಂತಂದ್ರೆ there are two judgments of the Supreme Court. If ಇದು something had become final ಅನ್ನೋ ಹಾಗೆ ಆದರೆ ನಾವು ಇದನ್ನೇ ರೇಸ್ ಮಾಡಬೇಕು. ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಪೀಲನ್ನೇ ಫೈಲ್ ಮಾಡಬೇಕು. ಇದಾದ್ರೆ ಏನು ದೋ ವಿ ಆರ್ ಅಲೌಡ್ ಟು ಟೇಕ್ ದಟ್ ಆಸ್ ಎ ಡಿಫೆನ್ಸ್ ಅಂಡ್ ರೇಸ್ ಇಟ್ ಇದ್ರೂ ಸಹಿತ as a matter of abundant precaution, we've also filed it as an appeal.
The appeal is always against the decree.
43 1A, the ground and
you can urge, you not challenge also. The order which has been passed during the trial of the suit need not be challenged. When you suffer
if I succeed, I can raise it as defense. If I fail, I will have to take it as a ground.
How the appeal is maintainable against a finding?
Now, we did not want to take any chance at all. So, that
by abundant caution,
as
you want us to, I think then order 41 rule, yado one rule nalli, the appellant without filing an appeal can make submission in justification of the or attack a finding which has gone against him ಅನ್ಕೊಂಡು ಒಂದು ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಿದೆ. Order
41 rule 22.
Yeah, there is a famous judgment in fact on that. Yes. 105. which is not appealable, and main appeal.
Order
Mark
6
up.
rule 17 is not an appealable
Not
order.
a-
where
not an
filed
appealable.
adversary. So this
43(1) ಕೆಳಗಡೆ ಅದು enlist ಆಗಿಲ್ಲ. Rejection of application under order 6 rule 17 is not one.
not
of
an
the
appealable
items
order under order 43 rule.
43(1). Okay, all right. Understood.
There, I have sought to narrate how and why these checks were, different checks were issued. 2 checks were returned back. These 2 checks were issued. Earlier, the name that was written was Shanta Srinivasa Murthy. Actually, it should have been Shanta Srinivas.
ಅಷ್ಟೇ.
ಮೂರ್ತಿ ಅನ್ನೋ ಇದು ಇರ್ತಿರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಅವು ಎರಡನ್ನ readily they had given the replaced the checks. Now, my lord, it is too strange a coincidence to say same amount in a check book, we must be having some other transaction. Therefore, I had issued to the same party. And the rejection, one of the reasons that is sought to be given by the court below is, it would be like you are introducing a new case after they filed an application for production of the other check dated 25/2/2004 bearing number so and so. It is for countering that. Now, as an afterthought, you have filed this application. It amounts to introducing a new case. Therefore, application is rejected. In substance, this is the main reason for rejection of the application. Whether 2 checks were issued, replaced, etc., was if amendment was allowed. In my evidence, if I failed to substantiate it, it could have been rejected as a contention. But to reject the amendment itself was wrong.
Yes.
In fact, check was dated 15/2 is something which I have specifically stated in the notice issued prior to the filing of this suit. It's not that something is
First time.
it comes in. It was in the notice itself, it was issued, and in the reply, in an implied manner, he says, yes, but we had agreed that it should be presented on or after 25/2. Contrary to our understanding and undertaking, you have presented it, was the reply.
Yes.
Then, my lord, all other contentions with regard to this is taken. Now, your lordship may kindly go to exhibit P2.
But in your appeal in RFA 852 of 2000.
That I'll check up.
Just check and
yes,
tell us. It's also relevant.
Please. ಹಳೆ appeal ನಲ್ಲಿ grounds.
Because by that time,
ಅಲ್ಲ,
already it was rejected.
Writ ಹಾಕಿ writ
Correct. That's right. But that was already rejected.
How?
Thereafter, you filed a
appeal.
In appeal, did you take up the ground that this rejection could not have been done?
Check ಮಾಡ್ಬೇಕ್ರಿ. Your lordship may kindly see exhibit
Because-
P2, my lord. That will.
Because court gave liberty to you while rejecting your application for recall of the WP order. Court in so many days alerted you. ಹಿಂಗ್ ಮಾಡ್ಬೇಕು ನೀವು ಅಂತ. ಲಾಸ್ಟ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ದಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಇಲ್ಲ ರಿಕಾಲಿಂಗ್ ಆರ್ಡರ್ ಅಪೀಲ್ ಮುಗಿದ ಮೇಲೆ,
ಅಪೀಲ್ ಅಲ್ಲ,
ಅಪೀಲ್ ಅಷ್ಟೊತ್ತಿಗೆ ಅಲೋ ಆಗಿ ರಿಮಾಂಡ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು. ನಾವು
ಅಪೀಲ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಬಂತು ಅಂತ
ಹೌದು, ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅದನ್ನ ರೇಸ್ ಮಾಡಿದ್ವಿ. ಕೋರ್ಟ್ ಪಾಯಿಂಟ್
ಡಿಗ್ರಿ ಮಾಡ್ಬೇಕು, ಡಿಗ್ರಿ ಆದಾಗ ಮುಂಜಾನೆ ಡಿಗ್ರಿ ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ ಅವತ್ತಿನ ದಿವಸನೇ WP ರಿಜೆಕ್ಟ್ ಆಯ್ತು,
ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಅಂತ.
ಹೌದು,
ಅಲ್ಲಿದು ಬರ್ಲಿಲ್ಲ,
ಅಲ್ಲಿದು ಬರ್ಲಿಲ್ಲ.
ನೀವು ರಿಕಾಲ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೋಗೋ ಅಷ್ಟೊತ್ತಿಗೆ ಅದು ಇನ್ಫ್ಯಾಕ್ಟ್ ಅಪೀಲ್ ಅಲೋನೇ ಆಗಿ ಹೋಗಿ
ಆಗೋಯ್ತು.
Then you stand. You are right. You are right.
Please,
You are right.
your lordship may kindly go to exhibit P2, that would be page 223. ಅದರದ್ದು ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಇದೆ. ನಾವು ಮೊದಲೇ ರೆಫರ್ ಮಾಡಿದ್ದು ಟೈಪ್ಡ್ ಕಾಪಿ ಆದ್ರೆ ಐ ವಿಲ್ ಟೈಪ್ಡ್ ಕಾಪಿ.
ಜೆರಾಕ್ಸ್ ತೊಳಿ, ಜೆರಾಕ್ಸ್ ತೊಳಿ, ಯಾಕಂದ್ರೆ ಟೈಪ್ ನಲ್ಲಿ ಒಂದ್ಸರಿ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗೋ ಪಾಸಿಬಲ್.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್, ಅದರಲ್ಲಿ your lordship may kindly see page 225 ಬಾಟಮ್ ನಲ್ಲಿ ಕಂಡೀಷನ್ಸ್ ಎಲ್ಲ ಶುರು ಆಗುತ್ತೆ.
Correct.
Kindly come to 226.
Ah.
Same for a total consideration of so and so. 74,80,000 only. The said consideration amount shall be paid by the purchaser to the vendor as under.
Correct.
A sum of 22,30,000 is paid cash by the vendor to the purchaser this day.
27,30,000, 2,70,000, ಅವೆರಡನ್ನು ಬಿಟ್ಟು ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಬನ್ನಿ.
ಅಲ್ಲಲ್ಲ, by purchaser to the vendor ಅಂತ
ಏನೋ ಬೈ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಆಗಿದೆ. ಆಮೇಲೆ kindly see the receipt of that amount is acknowledged ಅಂತ ಬಂತು. Roman 2. A sum of rupees 34,80,000 on or before 5/3/2001.
Correct.
ಇದು 17/2/2001 ಅಗ್ರಿಮೆಂಟ್. 5/3/2001 ಈ ಅಮೌಂಟ್ ಅನ್ನ ಕೊಡಬೇಕು ಅಂತ. The other amount of 15 lakhs on the date of registration. ಇದರ ಮುಂದಿನ ಕಂಡೀಷನ್ which was highlighted by the appellant, page 227. The sale deed shall be executed within 60 days from the date of execution of this agreement, or within a period of 7 days from the date of receipt of NOC under chapter 20C and certificate under section 230A of the Income Tax Act and the order of conversion to non-agricultural use under section 95 of the Karnataka Land Revenue Act, whichever is later. There is no question of dissecting this sentence. Everywhere it is and that is used. ಈ ಮೂರೂ ಕೆಲಸಗಳು ಮುಗಿದರೆ whichever is later, ಅಲ್ಲಿಂದ 60 days ನಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಇದು ಎಲ್ಲದೂ ಮುಗಿದು 60 days ಗೆ.
Correct.
On the obtaining of the above, vendor shall intimate the purchaser of the same in writing and also furnish a copy of the certificate and per order to them. Then both the parties shall file the statement in so and so before appropriate authority constituted under the Income Tax Act. If the appropriate authority acquires the property, ಅದು ಎಲ್ಲದನ್ನೂ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಾದ ನಂತರ the relevant condition would be page 231, para 8.
The vendor
hand over all the original documents of title relating
vendor English ನಲ್ಲಿ ಇನ್ನೊಂದು ಇದೆ. Vendor hands over ಏಕವಚನ ತೃತೀಯ ಪುರುಷ ಆಗ್ತದೆ. Vendor God blesses. Vendor hand over ಅಂದ್ರೆ ವೆಂಡರ್ ಅನ್ನು ಕೊಡಲಿ ಅನ್ನೋ ಅರ್ಥ ಇದೆ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ. ಹಾಗೆ ಏನಂತ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನಾವು? ಹ್ಯಾಂಡ್ಸ್ ಓವರ್ ವೆಂಡರ್ ಶುಡ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಅನ್ಬೇಕಾದ್ರೆ ಈ ಅರ್ಥ ಅಂತ ಹೇಳ್ತಾನ ರೆನೆನ್ ಮಾರ್ಟಿನ್.
ಇದು ದಿಸ್ ಈಸ್ ಶುಡ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಅನ್ನೋದೇ ಅರ್ಥ. ಯಾಕಂತ ಹೇಳ್ತೇನೆ, ದ ವೆಂಡರ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಆಲ್ ದಿ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆಫ್ ಟೈಟಲ್ ರಿಲೇಟಿಂಗ್ ಟು ದಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ and grant a power of attorney in favor of the purchaser or their nominees, authorizing them to apply for conversion of the land. And
On receipt of second installment
and to
of
do
30
all acts necessary in this regard, in that regard, before the appropriate authorities, on receipt of the second installment of 34,80,000 as stipulated in clause 2 above. ಇಲ್ಲಿ 3 ಶಬ್ದಗಳು ಅವರ ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ಹೊಂದೋದಿಲ್ಲ, ಅವು ದೇ ಬಿಕಮ್ ಡಿಫರೆಂಟ್. authorizing them to apply for conversion. Earlier, vendor should get this converted, etc. ಅಂತ ಹೇಳೆಲ್ಲ ಹೇಳಿದ್ರು. ಇಲ್ಲಿ authorizing them to apply for conversion, issue a power of attorney, all these things, the responsibility was shifted to them. Ali vendor should, that earlier sentence is adu page 230 condition 11.
Correct.
ಅದರಲ್ಲಿ ನೋಡಿದ್ರೆ
ನೋಡಿದೆ ನಾನು.
The vendor undertakes to apply for conversion of the scheduled property.
ಅಲ್ಲಿ ಅವ್ರದ್ದೇ ಅಬ್ಲಿಗೇಷನ್ ಮಾಡ್ಕೊಂಡಾರೆ.
ಹೌದು,
ಪಾರ್ಟ್ ಅವೇ ಮಾಡ್ಯಾರೆ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
ಇಲ್ಲಿ ಫೈಲಿಂಗ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಸಹಿತ ಇಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಖರ್ಚೆಲ್ಲ ಅವರೇ ಕೊಡಬೇಕು, ಅವರೇ ಖರ್ಚೆಲ್ಲ ಕೊಟ್ಟು ಕನ್ವರ್ಷನ್ ಫೈನ್ ಎಲ್ಲ ಕೊಟ್ಟು ಮಾಡಬೇಕು. ಅಕಸ್ಮಾತ್ ವೆಂಡರ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಿದ್ರೆ ಅದನ್ನ ರಿಯಂಬರ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಕಂಡೀಷನ್ ಇತ್ತು. ಇಲ್ಲಿ ಅದು ಅಷ್ಟನ್ನು ಅವರಿಗೆ ಕೊಟ್ಬಿಟ್ರಿ. ನಾವು ಖರ್ಚು ಮಾಡಿ ರಿಯಂಬರ್ಸ್ ಮಾಡೋದು ಅಥವಾ ಇಂಥದ್ದು ಯಾವುದೂ ಇಲ್ಲ. ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಎಲ್ಲದೂ ನಿಮಗೆ ಆಥರೈಸಿಂಗ್ ದೆಮ್ ಟು ಅಪ್ಲೈ. And that would be done on receipt of the second installment. It is very specifically stated. Question of first clause, second clause, etc. will not come because it gives the specific state, it makes a specific statement that original should be handed over, power of attorney should be executed, authorizing them to apply for conversion on receipt of the amount.
Suppose ಈ ದುಡ್ಡು ನೀವು ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ,
ಅವರು ಸೆಕೆಂಡ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಇನ ರೊಕ್ಕ ಕೊಡಲ್ಲಿವರೆಗೂ ನಾವು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಕೊಡೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ.
ಕರೆಕ್ಟ್. ಅಗ್ರೀಡ್.
ಆವಾಗ ವೆದರ್ ದೇ ಹ್ಯಾಡ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ದಿಸ್, ವೆದರ್ ದೇ ವರ್ ರೆಡಿ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್, ಅದೆಲ್ಲ ಒಂದು ಪ್ರಶ್ನೆ ಬೇರೆ.
ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪ್ಯಾರಾಗ್ರಾಫ್ 3. ಎಲ್ಲಿದೆ? ಕಾನ್ಫ್ಲಿಕ್ಟೇ ಇಲ್ಲ ಎರಡರ ನಡುವೆ.
ನಾನು ಹೇಳೋದು
ನೋಡಿ, ನಿಮ್ಮ ಡ್ಯೂಟಿ ಇದನ್ನೆಲ್ಲ ವೆಂಡರ್ಸ್ ಈವನ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 54, 55, 56, 57 ಆಫ್ ದಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್, ಇಟ್ ಇಸ್ ವೆಂಡರ್ಸ್ ಡ್ಯೂಟಿ ಇದೆ.
ವೆಂಡರ್ಸ್ ಡ್ಯೂಟಿ.
ನೌ ವಿ ಹ್ಯಾವ್ ಟು ರೀಡ್ ದೀಸ್ ಪ್ರಾವಿಷನ್ಸ್ ಕನ್ಸಿಸ್ಟೆಂಟ್ ವಿತ್ ದೋಸ್ ಪ್ರಾವಿಷನ್ಸ್. ನಂಬರ್ 1. ಲೆಟ್ ಅಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ 3 now.
Please. The sale deed shall be executed within 60 days from the date of execution of this agreement.
Correct.
Or within a period of 7 days from the date of receipt of NOC under Chapter 20C and certificate under 230A of the Income Tax Act, and the order of conversion to non-agricultural use under Section 95 of the KLR Act, whichever is later.
Correct.
Whichever is later.
ಇದೇನ್ ಹೇಳ್ತದೆ? ನಿಮ್ ಮೇಲೆ ಕಂಡೀಷನ್ ಇದೆ ಅಂತ ಒಪ್ತೀರಾ? ಈ ಕಂಡೀಷನ್ ಡೈಲ್ಯೂಟ್ ಎಲ್ಲಿ ಆಗಿದೆ? ಇದರಲ್ಲಿ
ಅದ್ರಲ್ಲಿ ಡೈಲ್ಯೂಟ್ ಆಗಿದೆ. ಇಷ್ಟೇ ಡೈಲ್ಯೂಟ್ ಆಗಿದೆ. ಏನಂದ್ರೆ ಆಥರೈಸ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಎ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಆಥರೈಸಿಂಗ್ ಹಿಮ್ ಟು ಡೂ ಆಲ್ ದಟ್. ಅದು ಯಾಕೆ ಅಂತ ಅಂದ್ರೆ ಕೈಂಡ್ಲಿ ಸಿ ಕಂಡೀಷನ್ ನಂಬರ್ 9.
ಈ ದುಡ್ಡು ಕೊಟ್ರೆ ಮಾತ್ರ ನೀವು GPA ಕೊಡ್ತೀರಿ.
ಹೌದು.
ಅದರ್ವೈಸ್ ಇಲ್ಲ. ಅವಾಗ ಈ ಕ್ಲಾಸ್ ಅಪ್ಲೈ ಆಗಲ್ಲ.
ಅದು ಲೇಟರ್ ಅಂತ.
That will not kill this clause ಅಂತ ನಾ
ಹೌದು. ನಾವು ಅದನ್ನ ಕನ್ವರ್ಷನ್ ಮಾಡಿಸೋದಕ್ಕೆ ಆ ಸ್ಟೆಪ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಸೆಕೆಂಡ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟಿನ ಪೇಮೆಂಟ್ ಆಗಬೇಕು.
ಅಲ್ಲ, ಈ ಕಂಡೀಷನ್ ಸ್ವಲ್ಪ ನಿಧಾನವಾಗಿ ಮೈಂಡ್ ಅಪ್ಲೈ ಮಾಡಿಕೊಳ್ಳಿ. 3 and 8 are to be harmoniously read ಅಂತ ನೀವು ಹೇಳೋದು.
ಹೌದು,
ನಾವು ಹಂಗಂತ ಇಲ್ಲ. ಈಗ ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೇವೆ.
ಆಯ್ತು.
Come to his friends, that's another thing. 3 is an island provision. 8 is an island provision. If 8 is complied with, then 3 is diluted.
3 will not be diluted. 3
ಅವ್ರ ಮೇಲೆ ಬರ್ತದೆ, ಅದಕ್ಕೆ
ಅವ್ರ ಮೇಲೆ ಬರ್ತದೆ. ಆದ್ರ ಆರ್ಡರ್ ತಗೊಂಬಂದ 60 ದಿವಸಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋದು.
ಕರೆಕ್ಟ್.
ವಿಚ್ ಎವರ್ ಈಸ್ ಲೇಟರ್ ಅಂತ ಇದ್ದಿದ್ದಕ್ಕಾಗಿ.
ವಂಡರ್ಫುಲ್.
ಹಾ,
we are in full agreement with you. Where is why you are reading 8 as diluting the requirement of 3 ಅಂತ ತಿಳಿತಾ
ಇಲ್ಲ ಇಲ್ಲ, I am not diluting it. On the other hand, please see page 230, condition 11. In support of their argument itself. The vendor undertakes to apply for conversion of the scheduled property for non-agricultural commercial use immediately after the execution of this agreement and to take all steps to expeditiously get such conversion. All expenses, including the conversion fees and betterment charges legally payable, if any, in this regard, shall be paid by the purchaser to the authorities, or if so paid by vendor, shall be reimbursed by the purchaser. The purchaser shall also assist the vendor in expediting such conversion. Purchaser shall assist the vendor in expediting this conversion. So I am executing a power of attorney, giving it to him to get it as early as possible that he wants to get this LD.
ಆ ಪ್ರಶ್ನೆ ಬರೋದು ಈ ಅಮೌಂಟ್ ಪೇ ಮಾಡಿದ್ರೆ ಮಾತ್ರ.
ಹೌದು,
ಈ ಅಮೌಂಟ್ ಪೇ ಮಾಡಿಲ್ಲಲ್ಲ ಅವರು.
ಅವ್ರು ಈ ಅಮೌಂಟ್ ಪೇ ಮಾಡ್ಲಿಲ್ಲ, ಅದಕ್ಕಾಗಿ ಆಗ್ಲಿಲ್ಲ.
ಅವಾಗ ಆ ಕ್ಲಾಸ್ ಹಂಗೆ ಉಳಿತದೆ ಅಂತ.
ಆ ಕ್ಲಾಸ್ ಹಾಗೆ ಉಳಿತು. ಹಾಗೆ
ನಿಮ್ಗೆ ಬರ್ತದೆ.
ಆ ಕ್ಲಾಸ್ ಹಾಗೆ ಉಳಿದ ನಂತರ 2 ವರ್ಷದವರೆಗೂ ಅವ್ರು ಏನೂ ಮಾಡದೇ ಇದ್ದಾಗ, in fact the agreement would have been cancelled or something. But ಆವಾಗ ಎಕ್ಸಿಬಿಟ್ P3 ಬಂತು, ಮತ್ತೊಮ್ಮೆ 2 ವರ್ಷ 10 ತಿಂಗಳ ನಂತರ. ತಾವು ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರಿ, ನಿಮ್ಮದೇ ಅಲ್ಲದೆ ಹೋದ್ರೆ ನೀವ್ಯಾಕೆ 10 ಲಕ್ಷ ಎಕ್ಸ್ಟ್ರಾ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ.
Anyway, it's a novation. The new agreement itself. Terms may be printed there, but it's a novation. I admitted also.
ನಾನು ಅದನ್ನ ಡಿನೈ ಮಾಡ್ತಾ ಇಲ್ಲ. ಸೀಕ್ವೆನ್ಸ್ ಏನಾಯ್ತು ಅನ್ನೋದನ್ನ ಈಗ ನನಗೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಐ ಶುಡ್ ಗೆಟ್ ಇಟ್ ಅರ್ಲಿ ಅನ್ನೋದಕ್ಕೆ, ಅವರು ಕಾಸ್ಟ್ ಅಲ್ಲದು ಅವರು ಬಂದು ತುಂಬಬೇಕು ಅನ್ನೋದಕ್ಕೆ, ಅದನ್ನ ಹೌ ಐ ಡಿಸ್ಚಾರ್ಜ್ ದಟ್ ಅಬ್ಲಿಗೇಷನ್, ಹೌ ಐ ಶುಡ್ ಡೂ ಇಟ್ ಅನ್ನೋದನ್ನ 8ನಲ್ಲಿ ಹೇಳಿದ್ರು. ಕಾಸ್ಟ್ ಅವ್ರು ಬಂದು ಕೊಡೋದು ಗಿಡೋದ್ರ ಬದಲು ಅವರ ನಾಮಿನಿನೋ ಯಾರು ಅವರಿಗೆ ನೀವು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಕೊಡಬೇಕು ರೊಕ್ಕ ಕೊಟ್ಟ ಮೇಲೆ.
ನಿಮ್ಮ ಲೀಗಲ್ ನೋಟಿಸ್ ನಲ್ಲಿ ಈ ನಾನ್ ಕಾಂಪ್ಲಯನ್ಸ್ ಆಫ್ ದಿಸ್ ಕ್ಲಾಸ್ ಮೇಲೆ ಏನಿದೆ?
ಇದು ತೋರಿಸ್ತೀನಿ. P3, in view of the delay in completion of the same, purchaser has agreed to pay additional sum of 5 lakhs so and so. ಅದಕ್ಕೆ ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ವಿ ಅಂತ P3 ದಲ್ಲಿ ಬಂತು. ಲೀಗಲ್ ನೋಟಿಸ್
ಈ 3 ಚೆಕ್ ನಲ್ಲಿ ಯಾವುದು ಎನ್ಕ್ಯಾಶ್ ಆಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ಯಾವುದು ಎನ್ಕ್ಯಾಶ್ ಆಗಿ.
Because 25 to 2004 ಏನಿತ್ತು ಅದು that itself stood dishonored ಅಂತ ನಿಮ್ಮ contention. It is dated 15/2.
It is dated 15/2.
ಇಲ್ಲಿ ತಪ್ಪಾಗಿ ಬರ್ದಾರೆ ಅನ್ನೋದು ನಿಮ್ಮ contention.
ಫೈನಲ್ ಚೆಕ್ ಅವರು ಎನ್ಕ್ಯಾಶ್ ಮಾಡೋ ಕ್ವೆಶ್ಚನ್ ಬರಲ್ಲ, ಬಿಕಾಸ್ ದೇ ಟರ್ಮಿನೇಟೆಡ್ ಅಗ್ರಿಮೆಂಟ್. ಅದೇ ದಿವಸ 25/2
ಅಲ್ಲ, ಅವ್ರು ಹೇಳೋದು 15/2 ಅಂತ.
ಅಲ್ಲ, ಈ 2 ಅವ್ರೆ ಅದೇನು ಹೇಳಲ್ಲ. 15/3 ಇದೆಯಲ್ಲ, 15/3 and 15/4 3 ಚೆಕ್.
ಉಳಿದ
15
ಎನ್ಕ್ಯಾಶ್ ಮಾಡ್ಲಿಲ್ಲ ಬಿಕಾಸ್ 25/2 ರಿಸೈಂಡ್ ಆಗಿ ಹೋದ್.
ರೀಸೆಂಟ್.
ಅದರಲ್ಲಿ ಒಂದರಲ್ಲಿ ತಪ್ಪಾಗಿದೆ ಅಂದ್ರೆ ಇನ್ನೆರಡಕ್ಕೆ ಏನು ಹೇಳಲ್ಲ. ಬಟ್ ದೇಸೇ ನೋಡಿ
ಇಲ್ಲ ಇಲ್ಲ, ಇನ್ನೆರಡು ಚೆಕ್ ಹೊಸದಾಗಿ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಅಂತೇಳಿ ಅಮೆಂಡ್ಮೆಂಟ್ ನಮ್ದು.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಹೆಂಗೆ ನೀವು ಮೊದಲನೇ ಚೆಕ್ಕಿಗೆ ಈ ರೀತಿ ಹೇಳಿದ್ರಲ್ಲ, ಇನ್ಕ್ಯಾಶ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ, ಡಿಸಾನರ್ ಆತು ಹಿಂಗಿಂಗೆ ಅಂತ. ಇವೆರಡು ಚೆಕ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿಲ್ಲ, ಅದ್ನೇನು ಹೇಳಿಲ್ಲ ಅನ್ನೋದು ಅವ್ರ ಕಂಟೆಂಟ್.
ಏನು ಹೇಳಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಎಸ್ ಐ ಟರ್ಮಿನೇಟೆಡ್ ದಿ
ಅಗ್ರಿಮೆಂಟ್ ಅಂತ ನಿಮ್ಮ ಎಕ್ಸ್ಪ್ಲನೇಷನ್. ಆಲ್ ರೈಟ್.
Exhibit, of course, my lord, here I may, it's better that my learned friend explains that exhibit P6, page 268, income tax ಗೆ ನಾವೇನು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅನ್ನೋದು, that may not be correct. This appears to be
268.
37I ಬಂದಿದೆ. 37I ಮೆಲಾಡ್
ಆಗಿ ಬಂದ್ಬಿಟ್ಟಿದೆ.
37I ಬಂದಿದೆ.
ಅಲ್ಲ 37I ಗೆ ಇಬ್ರು ಸೈನ್ ಮಾಡಿ ಕೊಡ್ಬೇಕದು.
ಅದು ಮಾಡಿದೆ,
ಅದನ್ನ ಕಂಪ್ಲೈ ಆಗಿದೆ,
ಅದಾಗಿದೆ.
ಅಂದ್ರೆ ಇವರು ಏನೂ ಸ್ಟೆಪ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಇರ್ಲಿಲ್ಲ. ಬೋನಫೈಡೆ ಸೈನ್ ಮಾಡಿಕೊಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಆಯ್ತು. ರೊಕ್ಕ ಯಾವಾಗ ಬರ್ಲಿಲ್ಲ 17/2/21, 5/3/21 ಎರಡನೇ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ರೊಕ್ಕ ಕೊಡಬೇಕಿತ್ತು. ಅಂದ್ರೆ 20 days ನಲ್ಲೇ.
Then why they signed P3 ಮೆಲಾಡ್? ಅಗ್ರಿಮೆಂಟ್ ಆಗಿ ಒಂದೇ ತಿಂಗಳಲ್ಲಿ ಇಬ್ರು ಸೇರಿ 37I ಫಾರ್ಮ್ ಹಾಕ್ತಾರೆ. ಹಾಕಿ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ
ಮೊದಲಿಂದ
2001 ನಲ್ಲಿ.
ಅಗ್ರಿಮೆಂಟ್
ಆಮೇಲೆ 230A ಇಲ್ಲ, ಮತ್ತೆ ಕನ್ವರ್ಷನ್ ಇಲ್ಲ.
ಅದು ಬೇಕಾಗತ್ತೆ, ಎರಡೂ ಬೇಕಾಗತ್ತೆ ಅಂತ ನಿಮ್ ಕಡೆ.
2003 ನಲ್ಲಿ ನೋವೇಷನ್ ಆಗತ್ತೆ.
ಸ್ಟೆಪ್ ತಗೊಂಡಿಲ್ಲ ಅನ್ನೋದು ಕರೆಕ್ಟ್ ಅಲ್ಲ. ಸ್ಟೆಪ್ ತಗೊಳ್ಳೋ ಅಂತ ತಗೊಂಡಿದ್ರು, ಅವ್ರು ಸ್ಟೆಪ್ ತಗೊಳ್ಬೇಕಾದ ಸ್ಟೆಪ್ ಅನ್ನ ಅವ್ರು ತಗೊಳ್ಳಿಲ್ಲ.
ಅಂಡರ್ಸ್ಟುಡ್ ದ ಪಾಯಿಂಟ್. ನಾವು ಈಗ ನಿಮ್ ಕಾಂಡಕ್ಟ್ ಆಫ್ ಯುವರ್ ಪಾರ್ಟಿ ನೋಡಿ.
ನಮ್
ಆರ್ಡರ್ ನಾಟ್ ಟು ಏಲಿನೇಟ್.
2 acre 2 ಎಕರೆ 2 ವರ್ಷ 10 ತಿಂಗಳ ನಂತರ ಸಹಿತ ಇವರು ಆಯ್ತು, ಮಿಸ್ಟೇಕ್ ಆಯ್ತು, 5/3/2001 ಕೊಡ್ಬೇಕಿತ್ತು, ನಾವು ರೊಕ್ಕನ ಕೊಟ್ಟಿಲ್ಲ, ಇಂಥದ್ದೆಲ್ಲ ಆದ್ರೂ ಸಹಿತ ಸ್ಟಿಲ್ 2 ವರ್ಷ 10 ತಿಂಗಳಿಗೂ ಆಲ್ ರೈಟ್, ಇನ್ನು 5 ಲಕ್ಷ ಹೆಚ್ಚಿಗೆ ಇದು, ಯು ಪೇ ದಿ ಅಮೌಂಟ್ ಅಂಡ್ ಟು ಬಿ ಡನ್ ಅಂತ ಹೇಳಿ ಒಪ್ಕೊಂಡ್ವಿ. ಆವಾಗ ಕ್ಲಾಸ್ 8 ಹೋಗ್ಲಿಲ್ಲ, ಅಮೌಂಟ್ ಅಷ್ಟೇ, ಹೊಸ ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಷ್ಟೇ.
ಅಲ್ಲ, in alienating the property, when there was a restraint order by the court not to transfer the title ಅಂತ ಆರ್ಡರ್ ಇದೆ.
ಅದಕ್ಕೆ ಅದರದ್ದು ಅದನ್ನ ದಟ್ ಐ ವಿಲ್ ಪಾಯಿಂಟ್ ಔಟ್. ಇದು ಈ ಆಸ್ಪೆಕ್ಟ್ ನಲ್ಲಿ ಆ ಎಕ್ಸಿಬಿಟ್ P3 ದಿಂದ ಬೇರೆ ಯಾವುದು ಚೇಂಜ್ ಆಗ್ಲಿಲ್ಲ. ಮೊದ್ಲಿಂದಕ್ಕೆ 5 ಲಕ್ಷ ಸೇರಿಸಿ ಕೊಡ್ಬೇಕಿತ್ತು,
ಅದನ್ನೇ ಡೂಪ್ಲಿಕೇಟ್.
ಅದು ಎನ್ಕ್ಯಾಶ್ ಆಗಿದ್ರೆ I was required to execute a power of attorney. I was to proceed and do all those things. ಅದು ಎನ್ಕ್ಯಾಶ್ ಆಗದೆ ಇದ್ದಿದ್ದಕ್ಕೆ ಆಸ್ ಪರ್ ಕ್ಲಾಸ್ 8 ಕ್ವಶನ್ ಆಫ್ ಮೊದಲೇ ಚೆಕ್ಕು ಇರಲಿಲ್ಲ, ಬರೀ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕು ಅನ್ನೋದಷ್ಟೇ ಕಂಡೀಷನ್ ಇತ್ತು. ಈ ಸಲ ಚೆಕ್ಕೇ ಇತ್ತು, ಚೆಕ್ ಆ ಡೇಟಿಗೆ ಆಗಲಿಲ್ಲ. ಆಗದೆ ಹೋದ ಕೂಡಲೇ I terminated the agreement. Therefore, to put the blame on me with regard to the payment of amount or not applying for conversion is not correct at all. As far as that is concerned, court has recorded a finding in our favor.
Yes. You said that there is a provision for forfeiture of the amount, etc.
ಅದು agreement ನಲ್ಲಿ,
ಎಲ್ಲಿ?
Your Lordship may kindly see exhibit P2. ಇದು 231 para 10.
Two 31.
In the event vendor committing breach of this agreement or being for any reason or is unable to execute the sale deed in favor of the purchaser, transferring absolute title to them, she shall be liable to refund the advance paid by the purchaser with interest at the rate of 24% per annum and also pay liquidated damages of rupees 10 lakhs only. In case the purchaser commits the breach of this agreement, purchaser shall be liable to pay liquidated damages of rupees 10 lakhs to the vendor, and vendor shall refund the balance of the advance paid this day to the purchaser.
Where did you refund the remaining amount?
Notification notice nalli, I called upon them to collect the advance amount.
And collect the advance, you should have sent the check.
I could have sent a check or DDA this thing. This thing, I sent a notice saying, please collect the advance amount. I'm ready to pay.
No, that's only a self-serving statement. You should have sent. You had received the money by check. You should have sent. See, I have rescinded the agreement. Come to my store. ಅಲ್ಲಿ ಬಂದು ನಿಮ್ ಕಟ್ಟೆ ಮೇಲೆ ಕುತ್ಕೊಂಡು ನಮ್ ದುಡ್ಡು ಕೊಡಿ ಅಂತ ಕೇಳ್ಬೇಕು ಅವರು. This is a huge deal. Where is the fairness? See, things have taken place in the terms of checks. They have received amount money by check.
Check 2,20,000 ಮಾತ್ರ.
All right. You should have said, ಈ ಅಮೌಂಟ್ ನೋಡಪ್ಪ, you should have said, ಅಷ್ಟು ಅಮೌಂಟ್ ನೀನು ಕ್ಯಾಶ್ ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ, ನನ್ ಕಟ್ಟೆ ಮೇಲೆ ಬಂದು ಕುತ್ಕೋ, ನಾನು ಹಿಂಗ ಆ ಕ್ಯಾಶ್ ಅನ್ನು ಕೊಟ್ಟು ಕಳಿಸ್ತೀನಿ. Where is that stand? Anyway, take away taking the money and returning.
Legal notice ನಲ್ಲಿ ಅಮೌಂಟ್ ನಿಮ್ಮ ಅಡ್ವಾನ್ಸ್ ಅಮೌಂಟ್ ಅವರು ತಿರುಗಿ ಉತ್ತರದಲ್ಲಿ immediately on the in a week they answered saying
No, where is the
termination
fairness?
is accepted.
Not that. In standard books on specific performance, like Nelson, Goyal, LC Goyal, they say, even Halsbury says, the conduct of the parties is there. ಅದು ಅಬೌವ್ ಇರ್ಬೇಕು. ಏನಂತ ನೋಡಪ್ಪ, ನೀ ನನಗೆ ಇಷ್ಟು ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಈ ರೀತಿ ಫಾರ್ಫೀಚರ್ ನಿನ್ ಕಡೆಯಿಂದ ತಪ್ಪಾಗಿದೆ, ನಾನು ಫಾರ್ಫಿಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ನಿಂಗೆ ಚೆಕ್ ಕಳಿಸ್ತಾ ಇದ್ದೀನಿ, ಇದನ್ನ ಎನ್ಕ್ಯಾಶ್ ಮಾಡ್ಕೋ, ಜೋಬಿಗೆ ಹಾಕೋ. Where is that conduct? One. Where is the conduct? Where one who violates the court order and sells it to.
That is after the.
The conduct is very essential. One who has no respect for the court order. How court should hear his arguments? After all, these are all more of equitable jurisdiction. Where is your conduct? The court said, don't transfer the title. Therefore, I asked Mr. Naganand, what is meant by status quo? Status quo, there are arguments, there are judgments, this side, that side. Andhra Pradesh judgment, full court bench. The status quo refers to possession, enjoyment of the property, not conveyances at all. There is a specific injunction saying, you shall not transfer the title.
ಇದು 274 ನಲ್ಲಿ page 274.
ಫಾರ್ಫಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೇವೆ ಅಂತಾನೂ ಹೇಳಿಲ್ಲ ನೀವು.
ಇಲ್ಲ, you may arrange to collect the advance amount.
Therefore,
paid
there
by
is no
you
forfeiture also.
under the agreement from my client. However, you may note that my client reserves the liberty to recover from you damages suffered by her on account of your default.
So forfeiture clause exercise ಮಾಡಲಿಲ್ಲ ನೀವು. You have not exercised forfeiture.
I may be excused.
Very, very.
Forfeiture exercise ಮಾಡಿಲ್ಲ ಆಗಲ್ಲ ಇರ್ಲಾರ್ದು. ತಾವು ಆ ಫೋರ್ಫೀಚರ್ ಕ್ಲಾಸ್ ನೋಡಿದ್ರೆ 10 ಲಕ್ಷ ಡ್ಯಾಮೇಜಸ್ ಅದನ್ನ ಮುರ್ಕೊಂಡು ಅಡ್ವಾನ್ಸ್ ಅಮೌಂಟ್ ವಾಪಸ್ ಕೊಡ್ಬೇಕು ಅಂತ.
ಕರೆಕ್ಟ್, ಅದನ್ನ ಮಾಡ್ಲಿಲ್ಲ ನೀವು ಅಂತ.
ಅಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ಏನ್ ಹೇಳಿದ್ದೀನಿ, ಯು ಮೇ ನೋಟ್ ದಟ್ ಮೈ ಕ್ಲೈಂಟ್ ರಿಸರ್ವ್ಸ್ ಲಿಬರ್ಟಿ ಟು ರಿಕವರ್ ಫ್ರಮ್ ಯು ಡ್ಯಾಮೇಜಸ್ ಸಫರ್ಡ್. ಅಂದ್ರೆ 10 ಲಕ್ಷ ಇಟ್ಕೊಂಡು ಉಳಿದಿದ್ದನ್ನು ಕೊಡ್ತೇನೆ. Maybe they thought if the things are to be worked out, ಪೂರಾ ಅಮೌಂಟನ್ನು ವಾಪಸ್ ಕೊಡ್ಬೋದು ಅಂತೇಳಿ ತಿಳ್ಕೊಂಡಿರ್ಬೋದು. ಅವರ ರಿಪ್ಲೈನಲ್ಲಿ we are proceeding with the specific performance ಅಂತ ಹೇಳಿ ರಿಪ್ಲೈ ಕೊಟ್ಟರು. Therefore, thereafter, things have not worked further. The first thing is, if I am allowed to argue on that amendment application, then, my lord, all these things will fall into place. If here is a person who issues a check which was in a wrong name, therefore, he again, that the amendment application pleading that we wanted to introduce,
ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದು,
ಅದರಲ್ಲಿ ಅಂದ್ರೆ ರೆಕಾರ್ಡ್ ನಲ್ಲಿ ಇದೆ, ಇಲ್ಲಿ ಇದರಲ್ಲಿಲ್ಲ.
ಕೊಡಿ. ಇದನ್ನ ಸ್ವಲ್ಪ ಬೇರೆ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ, ಆಮೇಲೆ ಬಿಡಿಸ್ಕೊಡಿ. ಒಂದು ಮೆಮೊ ಹಾಕಿಕೊಡಿ. This application was moved after how many years of the suit?
earlier ಡಿಗ್ರಿ ಆಗೋದಕ್ಕಿಂತ ಮೊದಲೇ just give me lord. ಇದು 2015 ಸೂಟು. ಇದು ಸೂಟು.
When the suit was filed?
Suit filed
11/3/2005.
This application was filed only after they made an application for calling for production of original check dated 25/2.
WS was filed on which date?
February 2008.
2000 data? And issues were framed on which date?
13/3/2008.
Page 64.
The trial began when the witness was called to the box? one went to box when?
23/10/2010. It's only one witness on their side.
And your evidence was closed on?
DW2 was 22/9/2014. 22/9/2014, last cross-examination of DW2. DW2.
PW1 ಯಾವಾಗ
PW1, PW1, my lord, conclusion was 9/12/2013. Defendant's evidence began in January 14.
9/12/2013. Obre witness, sir?
Obre witness.
PW1 Obre.
Yes.
Then DW1.
DW1, no, husband of defendant 1.
Correct.
His chief examination started on 15th January 2014.
2.
His cross-examination completed on 20th August 2014. Then DW2 is there, no? Aurdu 10/9/14. 22/9. 5/9/2014. To conclusion date.
DW1.
DW1. DW1, no, 28.
5/1 irlikilla.
Illa, my lord. DW2, my lord, his evidence begins on 10th of September 2014. And it concludes on 22nd, 25/9/2014.
When that application for amendment was filed? IA?
Amendment application was filed on 31/1/2012.
That was after the trial began.
Yes, yes.
No, it was only after they filed an application IA number 20 calling for me to produce the check dated so and so bearing number so and so.
Now, since courts have differentiated between pre-trial amendments and post-trial amendments, in that direction, we ask this question. All right. Yes, sir.
Your Lordship may kindly see in the entire evidence that the check presented is a different check. It was 15 check alla anta illa. Even in the evidence of PW1 by way of affidavit, his evidence is contrary to our understanding and the agreement. Check was presented on 17. The other checks were not issued by me. For both of us, probably, andre parties gottitto gottillo, appears to be both the advocates came to understand that there has been a mistake in check number only at that stage, and they made an application IA number 20. I'll give the date of that application IA number.
Ignorance or parties ignorance. My learned friend is drawing advocates into it now.
Probably it was so.
Hello, lawyers confused.
Probably ಯಾಕಂದ್ರೆ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ನಲ್ಲೂ
ಅದ್ರ
ನೋ
ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ಅಂತ.
ನೋ ವೇರ್ ದಿಸ್ ಕೇಮ್ ಇನ್.
Legal notice ಎಲ್ಲ issue ಮಾಡಿದ್ರೆ I don't know what the lawyers practice, not our practice, standard practice. On instructions, legal notice is prepared. The notice is sent to the client with a covering letter. On your instructions, we have prepared this. Please verify the facts and figures. If you approve it, you may dispatch it. ನಮ್ಮ ಆಫೀಸ್ ಇನ್ dispatch ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. Client would dispatch it and then give us the postal acknowledgement. Card ಎಲ್ಲ ರೆಡಿ ಮಾಡಿ ಕೊಡ್ತಾ ಇದ್ವಿ. So that is a normal practice which most lawyers practice.
Yeah.
Especially except not in cases where you are appearing for some statutory body or government, maybe that practice may not be followed.
Yes. So your submission is the finding and order as to rejection of your application for amendment is to be reversed and that application ought to have been considered. That you are doing because of order 43, rule 22, 41, rule 22. Na?
22, order 41, rule 22.
41, 22, 41, 22. 105, read with 105, because it's not appealable.
41, rule 22. And in that regard, my lord, there is one other provision which I had brought to your lordship's notice. Kindly see order 41, rule 33.
That's all. Separate memo haki. Application. ಆಮೇಲೆ WP ಅಪ್ಲಿಕೇಶನ್ WP ಆರ್ಡರು ಆಮೇಲೆ ಅದಾದ್ಮೇಲೆ ಒಂದು ರಿಕಾಲ್ ಹಾಕಿರ್ತೀವಿ, ಅದ್ರ ಮೇಲೆ ಆಗುವಂತ ಆರ್ಡರ್ ಅದನ್ನು ಕೊಟ್ಬಿಡ್ತೇನೆ ನಾನು ಇಲ್ಲೇ ನಮ್ಗೆ ಸಪ್ರೇಟ್ ಅಷ್ಟು ಹಾಕ್ಬಿಡ್ತೀನಿ.
Your lordship may kindly see order 41, rule 33.
Judgment may be for confirming, varying, reversing. The parties to the appeal agree as to the form which the decree in appeal shall take. As to the order to be made in appeal, the appellate court may pass a decree or make an order accordingly. ಏನ್ ಬಹಳ ಬೇರೆ ಬಹಳ ವಿಚಿತ್ರ ಇದೆ ಇದು, ನಾವಿದ್ ನೋಡಿರ್ಲಿಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್. ಸೊ ನಿಮ್ಗೆ ಡ್ರಾಫ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ನಾವು ಬರೆದು ನೋಡ್ರಿ ಈ ರೀತಿ ಮಾಡ್ಬೋದಾ, ನೀವಿಬ್ರು ಒಪ್ಪಂಗಿದ್ರೆ ಈ ರೀತಿ ಮಾಡ್ತೇವಿ ಅಂತ ಹೇಳಂಗಿದೆ ಇದು.
ಅಲ್ಲ ಅಲ್ಲ
ಹೌದಾ? If the parties to the appeal agree to the form which the decree in appeal may take place. Quite possible. ಇದು ಒರಿಜಿನಲ್ CPC ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲನು? ಇತ್ತು
ಇದೆ. Rule 33 ದಲ್ಲಿ 41, rule 33. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be exercised by the court notwithstanding that appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees.
Wide power.
Ultimately, to meet the ends of justice in a way, if something is to be done and some technical aspect comes in the way for passing such order, all those hurdles are removed.
ಆಗ್ಲಿ. This you are reading to tell us to do what?
This I am to tell that in spite of any restrictions that might have been put under Order 6, Rule 17, in case the court feels that this is something which should be adjudicated upon in this matter.
ಅಲ್ಲ ಅದು 4122 ಬಂದ್ಬಿಡು.
ಅಲ್ಲ 4122 ಅಲ್ದೇನೆ
ಅಲ್ಲ
ಅಲ್ಲಲ್ಲ ತಾವು
ಅದ್ರ ಜೊತೆನೇ ಓದಿಬಿಡಿ ಅಂತ.
ಪಾಯಿಂಟೆಡ್ಲಿ 2-3 ಕ್ವಶನ್ ಕೇಳಿದ್ರಿ. ಟ್ರಯಲ್ ಯಾವಾಗ ಶುರುವಾಯ್ತು, ಎವಿಡೆನ್ಸ್ ಯಾವಾಗ ಶುರುವಾಯಿತು, ಅಪ್ಲಿಕೇಶನ್ ಯಾವ ಡೇಟಿಗೆ ಫೈಲ್ ಮಾಡಿದ್ರು, ಇದು ಆ ಕ್ವಶನ್ಸ್ ಎಲ್ಲದು ಬಂದಿದ್ದಕ್ಕಾಗಿ ಇನ್ ಕೇಸ್ Order 6, Rule 17 ನಲ್ಲಿ ರಿಸ್ಟ್ರಿಕ್ಷನ್ that after the trial begins.
But we know why Patil is reading this provision. You are a seasoned lawyer. At least with that we know.
ಅದಕ್ಕಾಗಿ ಇನ್ ಕೇಸ್ ಯಾವ್ದಾದ್ರು ಟೆಕ್ನಿಕಾಲಿಟಿಯ ತೊಂದರೆ ಬರ್ತತಿ ಅಂದ್ರೂ, ಇಫ್ ಐ ಆಮ್ ಏಬಲ್ ಟು ಪರ್ಸ್ಯೂಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ that is something which should be answered for or against. Without that, the things will not be, a decision on the matter will not be proper antandre. In conjunction with all these powers, that amendment ಇದು ಇದಾಗಬೇಕು. ಆ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಂತ ಕೇಳಿದೇವೆ ಅಂದ್ರೆ,
ನೋಡ್ದೆ ನಾನು ಕೊಟ್ಟಿದ್ದ ಕಾಪಿ.
ಅದರಲ್ಲಿ ಅಂದ್ರೆ ಆ ಸ್ಪೆಸಿಫಿಕ್ ಇದು it is submitted that check bearing number so and so dated 15/2 was drawn on Punjab National Bank, MG Road, Bengaluru. Same was issued in the name of the first defendant, but the name of defendant number 1 was wrongly shown as
ಮೂರ್ತಿ ಅಂತ ಅನ್ಕೊಂಡು ಸೇರಿಸಿದ್ರು.
Srimati Shanta Srinivas Murthy as against Srimati Shanta Srinivas by the plaintiff. It is a account payee check. While the check was written in the name of Shanta Srinivas Murthy for 29,80,000, check bearing number so and so, another check dated 15/3/2004 by written the same, by writing the same bearing in check number so and so. When the check was handed over to the defendant, the husband of this defendant, who in fact enlightened the plaintiff that the aforesaid checks were drawn in the wrong name of the defendant, and it is alarmed the plaintiff that in the same style, if the instruments are presented to honor, the bank cannot be honored at all because of the discrepancy in showing the name of the defendant, which naturally does not tally with the name of the account holder. Therefore, it was necessitated to give back the original instruments to the plaintiff, and alternatively, the plaintiff was asked to issue new checks upon showing the name of defendant number 1 correctly. The plaintiff accordingly have taken back the original instruments, and Xerox copies of those checks are still with the defendant number 1. The original instruments are handed over to the plaintiff, and therefore it was necessitated the plaintiff to issue 2 other checks for 20,000 and 20 lakhs and 29,80,000, which check bearing number so and so.
ಇಲ್ಲಿ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದಾವ ನಿಮ್ಮಲ್ಲಿ, ನಿಮ್ಮ ಹತ್ರ ಇದಾವ?
ಇಲ್ಲಿ ಅಂತೂ ಇಲ್ಲ. We'll just ascertain what it is.
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವ್ರು ಕೇಳಿದ್ರೆ ಆ ಚೆಕ್ ನಾನು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ದಾಖಲೆ ಏನು ಇಲ್ಲ, ಐ ಹ್ಯಾವ್ ನಾಟ್ ಗಾಟ್ ಎನಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್, ದಟ್ಸ್ ವಾಟ್ ಹಿ ಸೇಸ್ ಇನ್.
ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ದಾಖಲೆ ಇಲ್ಲ,
ಜೆರಾಕ್ಸ್ ಇದಾವ ಅನ್ನೋದು ಇಂಡಿಪೆಂಡೆಂಟ್.
ಚೆಕ್ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ನಾವು ಇದನ್ನ ಹೇಳಿದ್ವಿ. ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಕ್ಕಾಗಿ ಬೇರೆ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಔಟ್ ಆಫ್ ದಿ ಅಫೋರ್ಸೆಡ್ 2 instruments presented on so and so ಅಂತ ಮುಂದಿನ ಹೇಳಿ.
ಮಂಡೇ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕೋಣ. ಸ್ವಲ್ಪ ಮ್ಯಾಟರ್ಸ್ ಹಾಕ್ಸಿ ಮಧ್ಯಾಹ್ನದಿಂದ ಹಾಕೊಂಬೋದು. ರೆಗ್ಯುಲರ್ ಬೆಂಚ್ ಇದೆಯಾ? ಆಯ್ತು, ನಾಳೆನ ಹಾಕೊಂಬಿಡಿ. ರೆಗ್ಯುಲರ್ ಬೆಂಚ್ ಇದ್ರೆ ನಾಳೆನ ಹಾಕೋಬೋದಾ? ನಾಳೆ ಅವ್ರು ಅಪ್ಲೈ ಮಾಡ್ಬೇಕಲ್ಲ.
ಆಯ್ತು, ನನಗೊಂದು ಅವಕಾಶ ಅದಾದ್ಮೇಲೆ ಕೊಟ್ರೆ ನಾಳೆ ಒಂದ್ ದಿವಸ ನನಗೆ ಐ ಆಮ್ ನಾಟ್ ಇನ್ ಸ್ಟೇಷನ್.
ಹೌದಾ?
My learned friend, my lord, if your lordship permits, he can.
ಅಲ್ಲ
continue.
ನಿಮ್ ಅಬ್ಸೆನ್ಸ್ ನಲ್ಲಿ ಆದ್ರೆ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು ಅನ್ಕೊಂಡು ನಿಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಹೌದು.
ಆಮೇಲೆ ಇವ್ರು ಬ್ರೀಫ್ ಮಾಡ್ಬೇಕು
ಹೌದು.
ಅಥವಾ ನಾವ್ ಹೇಳ್ಬೇಕು, ಹಿಂಗೆಲ್ಲ ಆಗ್ತದೆ.
ಸೋಮವಾರ.
ಸೊ ಆಯ್ತು ಇನ್ನೊಂದ್ ದಿವ್ಸ ಹಾಕಿ ಮಂಡೇ ಜಾಸ್ತಿ ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಬೇಡ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಅಲ್ಲಿ ಇನ್ನೂ ಪ್ರವೃತ್ತಿ ಇದ್ದಾರೆ. ಅವ್ರದ್ದು ಎಷ್ಟು ಟೈಮ್ ತಗೋತಾರ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗಿನ್ನು. ಅವ್ರು ಇನ್ನು ಏನೇನ್ ಬಾಣ ಇದಾವು.
ಮಂಗಳವಾರ 11th. Would it be 11th then?
11th
11th.
ಟ್ಯೂಸ್ಡೇ ಮ್ಯಾಟ್ರ್ ಜಾಸ್ತಿ ಹಾಕ್ಸ್ಕೊಡ್ಬೇಕು ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ ಏನೇ. ಇದು ನಮ್ಮ for further hearing on Tuesday. ಇಷ್ಟೊಂದೇ ಎರಡು ಇಲ್ಲ ನಾವೇನು ಮಾರ್ಲಿಕ್ಕೆ ಹೋಗಿ ಹೋಗಿ ಹೋಗಿ. ಮಿಸ್ಟರ್ ಪಾಟೀಲ್, ರಾಜಗೋಪಾಲ್ ಪಾಟೀಲ್, ಏನು ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ಯಾರೋ ಒಬ್ರು ಇದ್ರೆ ಸಾಕು ಓಪನ್ ಕೋರ್ಟ್ ಅನ್ನೋದಕ್ಕೆ. ಯಾರೋ ಒಬ್ರು ಯಾರೋ ಇಷ್ಟ ಏನ್ ಬೇಡ ಬರಿ, ಏನು ಸೈನ್ ಮಾಡೋದೆಲ್ಲ ಇದೆ. ನೀವೆಲ್ಲ ಪಾಪ ಸಾಕಾಗಿರ್ತೀರಿ.
ನಾವಿರೋಣ.
ಇದು ಡಿಸ್ಪೋಸಲ್ ಇಬ್ರು ಒಂದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ತಯಾರಿ ಮಾಡ್ರಿ.
Already it is there in the file when the matter was.
Most of these arguments, Mr. Nayak had already.
Yes,
we have made our notes.
Your lordship has already made the notes. Much of it.
Register number.
ನಿಮ್ದು ಇದು ನಿಮ್ದು.
ಯಾವ ತಿಂಗಳು ಕೊಡ? ಮಂಗಳವಾರ 11ಕ್ಕೆ. Okay.